What a memo.
ಟೈಮ್ ಲಿಸ್ಟ್ ಆಗಿತ್ತು ವಾರ ಟೈಮ್ ಕೊಡಿ ಒಂದ್ ವಾರ ಆಗೋಯ್ತು ಹೆಂಗ್ ಕಂಪ್ಲೇಂಟ್ ಇಲ್ಲಿ ಫೈಲ್ ನಿಮ್ಮ ಹತ್ರ ಇದೆ ನಂಬರ್ ಅಲ್ಲಿ ಹೆಂಗ್ ಮಾಡೋದು ಒಂದ್ ವಾರ ಕಂಪ್ಲೇಂಟ್ ಮಾಡೋದು
ಕೊಡಲ್ಲ ಲಿಸ್ಟ್ ಆಗ್ತದೆ But adjournments. List number 1, page number 5, serial number 21 and 22. Page number 6, serial number 23 to 32.
At that time, what did you do? How much time did it?
10 days.
Released on 2nd March. Well, released on 3/3. If arguments are not advanced on that date, the petition will be liable to be dismissed for non-prosecution.
Number 29. That's the 100 one person is served, my lord, in 10,000. 987. 983, my lord. I'm including
Learned counsel for the RTC seeks for and is granted 10 days time to effect service on unserved respondent number 3, released on 7/3.
Page number 7, serial number 33 to 41.
Page number 8, serial number 42 to 47.
No, 41, my lord.
43.
43 is there, 43. 43, my lord.
Yes.
It's a very short matter.
Yes.
Matter was closed. Witness was not produced. We brought the witness at 3 o'clock.
It will reach very soon. It should reach very soon, Mr. Kasturi. We'll take it.
Very long. Much obliged. ಇಲ್ಲ ಅವರು ಅದರ್ ಸೈಡ್ ಕೂಡ ಹೇಳಿದ್ರು ಸಾಹೇಬರಿಗೆ ಮೆನ್ಷನ್ ಮಾಡೋಣ ಅಂತ ಅದಕ್ಕೋಸ್ಕರ
Number 44, my lord.
Yes. You inform the respondent
ಹೇಳಿದೀನಿ. 3ನೇ ತಾರೀಕು ಹಾಕೊಂಡ್ರೆ ಮಾಡಿ.
at the request of the counsel for the petition. This on 3-3.
Oh, 16 ಕೊಡಿ.
Page number 9, serial number 48 to 59.
Serial number 56, my lord. I am appearing for the petitioner. I have informed the other side also.
Yeah, I appear for the respondent.
I am trying for hot accommodation.
56 at the request of the counsel for the petitioner released on 14-3.
53, my lord.
Yes.
Much obliged. Much obliged.
Please.
I have informed Ravindranath. He said they may be noted and
3-3. Learned counsel for the respondent submit that he has not received the full set of the petition. Learned counsel for the petitioner undertakes to furnish the same by end of day 20th February. Objections, if any, by 10th March, released on 17th March.
Page number 10, serial number 60 to 65.
Serial number 62, your lordship, I am for respondent. I have informed to Karnataka, kindly we adjourn it for 2 weeks. Your lordship.
Anikraj,
Serial number 62,
ಇದ್ದಾರೆ.
Karnataka, I have informed.
respondent released on 16-3. 16-3.
No, Mark, sir.
Yes, Mr. Brownie? When I
63, my lord.
Huh?
Just for a week's accomplishment. Interim stay back again.
63 at the request of the counsel.
Reference challenge ಮಾಡಿದ್ದಾರೆ.
Huh?
Reference challenge ಮಾಡಿದ್ದಾರೆ.
ತಿಂಗಳು ಶಿವರಾತ್ರಿ ಬರಬೇಕಲ್ಲ.
Released on 6-3. We are granted it.
March.
If I learned AGA, released on for objections, huh? 2 weeks time. Objections, if any, by 10th, released on 17th.
66, my lord. The matter between me and Mr. Ashwin. Almost settled, my lord. Modalities were
ಯಾವಾಗ ಮಾಡ್ತಾರೆ?
1 week.
66, both councils submit that they are more or less arrived at a settlement. And if a week's time is granted, they will report.
ನೀನು ಹೋಗಿದೆ ಹೈಕೋರ್ಟ್ಗೆ.
27-2 at 2:30. Report under the caption.
ಮಧ್ಯಾಹ್ನ ಬಂದ್ಬಿಟ್ಟೆ.
Page number 2, page number 1, serial number 1 to 10.
5.6 minutes. For respondent, the intimate other side. Next week.
5 and 6 at the request of the council for the respondent. Released on
ನಾರಾಯಣ ಯಾಕೆ ಮಾಡಿಲ್ಲ?
16.
ಶಿವಭಾಗಿ ಯಾಕೆ ಮಾಡಿಲ್ಲ?
Page number 2, serial number 11 to 19.
Serial number 19 and 20, my lord. These two matters, my lord, pertains to the Provident Fund, my lord. Which is adjourned 6-3, my lord.
19 and 20.
Remote
6-3 connect with
WP 11847 of 90. That is the main.
My lord.
matter. And WP.
My lord, I appear for the respondent Provident Fund. 6-3 is, I am out of station, my lord. I appear for Provident Fund.
all the batch matters are posted on 6-3, madam. Your
Okay, my lords, because I'm out of
presence may
station.
not be much required. Your presence may not be much required because
Much
Mr.
obliged. Much obliged.
Ramananda has to first indicate how it is not covered, then only.
Please, my lord, please.
What earlier granted is extension itself.
Serial number 18, my lord, in the same list. No notice was sought, he is unrepresented, my lord.
Yeah, who appeared for the
Before the labor code, he was appearing party in person.
party in person?
Therefore, I wanted to take some instruction.
At the request of the counsel for the petitioner, released on 13th.
13. Much.
Number one. Till number 31, madam. Speak.
31. ಯಾರಿಗೆ ನೀವು
Petitioner, madam.
ರೆಸ್ಪಾಂಡ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೀರಾ?
Inform ಮಾಡಿದ್ದೀನಿ.
ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಬೇಡ.
One matter we want to withdraw, madam. Can it be taken up on Monday, madam?
But the caption withdrawal. ನೀವು ಅವತ್ ಬಂದ್ರಿ, ಆಮೇಲೆ ಮಹಾತ್ಮ ಬಂದ್ರು, ಮತ್ತೆ ನೀವೇ ಬರ್ತಾ ಇದ್ದೀರಾ ಇವಾಗ. 17. It is submitted that the party in person is unwell. ನಿಮ್ಮ ಹೆಸರೇನು? Mr. N. Ramaya, who is present in person before this court, submits that the party in person is unwell and seeks for 2 weeks accommodation. We list on 14/3. Mr. Ramaya is directed to inform Mr. Mahatma about the set date or ಹೇಳ್ಬಿಡಿ date. 13/3. 4 ವಾರ ಅಷ್ಟೇನು ಹುಷಾರಿಲ್ಲ ರೀ. 13/3. 3 ವಾರ ಕೊಟ್ಟಿದ್ದೀವಿ, ಇನ್ನ ಬೇಕಾ? 14/3. ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಡಿ 14/3 ಬರುತ್ತೆ.
Case number 1, fresh matter, serial number 1. थोड़ा पढ़िए.
Service of the response no interim to BMTC. Harish Bandari is directed to accept notice for responding. Counsel for the petitioner serve a copy of the petition along with annexures on the said counsel. Objection if any by 17th, released on 24th.
Serial number 2.
Goes before a bench of which SGRJ is not a part.
Serial number 3. Hemant Rao.
Annex C is under challenge, madam. It's an attachment order which has been passed, my lords, attaching the petitioner's bank account. Here, my lords, section 7A order was passed and we have preferred an appeal, my lords. Since the presiding officer is not there in the tribunal, this appeal was not considered, my lords. In the meanwhile, they have attached my bank account, my lords.
They already attached.
They have attached, my lords. Order of attachment is passed. Annex C, my lords.
How much money is there in that account?
That exact amount I'm not aware of.
14 lakhs is what is due.
Yes, ma'am.
So we'll release the attachment over and above 14 lakhs.
My lords, because my appeal is pending, my lords.
Security
I have sought for IA stay also, my lords, before the tribunal.
ಅಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ, ಇವಾಗ ಇಲ್ಲಿ security ಏನು ಕೊಡ್ತೀರಾ?
Till it's considered, this may be stayed, my lords.
It can't be a blanket stay.
If I may just pass on one interim order of the coordinate bench, my lords.
Can't be a blanket stay. Interim order will not bind. If you are going to offer some security, we'll stay. If you are not going to offer, we won't stay.
Or a deposit of 25%. My lords, we'll deposit
20%, not less than.
Even before the tribunal, they take 25%.
25%.
Because it's a 7A order.
25% ಕೊಟ್ಟಿದ್ದೀರಾ?
It's not considered. I filed it within the period of 4
For you to approach, you have to pay 25%. ಆಮೇಲೆ stay.
Under 7, okay.
So 25%, if you have paid 25%, we will direct 25% here, recording your submission.
My lords, I'll just take instructions. So we passed over.
All these, the petitioners are administrative stops in the respondent corporation. They were subjected to disciplinary inquiry on the ground.
Any other connected matters, Ms. Mukuna?
I have not sought for any.
Any other connected matters?
There are some more matters.
ಅದ್ರಲ್ಲಿ ಯಾರಿಗೆ notice ಮಾಡಿದೀವಿ?
Connected by first time ಬರ್ತಾರೆ ಸುಮಾರು. There are 9 cases.
ಇನ್ನ ಬರಬೇಕು.
ಇನ್ನ ಬರಬೇಕು.
4, 5, 6 connect them to each other. They are case at PC. The DL Sanjeev is directed to accept notice for the respondent. Copy of the petition to be served, objections if any by 17th, released on 24. File ಮಾಡಿದೀರಾ ಮಾಡಿಲ್ವಾ ಇನ್ನ
ಅದನ್ನು ಮಾಡ್ಬಿಟ್ಟಿವಿ ಸ್ವಾಮಿ.
FR number ಕೊಟ್ಬಿಡಿ ಎಲ್ಲ ಕನೆಕ್ಟ್ ಮಾಡಿ ಎಲ್ಲ ಅಬ್ಸರ್ವ್ ಮಾಡಿ.
The respondents were retired officers between 2012 and 2022, my lord. My lord, now they have raised a fresh charter of demands seeking increasing retirement age from 58 years to 60 years. Unfortunately, government has referred them at whether they are justified in demanding retirement age from 58 years to 60 years.
After retiring.
After they retired between 2012 and 2000, your lordship can kindly turn to page 58. 58. They have only produced. Settled legal portion, even assuming they are the workmen, they cannot, when the jural relationship ends, they cannot raise the dispute.
We are finding lot of these references which are made is without application of mind.
Totally without application of mind.
Reference order also does not, point is also not reading properly. Yeah, who makes this reference order?
They have.
Do they have any legal knowledge or no legal knowledge at all?
The service rules done implement padake agala I tara madre.
They have to, this is unnecessary litigation by doing this. And AG accepts notice for respond number
1 minute. Notice has to go for respondent number 2.
Respond number 2 to
41.
41. Not ಎಷ್ಟು waste ಇದು 41 people ಎಷ್ಟು 150 pages. ಅಷ್ಟು 5,000 pages will have to be wasted on this for no reason. Incredible by 27(3), the order of reference.
Annex E, my lord.
9/1/2020 made by the first respondent at Annex E, he stayed till further orders.
Much obliged.
AGA is also directed to inquire and make his submissions as regards the persons, the qualification of the persons who make the reference order and if they have legal background. SSP to be paid on or before 21st, failing which the interim order will stay in automatically vacated. Subramania, SSP by 21st.
Right.
21st.
Process. Very well.
Automatically vacated.
Yes, yes.
41 ಅಂತ one day extra.
Is the appropriate government for Metro Rail Corporation.
Number 8, Malaj, I appear for the petitioner, please, Malaj.
Yes.
In this, Malaj, in certain petitions, Malaj, the Union of India and the state government are yet to file their statement of objections, please, Malaj. The issue pertains to who is the appropriate government in respect of the Metro Rail Corporation, Malaj, which is operating in Bangalore.
They're not deleted petition number.
Yes, Malaj, in respect of that, Malaj, I'll do the needful during the course of the day itself, Malaj.
8.0 Learned Counsel for the petitioner seeks for and is granted 2 days time to comply with the office to delete petition number 3 and file amended first title.
Please.
AGA for R1 to R5 illa alla. Who is going to appear? Santosh Narayan for R1.
52-329.
40113. One sequence alone.
40.
R1 Santosh Narayan.
Please.
R2 to 4 Mr. Kumar, you are appearing. Gurraj Ravi will not be appearing now. What is who is R5? R5 Government of Karnataka. since the ASG has entered appearance, ASG na MN Kumara.
MN Kumar.
MN Kumar has entered appearance for respond number 2 to 4. Delete registry that delete the reference of ASG as appearing for respond number R2 to 4 and print the name of Sri MN Kumar. And AGA accepts notice for respond number 5. Hence delete the reference, registry is right to delete the reference in the cause list as AGA appearing for R1 to R5. Counsels for the response seek for and are granted.
Statement of objections. There are
You want to file, you don't want to.
want to file.
How that?
Sometimes 2 weeks.
Seek for 2 weeks, seek for and are granted 2 weeks time to file their respective statement of objection, objection by 10th March.
Petition was directed to server. Copy.
Copy kotilva.
Inde kottiruva swami. Adikagide.
You've served on the AG's office, Malaj. We'll furnish one more copy, Malaj.
Furnish one more copy.
Please.
I would have given.
You have Mr. MN Kumar's number.
Yes, Malaj, we have Mr. MN Kumar's number.
You are responsible to call him.
Please.
IA 1 of 22 has been filed by Sagar S, claiming that he is no longer a member of the committee, and as such he does not wish to prosecute the above petition. Accepting a submission, IA 1 of 2022 is allowed. Mr. Sagar S is deleted from the array of parties. Counsel for the petitioner to delete him from the petition and file amended past title. The array of the parties is the same.
Yes, Malaj.
Santosh Narayan R3 and the R1 agile.
For R2, Santosh Narayan.
2 and 3 are set. Idella wrong. And AGA accepts the registry guide to correct the appearance of counsels as under. And AGA appearing for respondent number 1, Shri MN Kumar appearing for respondent number 2, Shri Santosh Narayan appearing for respondent number
R3.
DMRCL.
Yes.
Registry directed to delete all other references. The respective response counsel seek for and are granted 2 weeks time to file their respective objections by 10. You want to file rejoinder?
Malaj, depending on what their objections are, Malaj, we'll decide, Malaj.
Rejoinder, if any, by 24th.
Please.
8.2. Santosh Narayan for R1. R2. Your name will have to come instead of Mr. Shashikant. MN Kumar appears for respond number 2. His registry is that delete name of CH-16 as that appearing for respond number 2. Counsel for the petitioner seeks for and is granted a week's time to carry out necessary amendment and file amended past title.
Please.
Objections if 10, rejoinder if any by 20. 8.3. Obrena. No. 8.3 counsel for response seeks for 2 weeks time to file objection. Objection is any by 10, rejoinder by 24. 8.4.
In this case, 1 and 3.
I am petitioner in this case. Interim order is there.
Interim order is not the interim order. 8.4. MN Kumar accept notice for
Respond 1 and
respond number 1.
and 3.
3 is Regional Labour Commissioner. Our AGA will have to appear. There's so much of issue on this cause.
Metro, sorry, only 1.
MN Kumar for respond number 1. Registry is direct correct the appearance. MN Kumar for respond number 1. General Secretary BMRCL Union Arrow.
I appear for the union, Malaj, please. Respond number 2.
Appears for respond number 2. And AGA for respond number 3. Sections same. 8.5. Respondent seeks for 2 weeks. Objections, so on. 8.6.
I appear for response number 1. For the petitioner, interim order is released.
Respondent number 1 sent to you up there. M.N. Kumar for respondent number 1. Shri Jayan Dev Kumar for respondent number 2. Other reference. Objections by 10. Rejoin. 8.7. M.N. Kumar for respondent number 1.
Well, that's here
Illa.
Shanti Bhushan appears for
AGA for respondent number 1.
R2.
Shanti Bhushan will appear for
R2. His name is
different councils. One council, otherwise you will, both of you will say you want to argue. M.N. Kumar for R2.
direct me to take.
Santosh Narayan for R3. M.N. Kumar is directed to take notice for respondent number 2. Delete the name of Shanti Bhushan. Objections by 10. 24. 8.8.
800 Madhukar Deshpande for
AGA for R1. Santosh Narayan for R2. AGA for R1 and R3. Santosh Narayan for R2. M.N. Kumar is directed to accept notice for 4 and 5. Registry is directed print. Objections, if any, by 10. ಎಲ್ಲರೂ copy ಹೇಳ್ತೀವಿ. 8.9. M.N. Kumar for R1. Only one council, Mr. Desai. You won't be allowed to argue. There's no point.
long back we have filed a memo of appearance.
Yes, but only one council. Shanti Bhushan or ಹೆಸರು ತೆಗೆದಾಕ್ಬಿಟ್ಟು ನಿಮ್ದು ಅಷ್ಟೇ. M.N. Kumar for R1. Jayan Dev Kumar for respondent number 2. Objections by 10. Rejoinder by 24. Relist on 30th. And if you want to file common objection, you can file common objection.
Issue is very simple.
I think we don't want 24 councils for the union to come again.
Only appropriate government is the issue. Yes, sir.
Mr. Jayan Dev Kumar is directed to serve copies of the 2 sets of the petition along with annexures on Shri M.N. Kumar and the learned AGA in all the above matters. Twenty-fourth to rejoinder, 30th. We list on 30th. This is Mr. Nishant.
Serial number 9, your lordship.
Yes, my lord. Kindly, number 8, my lord, I got disconnected, my lord. I apologize.
You serve 2 sets on all the councils.
We'll do the needful, my lord. May I make one more submission, please, my lord? In certain matters, my lord, the interim order is in favor of the petitioners, my lord. May I make reference
Those are extended. Those are extended. Wherever interim orders are there, they are extended.
I'm grateful to my lord. I apologize, my lord. I got disconnected. Grateful.
Yes, Mr. Nishant.
Serial number 9 and 9.1, your lordship. The respondent. Senior said that since AG is going to appear in this matter, he wants to appear. Maybe it can be posted by next week.
This is that 17B matter where
17B application only.
supposed to appear on behalf of BBMP. On behalf of BBMP, where there's an application filed stating that 17B has to be complied. In the second matter.
When will he appear?
9.
Omkar is appearing.
In 9.1.
Yes, Mr. Omkar.
Yes, my lord, 9.1, my lord. AG has some difficulty, my lord. My lord can take it up on 3rd, my lord.
That will be quite a little bit.
I have.
There's this matter
23rd
required
and 24th, your lord.
to appear, Mr. Omkar. Why are you putting pressure on the learned AG in all matters?
No, my lord, this was the only matter where we had requested.
There's only one AG, we are 36 courts, so don't put pressure on him like that. The request of Shri Omkar Kambi on the ground that the learned Advocate General would be appearing in the matter. Relist on 3/3 at 2:30 p.m.
Much obliged.
Order earlier granted is extended till next day.
I'll comply with the objections so far as.
In the meanwhile, office objections to be complied.
I'm grateful.
I appear for the petitioner in this matter, Your Lordship. Pray for 1 week's time to the need.
R6, madam. Who is R6?
But I appear for the Provident Fund.
Yes, madam. They are responding. India District Cooperative. Milk Producer Society. Any standing counsel for, or will you accept? AJ, Mandya District Cooperative Milk Producers Society is Union Limited. Union Agara. They are standing counsel are either. Mr. Shekhar. Mandya District Cooperative Milk Producers Societies Union Limited. You take notice. BL Sanjeev accepts notice for respondent number 6. You saved a little
We'll
money.
serve the copy on.
Counsel for the to serve a copy of the petition along with annexures on the said council. Have you filed your objections, madam?
Please, my lord. This is also a higher pension case, my lord. This is
This
also
can
higher
be,
pension.
Yes, Your Lordship. In view of recent Supreme Court judgment, Your Lordship, covered.
Mandya Cooperative Milk Society. Is that the union or the society?
Mandya District Cooperative Milk Producers Society Union Limited.
Union, yes.
You list on 27.
Obliged.
When I play 15 weeks time,
AGS seeks fund is granted 2 weeks time to make payment of necessary process fee. If the process fee is paid, registry is directed to issue notice. So the unsought response is returnable by 6th April.
But in this, the response has expired. Address the deceased.
So application
We have to file application. So he's taking it.
Takes for 2 weeks time to file necessary application to bring the legal representatives on legal representative death respondent on record. We list on 10th March.
10 March. Interim order
Interim order earlier granted is extended. You'll have to look at some impressed amount. Alindana deduct.
Amendment carried out, amended.
Fast track election is filed, fast tracking the same thing on the record.
Amended.
What is the matter?
Pass over medicine. ಹೇಳಿದ್ದೀವಿ ಸರ್. ಮಂಡಳಿ ಅವ್ರಿಗೆ ಹೇಳಿದ್ರು.
So.
Lordships permit me. May I file a reply statement to the government statement of objections filed?
Yes, sir. They'll have to go through it and again. You can file.
I'll file it. Here the issue is, an order has been passed by the district magistrate.
You're filing something, they have to get time to see it and then we'll.
Yes, can you take it up for next week on Monday?
Petitioner has filed a rejoinder.
Rejoinder or
Rejoinder of objections filed by the learned AGA. Learned AGA seeks for and is granted 10 days time to go through the same.
10 days, taken up next week. No, because it's only, the whole issue is that whether section 143 and 144 of the CRPC is applicable or not.
For what?
For the order which has been issued by DM prohibiting strikes.
Prohibiting strikes, good. Why strikes?
Law and order. That is why, whether, of course, subject to your lordship's convenience, can be taken up on Thursday, next Thursday.
Point of law.
It's only point of law. Without jurisdiction, I'm saying.
Factual inner instruction read.
Next week.
23rd.
23rd. Very good.
14, Your Lordship, appearing for the petitioner here. I don't have any specific instruction, Your Lordship. Senior said maybe we can have this matter by next week. We'll make.
Instruction is dismissed.
Well, it's
By
matter has
next
come
week,
up last
definitely I'll
time.
do it by next week, Your Lordship. We've also asked the concerned union office bearers to come and what do you call come before us on Sunday. I will take appropriate steps.
Here we should summons.
Not that we have issued summons, we asked them to come on Sunday. They will be coming. So the senior also will be quite all right by that time.
Senior pressure act but ಅಂತ ನೀವು ಕೇಳಲ್ಲ.
ಅದಕ್ಕೆ ಭಾನುವಾರನೇ ಬರಕ್ಕೆ ಹೇಳಿದ್ದು ಅವರಿಗೆ ಅದಕ್ಕೆ ಮುಂಚೆ ಬರಬೇಡಿ ಅಂತ ಹೇಳಿದ್ದು.
Specifically, court had directed, my lords, on the last occasion, it has been recorded, this has been rendered infructuous, this writ petition. And specifically court pointed out to Satish.
Is not well.
With an understanding.
We have prohibited his appearance for this week.
It was with an understanding Satish should make a submission whether it survives or not. That was all the point that was there. In fact, it was recorded on the last occasion, my lords.
No, I'm not disputing about that, Your Lordship, but thing is,
Them on Sunday. At the request of the council, learned counsel for the petition submit that he has no instructions.
Correct.
Seeks for a week's time to make a submission. If no submissions are made on the next date of hearing, the petition will be liable to be dismissed as infructuous on the basis of the earlier submission made by learned senior counsel for the respondent. We list on 23rd.
Much obliged.
For the petition, 6 fund is granted 10 days time to comply with office obligation. We list on 10/3.
Yes, Sanjeev.
For the respondent.
Do it not so nice.
No, 60.
Hari Prasad. Yes, ma'am.
That is the copy of the statement objection.
Not service, the affidavit has not been shown. Learned counsel for the respondent 6 fund is granted 10 days time to comply with office of on 10/3.
Here for respondent number 3 here.
Where is Mr. Naik?
I pay for the petitioner.
You are appearing, madam.
Early hearing application ಹಾಕೊಂಡಿದ್ದಾರೆ.
Allowed.
Giving certain reasons for which I filed my objections. Compelling, ಅದಕ್ಕೆ ಹೇಳಿದ್ದು.
Early hearing objections.
ಅಲ್ಲ ಅದಕ್ಕೆ ಹೇಳಿದ್ದು. The allegations are such, my lord, the issue involved is about the closure. Now they say I have employed fresh hands in my organization.
Yours, the allegations made.
Against me, therefore I was forced to file my. And
A.R. Anand submit that there are certain allegations which have been made in IA 1 of 2023. The said application being one for early hearing, the allegations made in the said application are immaterial and would not be considered while taking up the matter for final hearing.
That is all.
IA 1 of 2023 is allowed in, as per the above observations, we list on 16th March for final hearing. These are complete?
Please, complete.
16th March for final hearing.
Please, Your Honor. Much okay.
Stay now, madam. You're asking for stay now.
Your Lordship, we have received a prohibitory order. Our matter was dismissed for non-prosecution. And in the meanwhile, we have received
We called that order last.
Lordship, I have sought stay for 2 prohibitory orders, Your Lordship.
Where is Mr. Sarvana? Pass out.
Permitted to file objections.
Again, is a
17B application ಹಾಕಿದ್ದಾರೆ. I am instructed to say that he is gainfully employed. They have got some documents to show. So
have documents.
Yes, that is
When will
the
you file?
instructions I have received.
When will you file?
2 weeks.
You already got the documents and well 2 weeks in.
ಅಲ್ಲ, ಅದು
ಅಲ್ಲಿ ಏನು ಪ್ರೂವ್ ಮಾಡಲಿಲ್ಲ.
ಅಲ್ಲ ಅದು ಪ್ರಶ್ನೆ ಬರ್ಲಿಲ್ಲ ಅಲ್ಲಿ. No, it is a approval application.
ಮಾಡಿಲ್ಲ ಬೇರೆ.
Approval application which is rejected now, against which I have come to this honorable court filing a writ petition. There is an interim order. I may be permitted to file objections to 17.
31(2)(b).
Oh, 32B, 33(2)(b), 33(2)(b). It is not a dispute or reference.
Counsel for the petitioner seeks bond is granted 10 days time to file his objections to IA-1 of 2023. Objections, if any, by 10th March, release on 14th March.
Please, please.
Or 10th ನಿಮ್ಗೆ ಸರ್ವ್ ಮಾಡ್ಬಿಟ್ರೆ ನಿಮ್ 4 ದಿನ ಮತ್ತೆ ಟೈಮ್ ಕೇಳೋದು ಬೇಡ. Kanakraj? Kanakraj.
My lord, I am here, my lord.
21. Ready, madam? Is Kanakraj ready?
Yes, my lord.
What about Mr. P.V. Manjunath? Your opponent is Mr. P.V. Manjunath.
Please.
Yes. In the second matter,
Please.
Mr. Ganesh Paso.
As a response.
22, I am appearing along with Mr. Nitin.
Yes. Yes, Mr. Jain.
Case of dismissal, my lord. And also, in another proceedings, it is withholding 4 increments permanently. So, please, my lord. But there are 2 proceedings, my lord.
2 proceedings and 2 punishments.
2 punishments. So, my lord, both are regarding absence, my lord. Unauthorized absent, my lord. In one case, my lord, that is on 12th March 1987, he is absent about 2 hours. It is the allegation of the management, my lord. Actually, there is no allegation, there is no absent, my lord. On that day, he posted as a leave reserve, my lord. In that proceedings, my lord, he put the signature on master roll at 10 p.m., my lord. And for leave reserve, there is no specific seat arrangement is shown by the management, my lord.
So the first proceeding was initiated as regards your unauthorized absence.
Absent only for 2 hours, 2 hours.
And second was initiated because you used these words.
In first proceedings only that is absent to 2 hours, and also he that use abuse of
proceeding. May make a submission, Lord. Sorry, my lord, for the intervention. There are 2 judges, absence apart. He called the superior officer a bugger. So he says it's a very friendly term. That's not correct. You can't ask tell an officer you bugger. How can you question him? This is a very serious thing. And apart from that, my lord, he has been gallivanting in this court by filing writ petition, writ appeal, special leave petition. So much time was wasted merely on technically challenging the proceedings before so many courts. There was a fashion for settlement. And we offered a fair amount. We wanted to get rid of the whole case. I don't know, Mr. Srinivasan could not convince his client. Now Mr. Jaina has come on record.
This is that matter, okay.
That is matter interruption, remember.
My lord, please. In another proceedings, my lord, there is a 8-month unauthorized absent, according to their allegation, my lord. For that, they initiated inquiry proceedings and finally dismissed from the service, my lord. On December 30th, he dismissed from the service, my lord.
What was the offer made by you, Mr. Kasturi?
We offer
my
5
lord.
lakhs of rupees as a global compensation.
Before that, my lord, before that,
If
my
I
lord.
am wrong, may I learn from you,
Even
correct
8
me.
months.
ನೀವೇನ್ ಹೇಳ್ತೀರಾ ಆಮೇಲೆ ಮತ್ತೆ ಬಂದು ಸೆಟಲ್ಮೆಂಟ್ ಅಂತ ಹೇಳ್ಬೇಡಿ.
Our ವಯಸ್ಸಾಯ್ತು ಈಗ ವಯಸ್ಸು he is about 80.
Now he is 80, my lord. He is a bachelor still, but he is not married.
Bachelor
But,
ಹೇಳ್ಬೋದು,
by that time, he is a active participant in trade union. That, my lord. For that only he is victimized, my lord.
We will hear you. We'll hear you. Since you have now appeared, CH-16 was appearing earlier. There was an offer made by Mr. Kasturi that 5 lakh rupees to be paid as global compensation and the matter resolved. Are you interested? Not interested?
Because, my lord.
Yes or no, everybody. I mean, we'll take it up or we'll.
Otherwise, my lord, kindly pass over email.
Ila, your lordship may have it on Tuesday. Let him consult his client.
My lord,
We don't want you at later.
petition is there, my lord. I will ask. Petitioner is before this court, my lord.
We don't want at later point of time when we are dismissing your petition for, if you were to dismiss.
My lord, we won't anticipate the result, my lord, legal result.
That's what we told Mr. CH-16, that when a proposal is made, you say yes or no.
They in fact went out of their way. Officers from Bombay came. Mr. Srinivasan and I sat with them, and this was not with great difficulty. This offer.
Yes.
My lord, according to you, my lord, even he is not, money is not the criteria, but he want to that scar on his service.
On Tuesday,
Scar on his service. My lord. He want to remove that one.
One accommodation I want till Tuesday.
My lord, here even he is not, money is not the criteria, but he want to remove the scar because it is stigma on his service.
We are not asking you to settle. Only thing that we say that once we take it up, if suppose it goes, then don't come back and say.
Please, my lord.
23rd.
The counsel for the
23rd.
at the request of the senior counsel appearing for the response released on 23rd at 2:30 p.m.
Very good.
Thursday, my lord.
Thursday.
Please, 2:30, my lord. Please.
Much obliged, my lord.
Here,
Anand?
Situation, my lord. This case.
Ready? Both of you are ready?
Yes, sir.
Both of you are ready?
Yes, sir.
Kindly come to page 129, exhibit, annexure M.
Page?
129, 129.
Yes.
This is the basis or foundation for the issuance of charge sheet to the respondent. My lord, this is from one Mr. Arun Shetty, to which is attached the email of Mr. Shankar. I may be permitted to read this, my lord. Dear Mr. Arun, first mail skip madana. Please come to the second. Dear Mr. Arun, greetings from Muller Martini. Muller Martini is an independent agency which is maintaining and servicing the machineries in Manipal Press.
Yes.
Hope all the machines are performing to the fullest capacity. This is for your information that Mr. Ganesh, who is the respondent, my lord, operator of BL500 machine, called me a few days back and he was cross-checking with me about new person joining your company to operate the same BL500. BL500 is the name of the machine. He was upset that I am involved in bringing new face to BL500 and this will affect his career. For your kind information, I do not run any consultancy service and I don't have this ethic. Since the machine belongs to Manipal Press, I don't bother who was operating the machine or who is going to operate this machine in future. If the operator calling me for problems on the machine, I am always there to help. But if he is calling me for reasons other than official, then I am not interested in that. I wish the matter should be solved between the operator and the company and not by involving third party. Hope you understand this. Now, what transpired is stated by one of the witnesses in the inquiry. The respondent calls up this Mr. Shankar Baliga and shouts at him and says, who are you to recruit? Who are you to recommend somebody in my place? My employment is at stake and all that. Assumes, imagines, and this is what actually transpired over telephone also between this Mr. Shankar Baliga and the respondent, about which Mr. Shankar Baliga has complained to one of the senior executives or the petitioner, and that petitioner is examined in the inquiry. And he has in detail stated the conversation, the telephonic conversation. It is not between conversation of the respondent with this Mr. Shankar Baliga before this email was sent. Now, in this background, the respondent was issued with the charge sheet, the inquiry is held, and he has been dismissed. Well, the award is for reinstatement, back wages, etc. 17D is being complied. There is no complaint. 17D is being paid. Now, the short point for consideration, my lord, in this background, whether the complaint, this complaint, and the statement or the complaint over phone given by Mr. Shankar Baliga to the senior executive who was the witness is hearsay evidence. The only ground on which the award is passed, my lord, in this background, inquiry is held to be fair and proper. Inquiry is held to be fair and proper. But on the merits of the matter, the labor court says that the management, that is the petitioner, should have examined Mr. Shankar Baliga himself personally in the inquiry. Otherwise, it amounts to hearsay evidence. And on that count, and on that ground, sole ground, the labor court has passed the award, granting relief of reinstatement and 50% back wages. Therefore, my lord, first I may be permitted to take my lord through the relevant portion of the evidence of the management witnesses in the inquiry.
Two charges.
How?
One is that he is very rude in the workplace.
Yes.
Second, Praveen Acharya.
Correct.
Second one is Shankar Baliga.
How?
In respect of Praveen Acharya, you led evidence?
Here, yes, evidence is led.
In respect to Shankar Baliga, you have not led evidence.
I have not examined Mr. Shankar
Baliga.
Now, the labor court decides each of these misconducts, habitual breach is not proved, disorderly behavior is not proved, disobedience is not proved, so on and so forth, for its own reasons as stated there. The charge sheet, my lord, is Annexure A, page 14.
Yes.
Now, in the light of this brief background that I have given to my lord, may I request my lord to kindly permit me to take my lord to the relevant portion of the evidence recorded in the domestic inquiry, which is the basis for the petitioner to dismiss the respondent. Please come to page number 68. This is the typed proceedings of the inquiry. 68. 68. I'm sorry, madam. Tappagiya.
59 ಆದ್ಮೇಲೆ 82 ಇದೆ. 59 AKMNO PQ ವರೆಗೂ ಇದೆ.
59 up to 59, my lord. Allah. May I, my lord? I'm sorry for it.
Annexure C 58. Inquiry is Annexure C, na?
How?
Okay, so this is type of. Yes.
My lord, the typed copy commences from.
What a problem is this? 60.
I'm sorry.
7 and 60.
Madam, correct agide. I'm sorry, my lord. I'm sorry.
68 is MW1.
Please, my lord.
Not overwriting, so yes, 68.
My lord, the typed copy of the proceedings commences from page 58. Typed copy of the inquiry proceedings.
Typed copy is even more. There is 58.
If my lord permits, to avoid that confusion. In one,
A, B, C, D, E.
58, 59, 60, 61, 62. I'm sorry. I'm really sorry. Madam, I'm really sorry, madam. I don't remember now.
ಎಲ್ಲ ಬಹಳ ವರ್ಷದ್ದೇ ಇವಾಗ ಬರ್ತಾ ಇರೋದು.
I'm sorry.
You can't, we don't expect you to remember.
Mistake ಆಗಿರೋದು ನಂಗೆ ಗೊತ್ತಾಯ್ತು.
No, we can't mark you.
ಅಲ್ಲ ನನಗೆ
But we
ಕೊಟ್ಟಿರೋದು ಸರಿ.
suggest, Mr.
Please.
Take this, number it continuously.
Please.
Because what has happened is for each of these pages, you are given A, B, C, D, E, F.
I'll look into it.
A to E then. A 58 F for F ಇದೆ. Then 59 G and H ಅಂತ ಆಗಿದೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ ಆತರ ಇಲ್ಲ.
ಫೈಲ್ ನಿಮ್ ಫೈಲ್ ಅಲ್ಲ ನಾವ್ ಹೇಳ್ತೇವೆ. ಈ ಫೈಲ್ ನಾವ್ ಹೇಳ್ತಾರೆ.
ಹೌದು, ಓವರ್ ರೈಟಿಂಗ್ ತುಂಬಾ ಇದೆ.
ಓವರ್ ರೈಟಿಂಗ್ ಬಹಳ ಇದೆ. ಆಮೇಲೆ ನಂಬರಿಂಗ್ ಇಸ್ ABCD ಅಂದ್ರೆ ಬಹಳ ಕನ್ಫ್ಯೂಷನ್.
No, I will carry it.
We'll waste a lot of time.
Not good.
What you do is you make a renumber it.
ಬೇರೆ ಒಂದು ಸೆಟ್ ಹಾಕ್ಬಿಡಿ.
ಒಂದು ಸೆಟ್ ಹಾಕ್ಬಿಡಿ, ಕಂಟಿನ್ಯೂಸ್ ನಂಬರಿಂಗ್.
ಹೌದು.
And same set you share with madam, so that all of us are on the same page.
I shall do that. I'm sorry, madam.
When the arguments were taken up, it is seen that there's a lot of overwriting in the page numbers and the issues as regards page numbering. Hence, Shri K.R. Anand, Learned Counsel submits that you would file a fresh set with continuous numbering after serving a copy thereof on the counsel for the respondent. Yavaga ಆಗ್ತೀರಾ?
Next week. 23rd, 24th May.
Agata illa. 10 days time to do the needful. We list on 6th March.
Please. Obliged. I'm sorry, my lord. I just.
ಎಲ್ಲ ಹಳೆಯದು ಇವಾಗ ಬಂದಿಲ್ಲಲ್ಲ. Trial court records are here. There's no problem. Also.
Respondent.
Was working as a conductor. He was found with excess cash of rupees 13.50. And the inquiry, after conducting an inquiry, minor punishment was held with 1 increment, withholding with cumulative effect. And the reference was made after lapse of 14 years. The labor court comes to the conclusion of page 25, is the labor court. Reference bearing
With cumulative, without cumulative.
with cumulative effect.
Labor court has said without cumulative.
Without cumulative. 14 years of delay.
Before, without conducting any inquiry, passing the punishment card.
But you can challenge it after 14 years, Mr. Ravi.
Reason, paragraph.
They keep the document. They are not supposed to keep the documents for you to come whenever you want to come.
On the basis of the apex court, so judgment, my lord, labor court has passed an hour, paragraph 15, page 25. In the decision, Karan Singh versus Executive Engineer, Haryana State Police.
Delay will not invalidate, but extraordinary delay will. 14 years is extraordinary.
No reasons also for this delay.
Cumulative.
Without conducting any inquiry, was an order of minor punishment with holding of one increment with cumulative.
They won't have the documents to produce after 14 years. ನೀವು ಬೇಕಂತ ಅಷ್ಟು ಡಿಲೇ ಮಾಡ್ತೀರಾ?
ಸರ್ವಿಸ್ ಅಲ್ಲಿ ಇದ್ರೆ ಇನ್ನು ಅವಾಗ ಡಿಸ್ಪ್ಯೂಟ್ ರೈಸ್ ಮಾಡಿದ್ರೆ ಸರ್ವಿಸ್ ಅಲ್ಲಿ ಇದ್ರೆ ಇನ್ನು
ಸರ್ವಿಸ್ ಅಲ್ಲಿ ಇದ್ದು ರೈಸ್ ಮಾಡ್ಲಿಲ್ವೇ 14 ವರ್ಷ? You accepted it. That is why we are asking, who is this person who refers these matters without appreciating? After 15 years refer ಮಾಡಿ ಇದೆಲ್ಲ dead matters are being referred. Now are you digitizing everything?
Yes, sir. Yeah, posting other one.
In future you will not be able to say that you don't have the papers. You may not have the original.
Now we've already started digitalizing it. All office communications are all done to.
ಸರ್ವಿಸ್ ರಿಜಿಸ್ಟರ್ ಅಂತ ಎಂಟ್ರಿ ಆಗಿರುತ್ತೆ, ಮೈನರ್ ಪನಿಷ್ಮೆಂಟ್ ಸರ್ವಿಸ್ ರಿಜಿಸ್ಟರ್ ಅಂತ ಇರುತ್ತೆ.
Petitioner Road Transport Corporation is seeking for the following reviews. The respondent workman was employed as a conductor with the RTC on 3/5/1995 when he was discharged his duties. CBT ಅಂದ್ರೆ ಏನು? KMC ಅಂದ್ರೆ? KMC is Shekhar or Wikipedia ನಮ್ಗೆ. From Chikballapur. Rajendra Market, Davangere. KMC andre. The checking official check the bus at back at KMC, Chikballapur CBT. At KMC stage 3, when it's found that the workman is collecting excess cash of rupees 13.50. Hopefully, if everybody is carrying cards, these issues will also not come up.
Cards, my lord, I asked them, my lord. They came and explained. Because the other matter, my lord, had instructed us to take. They came and explained, my lord. Now we have got out with the new technology in 2023. This is a new tab kind of a thing, my lord. We have already implemented all these things. But there are finding difficulties with giving those cards also, my lord. Because monthly pass allow, we've already started issuing cards. And apps have been downloaded. BMTC apps and monthly pass can be downloaded. So we don't have to give a physical form. So monthly pass can be downloaded and daily passes also can be downloaded in the apps. And only these tickets, my lord, is a bit difficult task which we are facing. We had a discussion, because tickets,
let's look at FASTag, which has been implemented. It's RFID.
Tickets, normally BMTC, KSRTC is a different issue. But BMTC with these tags, with this card thing, we are not able to board and onboard these buses because we will not be allowed to keep the passengers waiting in the road for more than a second or 2 seconds.
You don't need to.
But how will we get to know that they have tapped their this one?
You don't educate that tapping is old technology. You are 10 years behind.
Especially with an officer.
That is 10 years behind.
15th August, on 15th August,
just listen. You use FASTag?
Yes, ma'am.
You can, for example, if you get out of Bangalore near the airport, yes, the first toll. If you proceed further towards Hyderabad, you can get out wherever.
Yes.
The place where you get out is what will be charged.
Yes.
If you get out at the airport itself, it is only that which will be charged. If you go to Anantapur, it will be Anantapur charge. If you go to Hyderabad, it will be Hyderabad charge. It is not deducted on the first instant. It is deducted when the person gets out of the road. And there is no tapping involved. It's RFID.
Yes.
So if RFID technology could be used by you, they don't need to tap. Wherever they get out, the amount will be deducted.
That's okay. I discussed with them.
Either we are the expert, nor you are the expert, nor
what they
your
say.
legal officer is the expert.
I spoke to the technology team manager himself. He came.
You have to call experts outside.
So what, the technology team, they had come to our office, they explained how it works, because 2023 we have installed those machines and we have given it to the conductors. Now we also want to make it as an off-grid where all the cards can be used for this. But the only problem is if the passenger gets off and if he does not tap, then I have a loss.
Because the tapping is old technology from what we know. If you ask the proper technology experts,
we are also thinking, we also had a discussion offline, telling that we can move without the conductor. If at all state government supports us, we have an option of moving out without the conductor also. Because how it works, because if you give me 30 rupees per day for anywhere he drives, anyway he goes, 30 to 25 lakhs passengers every day, I get 6.5 crores. That is what I want for every day. But the state government has to look into all this. Conductorless.
Bojagota will look into.
State government has to take this decision. London.
It's a suggestion given by them which we can record for you to examine. The suggestion is very simple. If any person getting into the into any bus pays 30 rupees.
30 rupees. 30 for normal and AC they can see. Anytime.
They don't want.
Day passes.
They don't want any slab rate. It's a 30 rupees. He can get into any bus. He can get out anywhere.
The 70 rupees day passing. 70 rupees only the person who takes the day pass is 70 rupees. So everybody we do the same thing for 30 rupees.
So 70 rupees day pass badlo, it will become 30 rupees for everybody. So the administrative expenses will be saved for KSRTC.
We will not need conductors account because August 15th we had made free. Our
Inta cases will become history. For this 13 rupees 50 paisa, which is in excess, this paper is more than that. The administrative inefficiency of charge sheet, evidence, witness, so many people's time which is wasted. If you, for this 13 rupees 50 paisa, not less than probably 1 lakh of rupees is spent, not less than.
Another alternative, if they give us some transportation cess on electricity meters, what we have done is
how lawyers are happy. They can be happy, but for 13 rupees 50 paisa, should we spend 1 lakh of rupees or more? How efficient is it? Yes.
There's another alternative. The officer came out with this because what he was stating, there are 6.5 lakh meters in our Bangalore city. So if we can charge them some transportation cess on the market, 10 rupees or something.
In meter.
Westcom meters. Some cess if we charge for every household. We can also provide free transport for the entire Bangalore city. That is how it went. Allah. Transportation cess on the 10 rupees per house. So we can provide that. If we calculate the 10 rupees into 6.5 lakh meters, we just made a rough calculation. The law officer came out with this. So don't know how it works. But the state government has to take these calls.
It's an interesting suggestion.
Ellaru cess hakiru namge it works out.
You'll be in surplus, 10 rupees.
Surplus, and these kind of conductorless drivers.
They can be used for something else, not that they won't be. They can be used for something. They
Conductor
can
cum
be paid
drivers.
for,
Hello,
because
they're
you
all
can
conductor
pay
cum drivers.
another 200 buses and do.
No, they're all conductor cum drivers, so we can use them as drivers, but we will not have this conductor issues.
Then you should send a proposal to the government. To the government, it's a policy decision.
Policy, that's the only thing. BMTC itself cannot take the decision. That's a
Have you
policy.
given the proposal?
Not, that is an internal discussion offline, which we had it in our office.
You have to give the proposal, then only they'll consider.
We only had an office discussion, Mala. That is what I think. It's not actually, I don't know how viable also it is. Because
if you don't ask, God also will not give you anything else.
that is there.
So if you don't ask the government, they can't give you anything.
London only $2 what they charge money. You can travel in anywhere. Metro, bus and ship. That is how it worked there. $2 is 200 rupees.
Now you need to come up with something. Bangalore is a Silicon Valley of the country, Silicon Valley of the East. You need to make it more efficient. You ask the government, you push the government, they will also be interested. Everybody has so many things to do, you can't step back and take a broader view.
Yes.
Your officers in your organization have to step back and take the broader view and say that we can do this.
The problem is, we keep touch with only the law section. So the other sections, the law sections.
You should have a meeting with the bank director, bring it to the notice. This is what
we'll have.
And if BMTC or the KSRTC sends the proposal, then only the government will look at it. The government has so many other things to do. And whoever is on the ground should suggest.
Yes.
That's what we are told. All are being numbered and some 2 villages have taken as pilot project. Everything will be taken in sequence. We cannot interfere in the government's working. Whenever the issues come up, we can only suggest that you can do this. And
We have to go conductorless and introducing technology for BMTC. Only way is to go conductorless without even collecting any fares.
your cess idea seems to be interesting if the government takes it. What they are saying is 10 rupees cess on a Bescom meter if it is imposed, and that cess is given to BMTC. They will provide free service to all passengers. Nobody will be charged. Anybody can get in anytime, anybody can get out anytime. Passu beda, yenu beda. That's all. Innenu illa. 10 rupees is a very small amount for any household. You can even say a meter having a bill of 2,500 get 20 rupees.
Per day. Per day 10 rupees.
Per day 10 rupees.
Per day 300 rupees. But you can reduce it. 300, what I'm saying is it's a minimum, but you can reduce it, madam. Now 300 rupees for the entire family you get transportation fee. They can we had an example on 15th August, we made it free, madam. We had the record breaking of 30-40 lakhs passengers getting inside the bus. So if it is free, for sure, the public will also think of it, madam. When you pay,
congestion will be removed.
congestion will also be reduced. When everything is free.
Bangalore is supposed to, today's newspaper says Bangalore is the second most congested city in the world. Not in the country, in the world.
Because metro, my lord, metro's fares are totally higher side. So nobody wants to take the metro fares. The metro is 50 rupees, where bus is 15 rupees. So that class, adu bus se prefer market. So if you make it,
Place the report before this court, we can ask them to take cognizance of it. Until you come up with something, we can't do it.
You only came up with the solution to conductorless.
You play smart.
I went and
any government will be interested in taking the steps which will aid.
the election time.
Any government will take. If ideas have to be given. Crowdsourcing of ideas ಇಲ್ಲ ನಿಮ್ಮಿಂದ ಬರಬೇಕು. ನಿಮ್ಮಿಂದ ಬಂದ್ರೇನು ತಗೊಂತಾರೆ. ಕೊಡಿ ನೀವು. It is 13 rupees 50 paisa, more than a lakh of rupees. Fees 13.50. And since the workman was not authorized to possess more than rupees 15 as personal cash, and the workman had not got permission in the prescribed form for having rupees 13.50 excess, the checking officers reported the same to the disciplinary authority. The disciplinary authority issued articles of charges on 3/5/1995. The reply by the workman not being satisfactory, inquiry not being satisfactory, taking into consideration that 13.50 was in excess, the disciplinary authority passed a punishment order on 8/8/1995, withholding one increment of the respondent with cumulative effect. Now pending from 8/8/95. Each fact makes it difficult. To get this reduced. 28 years for 13.50. In our estimate of 1 lakh is too less. Must be much more. Agreed by the same, the workman on 9/2/2009. In the year 2009, raised a dispute which was referred to conciliation. The conciliation having failed, the appropriate government by order dated 9/2/2009 referred the dispute to the dispute under section 10(1)D of the Industrial Dispute Act 1947 to the Industrial Tribunal Hubli for adjudication, which came to be registered as ID number 147 of 2009. The Industrial Tribunal, after examining the evidence on it and hearing the partners, modified the order of punishment by directing the withholding of one increment for a period of 1 year without cumulative effect. It is agreed by the same that the RTC is before this court, contending that such modification ought not to have been done after a lapse of 14 years, taking into consideration the delay and latches on part of the workman in raising the dispute, which was so raised after 14 years of the punishment being imposed. The B.S. Srinivas, learned counsel for the RTC, that since there's admitted excess amount, the order of punishment was passed. If at all the workman had any grievance, the grievance had to be raised at the earliest. The delay of, on account of the delay of 14 years, the RTC did not have the necessary papers to produce it before the District Tribunal to establish the charges, which has been held against the RTC. The RTC cannot be put at blame for not producing the documents when the dispute itself was raised after 14 years. The SP Ramesha, learned counsel appearing for the respondent workman, would submit that there is no time limit for raising a dispute. The apex court has in 2008, 1 LLJ, page 289, and 2011, 1 LLJ, page 615, has categorically held that delay in raising the dispute will not invalidate the reference. It was for the RTC to have produced necessary documentary evidence to establish the charges when no inquiry had been held. These documents not having been produced, the Labour Court, the Industrial Tribunal has rightly considered the matter and modified the order, which does not require any interference. Third, yes, Srinivas, Sri S.P. Ramesh, produce papers. The dispute has been raised and the order passed by the tribunal is solely on account of no documentary evidence having been produced by the RTC to establish the charges against the respondent workmen. It's a matter of fact that the articles of charges were issued on 3/5/1995. The order of punishment was passed on 8/8/1995, and thereafter the dispute was referred on 9/2/2009. In my considered opinion, though delay itself would not invalidate the reference, an inordinate delay cannot be condoned, and the obligation by which the obligation of proving the charges be vested with the RTC after a period of 14 years, requiring the RTC to maintain documents and paperwork virtually in perpetuity. If at all the workmen had raised a dispute within a reasonable period of time, say 5 years, for which the RTC maintains its records, then the RTC could have produced those documents. The delay being on part of the workmen and the dispute having been raised after a period of 14 years, I have the considered opinion that the RTC could not be held to be at fault in not producing the documents, and or an obligation be imposed on the RTC to maintain the documents in perpetuity. As such, this non-production in my considered of documents, in my considered opinion, cannot be held against the RTC. And therefore I pass the following order. Petition is allowed. The order award of the Industrial Tribunal dated 37/2012 in ID number 147 of 2009 is set aside. The order of punishment imposed by disciplinary authority is confirmed. Bhandari?
The previous matter.
21st. Ready na? Put it 21st.
The respondent is a conductor, Mala. While check.
Inquiry ಮಾಡಿದ್ದೀರಾ?
Inquiry ಆಗಿದೆ.
ಆಗಿದೆಯಾ?
Inquiry ಮಾಡಿ reduced 3 annual increments with cumulative effect.
What was the punishment imposed?
3 cumulative effect, 3 annual increments with cumulative effect, suspension period treated as normal. Be not fair and proper. The entire order is set aside.
What are the grounds for setting it?
Not setting aside, it's a page, at para, page 25. Sorry, page para 9 in the Surah.
Yes.
Para 29, page 29, may read that. M3 is the article of charges issued to the workmen on 27/5/2005. It is alleged thereon that 12/3/2005, the first party workman was the conductor of KSRTC bus bearing numbers. When some passengers were alighted from the bus, the said bus was checked at Bemil Nagar. Then passengers have not been issued tickets by the first party workman, and in that regard, when the checking officials asked the said passengers, they entered into an argument with the checking official saying that they had boarded the bus before Bemil Nagar bus stop. And at that time, the first party workman encouraged those passengers to enter into an argument with the checking official. It is further alleged that the first party workman, instead of handing over the bag and ticket tray to the checking officer, threw them near the exit door and went away saying that "Ee tara neevu madidare kelasa maduvodu kagalla." And thus he misbehaved with the checking staff. M4 is the reply given by the was coming from KGF to Bangarpet. The same checking staff came to check the bus, and on finding nothing against the conductor, they went away with grumbling, and when he objected to the same, they told him that they would teach a lesson to him, and that on the following day, that is 12/3/2005, they came back to the bus in question and made some entries in the waybill, and subsequently, when he read the noting made by the checking officials, he came to know that they had recorded that the first party workman had objected to the checking, and after writing this, struck out the same. He denied that he had not issued tickets to 10 passengers. According to him, there were 20 passengers in the bus, and there was no head count of the passengers by the checking officials, and a false report has been made about it. Before the inquiry officer, one side of the Srapul was examined as witness on 28/6/2005. He gave evidence that on 12/3/2005, he and his colleague Manjunath Swami checked the bus bearing number F374 at Tamil Nagar and found 10 ticketless passengers alighting from the bus, and when they were asking those ticketless passengers, they told that they boarded the bus at the earliest stop, and that time the said ticketless passengers encouraged by the first party worker to enter into an argument with the checking officials, and thereafter the first party workman threw the cash bag and the ticket tray near the exit door of the bus and went away. He further stated that at the time, the passengers in the bus started asking them to clear the bus, saying that they have to catch a train, and thereby he made a shara in the conductor's name. During the class examination, the witness stated that he tried to collect the fine from the ticketless passenger, but they went away without paying the fine. He also stated he had obtained the statement of those ticketless passengers at exit, but none of the passengers had signed the said statement. He has also stated he had not obtained the statement. The workman examined by Veerbhadraya as a defense witness, and the said witness stated before the inquiry officer that he was traveling in the said bus on 12/3/2005, and at 7:45, the checking official boarded the bus near toll gate of Bemil Nagar, and they obtained the waybill from the conductor and wrote something in the Bemil Nagar. No passengers alighted from the bus, and no galata took place. Another witness by name Ramchandrappa was also examined as defense witness, and he too stated similarly. The said witness produced copies of their tickets bearing numbers ONs. M12 is the defense statement filed by the workman. He has retired his stand taken by him earlier. The inquiry officer has accepted the evidence of the checking officials and held that the charges good. He had not discussed the unchallenged evidence given by the defense witness Veerbhadrappa and Ramchandrappa. The conductor's waybill is not produced on publication of evidence, and failure of taking official to record the statement of and so-called ticketless passengers will all render the findings recorded by the inquiry officer's presence. The disciplinary authority has not considered the evidence of the defense witness. If really the conductor misbehaved the checking official, they would have made a report to the police concerned alleging that the conductor obstructed the discharge of duties by a public servant. The said checking officials have not done so. Under this circumstance, Tribunal finds the disciplinary authority was not justified in passing the punishment order dated 7, imposing punishment of reducing basic pay of workmen by 3 annual increments with cumulative effect, and further directed the period of suspension to period as to therefore answer. This is the reason the last.
Not examined anybody. Statement is not signed by the passengers, not collected fine. Only a statement of your checking officials against whom some allegations are also. Seem to be proper.
And there is also past history.
My evidence is unchallenged.
99 past history.
Though. We are concerned for this. Are you installing cameras now in the buses?
They have already installed, Malak, but I don't know how effective it is.
These are all, you have to do these things. If you do all those things, there's technology available, there's means available.
I think the checking officials have cameras now. They have,
Checking officials should have body cams.
they have body cameras.
The bus should have a camera.
Yes, they've got body cameras. 2023,
Everybody has. We'll record that statement.
That's what they said. I'll just ask.
All checking officials.
He is instructed that they have body cameras. I'm just verifying.
ಬಾಡಿ ಕ್ಯಾಮ್ರಾ ಮಾಡ್ಕೊಂಡಿಲ್ಲ ಯಾಕಂದ್ರೆ ಅದೇನು ಬೇರೆ ಬರಿಬೇಕಲ್ಲ ಅಷ್ಟೇ ಆಪೇ ಮಾಡಬಾರ್ದು ಅಂತ ಆರ್ಡರ್ ಮಾಡ್ಬೇಕು ಅಷ್ಟೇ ಅದು ಅಕಾರ್ಡಿಂಗ್ ಟು ದೇರ್ ಓನ್ ಕನ್ವೀನಿಯನ್ಸ್ ಇಲ್ಲ ಅದು ಅನ್ನೋದಿಲ್ಲ
ಭೋಜೇಗೌಡ ಇನ್ನೊಂದ್ರಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ ಬಾಡಿ ಕ್ಯಾಮ್ರಾಸ್ ಫಾರ್ ಆಲ್ ದಿ ಪೊಲೀಸ್ ಆಫೀಸರ್ಸ್ ದೇ ಆರ್ ಬೀಯಿಂಗ್ ಸೆಕ್ಯೂರ್ಡ್ ನೆಕ್ಸ್ಟ್ ಮಂತ್ ಬರ್ತಾ ಇದೆಲ್ಲ ನೋಡ್ಬೇಕು. The RTC is before this court seeking for the following reliefs. The respondent workman working as a conductor with the RTC on 12/3/2005 when he was discharging his duties on the bus flying on route number 83, is alleged that he had prevented the checking officials from checking the bus at BML Nagar at about 7:45 hours and instigated the passengers in the bus and misbehaved with the checking officials and created nuisance at the spot. The checking officials having submitted a report to the disciplinary authority. The disciplinary authority issued article charges, which was replied to by the workmen. The disciplinary authority, not being satisfied with the reply, instituted inquiry by retired district judge. The inquiry officer submitted a report that the charges against the workman had been approved. The disciplinary authority issued the second show cause notice, not being satisfied with the reply thereto, by way of a punishment order dated 17/9/2005. The disciplinary authority directed the withholding of 3 annual increments with cumulative effect. The workmen challenged the same, raised a dispute. Conciliation proceedings ended in a failure, and the appropriate government, by order dated 5/3/2009, referred the dispute to the industrial dispute to the Industrial Tribunal, Bangalore, which came to be registered as ID number 72 of 2009. The Industrial Tribunal, after recording evidence, hearing arguments, set aside the order of punishment and it agreed by saying that the RTC is before this court. During the pendency of the above matter, the workmen expired and as such as legal representatives have been brought on record. The B.S. Srinivas, learned counsel for the RTC, would submit that an inquiry being held to be fair and proper, the tribunal ought not to have disturbed the order of punishment passed by the disciplinary authority. The offences and or the delinquencies which have been alleged against the workman being serious in nature, the punishment of withholding of 3 annual increments is proper and correct. The tribunal ought not to have drawn adverse inference on account of non-examination of the ticketless passengers, since they left the spot in a hurry wanting to catch a train. The statement of the checking officials ought to have been believed and considered by the tribunal. The health shaker learned counsel appearing for the workman was permit that the evidence of the workman having gone unchallenged, workman under witness having gone unchallenged, they not being cross-examined. Apart from the checking officials, no witness having been examined by the RTC. There was nothing on record to implicate the workman in respect of the charges alleged against him, and as such, the tribunal has rightly rejected. It rightly set aside the order of punishment. So, whenever there is any delinquency which is being alleged against a worker, it is required for the employer to establish by a preponderance of probability the allegations made and the charges made against the workman. In the present case, the charges are that on 12/3/2005, the workmen had not issued tickets to around 10 passengers. And when the checking officials checked the bus, at the time when the passengers were alighting, they were found ticketless. At which stage it is alleged that the workmen instigated the passengers to have a quarrel and or an argument with the checking officials. It is on that basis that the entire disciplinary proceedings commenced. For these allegations to be established, it was but required for the checking officials to have recorded the statement of the ticketless passengers that they had not been issued tickets despite having paid for the same. The disciplinary authority, the RTC also ought to have, the checking officials also ought to have recorded the same in the waybill after obtaining the signature of the conductor. The checking officials ought to also have imposed penalty on the said ticketless passengers and collected the same. As could be seen from the evidence on record, none of the above basic things have been performed by the checking officials. And the reason being given is that the passengers were in a hurry to catch a train. Such an explanation cannot be accepted when there are ticketless passengers traveling on a bus selected, and mere being in a hurry would not have precluded checking officials from imposing such fine on the ticketless passengers. The allegation as regards the workmen having interfered with the performance of the official duties of the checking officials by instigating and misbehaving with the checking officials also ought to have resulted in a complaint being filed against the workmen immediately with the jurisdictional police, which is also not being done. These aspects have been rightly considered by the tribunal. The tribunal has rejected, set aside the punishment. I do not find any reason to interfere with such a finding. The petition stands disposed. At this stage on inquiry, Learned Counsel for the petitioner, Learned Counsel for the RTC submits that body cameras have been issued to all checking officials and that the are in the process of being issued to all checking officials and that cameras are also proposed to be installed in all buses, which would in future establish the events which have occurred. Though the above matter is disposed, relist on 13(3) to enable the counsel for the petitioner to place on record the standard operating procedure in respect of the body cameras, as also the cameras installed in the bus.
Last, when we disperse the amount, the monetary benefits within 3 months or 4 months, any date.
All the amounts, all and every amount which is required to be paid to the workman and subsequently to his legal representatives is directed to be paid within a period of 6 weeks, 4 weeks, 8 weeks from the date of receipt of a copy of it. Yeah, one payment 8 weeks back.
ಇದು ಆಡಿಲ್ಲ ಅಂದ್ರೆ 1 ವರ್ಷ ಆಗುತ್ತೆ. 1 ವರ್ಷ ಆಗುತ್ತೆ. ಈ ಆಡಿದ್ರೆ
we call for all records of how long it has taken for disbursement. Why does it take such a long time?
just check with the
These are all simple things.
Will delay this 14 years delay.
But RTC is before this court seeking for the following rules. The respondent workman is working as a conductor with the adjudication. Workman, while discharging his duties on 24/4/1991 from Sainagar to Chikbadapura, the bus was checked at the Chikbadapura gate and found that he had failed to issue one ticket of 0.75 rupees and not collected fair amount from him when he was traveling from Hosur to Chikbadapura. And further, the workman was found to be in possession of excess cash of rupees 11.15. The checking officer, having submitted the report to the disciplinary authority, the disciplinary authority issued articles of charges on 9/7/1991. The reply submitted by the workman not being satisfactory, inquiry was conducted.
Inquiry conducted without holding in.
Conducted inquiry and submitted report.
Yes. Really, synopsis ಹೇಳಿದ್ದಾರೆ, but award without conducting any. Paragraph 14 of the award, page 20. Like admitted the second party management has not conducted domestic inquiry in this case.
Para 14.
Para 14, page 20. After 5th line.
Inquiry ಆಗಿಲ್ವಾ Mr. Bandari? Inquiry ಅಂತ 13 ಅಲ್ಲಿ inquiry ಅಂತಿದೆ. Para 14 ಅಲ್ಲಿ no inquiry ಅಂತಿದೆ.
Actually, ಇದರಲ್ಲಿ records ಇಲ್ಲ actually. It is after delay he has challenged your lordship. They have not kept the papers.
So according to you, conducted the inquiry but could not produce it.
Yes.
Conducted an inquiry. The second show cause notice came to be issued, but the reply thereto also not being satisfactory. The disciplinary authority imposed an order of punishment. In punishment, holding one incident with cumulative effect. It is agreed by the same that the workman raised a dispute. When was the dispute raised?
In 2008, yes.
Reference order is 90.
What is the reference order?
Reference order, you have to get it. Reference order, ಹಾಕಿಲ್ಲ. Your Lordship, you get it 28/10/2008. First page, initial A.
Year 2008. When and conciliation having failed, the appropriate government wide reference order dated
28/10/2008.
28/10/2008 referred the matter to the Industrial Tribunal, Hubli, for adjudication. The Industrial Tribunal coming to a conclusion that there is no inquiry, there is no document produced to establish that there was an inquiry held and that the RTC had failed to establish the delinquency on part of the workmen.
And charge proved before the tribunal also.
Set aside the modified the order of punishment by directing the withholding of an increment without cumulative effect. It is agreed by saying that the RTC is before this court. The Harish Bhandari, Learned Counsel.
Your Lordship, in page 20. Thus, in the absence of the cogent and convincing evidence on record, there is no alternative except to hold that misconduct attributed against the workman stands established, and accordingly, I hold that the misconduct attributed against the workman stands established. Your Lordship, internal page 8. First paragraph of the ನಾಲ್ಕು line.
There are bada issues there. A lot of contradictions in this award. ಅಲ್ಲಿ ಎಸ್ಟಾಬ್ಲಿಷ್ಡ್ ಅಂತಾರೆ, ಇನ್ನೊಂದು ಜಾಗದಲ್ಲಿ ಇಲ್ಲ ಅಂತಾರೆ. ಎನ್ಕ್ವೈರಿ ಇದೆ ಅಂತಾರೆ, ಇನ್ನೊಂದ್ರಲ್ಲಿ ಎನ್ಕ್ವೈರಿ ಇಲ್ಲ ಅಂತಾರೆ. ಬಹಳ ಕಾಂಟ್ರಡಿಕ್ಟ್ಸ್. Seems to be a copy and paste. There is no application of mind.
There is a delay, Your Lordship. It's long.
Bhandari, Learned Counsel for the the petition is allowed.
And 13 years ಇದೆ.
ಮುಂದೆ ಇದೆ ಹೊರತು
One increment, withholding of one increment with cumulative effect.
RTC is before this taking for the following reason. Respondent workman who is working as a conductor in the room Nali to Shimoga. Way early. When it was found that the bus carried 40 adult passengers and 20 school-going students, and the conductor had not issued tickets to 20 students but had collected fare of 75 each. The students were subjected to penalty, and the penalty recovered from them. The checking officials forwarded the checking report to the disciplinary authority, who issued articles of charge. They replied there to be satisfied. On the basis of the documents available, the disciplinary authority imposed a minor penalty of reduction of fare 1 increment with cumulative effect while order dated 16/4/1996. The workmen raised a dispute in the year 2009. The conciliation having failed, the appropriate government referred the matter for adjudication to the Industrial Tribunal, Hubli. The Industrial Tribunal, after recording of evidence, came to a conclusion that the charges against the delinquent officer, delinquent conductor had not been proved. None of the documents relating to the issues of charge, reply, or documents relating to the alleged delinquency had not been produced. In that background, the Industry Tribunal set aside the order of punishment. It is agreed by saying that the RTC is before this court. The counsel appearing for the RTC would submit that the dispute having been raised after an inordinate period of 13 years, the RTC did not have the necessary papers in its possession to produce before the Industrial Tribunal, and as such the same cannot be held against the RTC. The disciplinary authority had imposed order of punishment on the basis of the document then available on record, which indicated that 20 students had not been issued tickets, though amounts were collected. The fact that penalty had been imposed on those students would establish the delinquency on part of the conductor. And as such, the tribunal ought not to hold the non-production of the documents after a period of 13 years to be against the RTC. These grounds is submit that the petition is required to be allowed. The SP Rameshal and counsel appearing for a response would however submit that the tribunal has rightly considered all the aspects and there being no documents on record to indicate the delinquency, no domestic inquiry having been held, no punishment having been imposed. It was for the RTC to establish the delinquency before the tribunal, which not having been done, the modification of the punishment order has been made, which ought not to be interfered with by this court. Also, and so forth. The same order as 26. But it is allowed. Mr. Subramania?
I appear for the petitioner.
Yes,
This matter, we have filed a judgment of the coordinate bench of this honorable court, which covers this issue, Your Lordship. We have filed this on 12/10/2022.
How was the judgment?
Judgment dated 8th December 2020, passed by this honorable court. This pertains to delay and latches, Your Lordship. After 20 years, they have raised the dispute, which was referred. This pertains to temporary TTR employees who were regularized in 1983 and
employer?
I'm sorry, Your Lordship.
Same employer?
Same employer, KPTCL.
This counsel for the petitioner submit that the list involved in the above matter has been decided in similar matter by a coordinate bench of this court, while order dated 8 December 2020 in WP 13075 of 2015. He submits that in view thereof, the
What has to be quashed, Your Lordship. Next check. If
petition is required to be allowed.
No, Your Lordship. Please, correct.
Allowed in the award dated 15/10/2010 passed by the Industrial Tribunal Mysore in reference number 89 of 2004 is required to be quashed. None appears for the respondent. In the interest of justice, one more opportunity is granted for the respondent to enter appearance, failing which the submission.
Previous date also the same observation was made by Your Lordship.
Then we'll pass it. None has been appearing for the respondent, and this court, while ordered at 9/2/2023, has granted one final chance for the respondent to appear, despite which the respondent has not appeared. In view thereof, I pass the following order. The award dated 15/10/2010 passed by the Industrial Tribunal Mysore in reference number 89 of 2004 is quashed in terms of the order dated 8 December 2020 in WP number 13075 of 2015.
Much obliged.
Yes. Sigata file copy beka. Copy ಬೇಕು ಅಂದ್ರೆ ಕೊಡ್ಸ್ತೀವಿ. Apply ಮಾಡಿ ಕೊಡ್ಸ್ತೀವಿ. ಇದೆಲ್ಲ ಹಳೆ matters we have. ಎಲ್ಲಾರ್ದು ಇದೇ same problem ಬರ್ತಾ ಇದೆ.
Next week ಮಾಡ್ತೀನಿ.
And counsel for the petitioner submit that he is misplaced his file. And as such he seeks for 2 weeks time to take out the file and make his submission. The counsel for the petitioner is also permitted to apply for copies of the court file, and if such an application is made, the registry is directed to issue necessary copies. Relist on 20th March. In Siglila under application act. Respond number 2, Mr. Number. To hand summons into the other case. Not through court summons that they have been served.
Ini inta ex-partner.
Is one of the partner.
Ex-partner
of this firm.
Of your
The
firm.
government industry.
You have a dispute with him.
I don't have any.
Then why don't you appear for him? If he's your ex-partner, you should appear.
He used to be a partner at one point of time, from 1998 to 2007, not thereafter.
Because this is only served through hand summons, Mr. Mukherjee. You have to issue court notice.
What this?
The registry has endorsed that respond number 2 has been served through hand summons. And the considered opinion that court notice has to be issued. Issue court notice to respond number 2 returnable by 30. ಆಗಿದೆ.
Earlier hand summons ಹೋಗಿದೆ ಸರ್.
Hand summons we can't.
Court notice office ಆಗಿದೆ ಅಂತ
ಮಾಡಿ.
No such person. And the postal hand summons and the postal summons issued has been written with the endorsement no such person. Hence, it would be required for fresh notice to be issued to the proper address. The SB Mukarnappa seeks for and is granted.
Otherwise, my lord, only way out for me to take a paper publication.
There is no ಹೊಸ address ಹುಡುಕ್ಬೇಕು ನೀವು.
Correct address in
No, I'll find out. If I know, I will give you certainly. Because his appearance will also be helpful to me to some extent.
Because he supports me. You and me go to the labor court, he has given me evidence of my favor.
Then it is in your interest to get. Fixed for and is granted 2 weeks time to secure the fresh address of respondent number 2 and furnish the same. Relist on 14/3. The Ramachandra.
This case, the other side has informed that the matter may be referred to mediation. So that there is a chance of settlement.
Mediation ನೀವೇ ಮಾತಾಡಿ.
ನಾನು ಅದೇ ಹೇಳಿದೆ ಇಲ್ಲೇ ಮುಗಿಸ್ಬಿಡ್ಬೇಕು.
What is the terms? ಬಂದ್ರಲ್ಲ.
The appellant was the petitioner was terminated from the services.
What is your offer? What is your offer? ಮಾತಾಡಕ್ಕಲ್ಲ ಇಲ್ಲಿ ಹೇಳಿ. ಗೊತ್ತಿಲ್ಲ ಅಂದ್ರೆ ಮಧ್ಯಾಹ್ನ ಹೇಳಿ.
ಮೀಡಿಯೇಷನ್ ರೆಫರ್ ಮಾಡಿದ್ರೆ
ಮೀಡಿಯೇಷನ್ ಹೋಗಿ ಮೀಡಿಯೇಷನ್ ಮಾಡಲ್ಲ, ಹೋಗೋದೇ ಇಲ್ಲ ನನಗೆ. ಎಲ್ಲ ರಿಟರ್ನ್ ಆಗ್ತಾ ಇದೆ.
ಇಲ್ಲ okay, it may be
That is
recorded.
why we are not referring matters, labor matters we are not referring. Other matters we refer. ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು ಮತ್ತೆ failed ಅಂತ ಬರ್ತಾ ಇದಾವೆಲ್ಲ.
Mediation refer ಮಾಡ್ಲಿಲ್ಲ ಅಂತ.
ಫಸ್ಟ್ ನಿಮ್ಮ ಆಫರ್ ಹೇಳಿ, ಆಮೇಲೆ ಅಲ್ಲಿ ರೆಫರ್ ಮಾಡಿ.
ಅಲ್ಲ, mediation refer ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಾವು ಮಾತಾಡ್ಕೊಂಡು next date of hearing ಅಲ್ಲಿ settle ಮಾಡಿ. Mediation refer ಆಗಲಿಲ್ಲ.
Once you give your offer, and once they give their offer, then we can see if there is some possibility.
In fact, there were talks in between, some difference is there.
ಆಮೇಲೆ ಅಲ್ಲಿ ಹೋಗಿ ಬಂದ್ಬಿಟ್ಟು ನಾವು 50,000
ಇಲ್ಲೇ ಮುಗಿಸ್ಬಿಡ್ಬೋದು.
10 ಲಕ್ಷ ಕೇಳ್ತಾ ಇದ್ರು, ಆಗ್ಲಿಲ್ಲ ಅಂತ.
Mediation refer ಮಾಡಿಲ್ಲ, ಪರವಾಗಿಲ್ಲ, ನಾವೇ ಮಾತು.
Both the council submit that given a week time, they will explore the possibility of settlement. Re-list on 27th at 2:30 PM for reporting settlement.
Much. Please.
Thirty-five
appear for the respondent in this matter, my lord.
Yes. Yes, Mr. Naik. Ready?
Lord. Yes, my lord.
ಅಲ್ಲಿ ಹುಡುಕ್ಬೇಡಿ, ನೀವು ರೆಡಿನಾ ಅಂತ ಹೇಳಿ.
I'm ready.
And Swami, ready? 35.
Second round.
Minimum wages ಇದೆ, ಇನ್ನು ಒಂದು GM ಇದೆ. ಅವ್ರು ಫೈಲ್ ಮಾಡಿರೋದು.
The writ which I filed, my lord, is regarding bank guarantee.
ಅದು ಯಾಕೆ ಕನೆಕ್ಟ್ ಆಯ್ತು ಅಂತ ಗೊತ್ತಿಲ್ಲ ಸರ್.
ಅದೇ ಕನೆಕ್ಟ್
ಮಿನಿಮಮ್ ವೇಜಸ್.
My lord, connected because pertaining to the same matter in the earlier round of writ petition when the matter was pending, I was asked to give a bank guarantee.
This being GM residuary will not come to us.
Please. No, because the issue arose out of the same order, it got connected.
Okay, the bank guarantee was required as security for the payment, is it?
Please.
So if the first one gets dismissed, then your bank guarantee goes. If the first one gets allowed, your bank guarantee will get encashed.
The bank guarantee, my lord, was required until the labor commissioner passed order that. So in effect, that is over. I was now not required during the present proceedings to furnish any bank guarantee. It was in the earlier writ proceedings that I was required to give bank guarantee.
So
but
then
still the bank is holding lien on this amount.
35.1 is infructuous. It has to be dismissed.
Please, it has to be dismissed, but the bank is still holding lien on it. That is the reason.
First argument ಮಾಡಿ ಅದರ ಮೇಲೆ
The impugned order is a connection game, right?
created
55021.
Yes.
Generally, the authorities has come to the conclusion. I am entitled for the difference of wages. And difference of wages alla kelta iralla. Avaru ಏನು ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ ಅಸಿಸ್ಟೆಂಟ್ ಸೇಲ್ಸ್ ಮೆನ್ಗೂ ಸೇಲ್ಸ್ ಮೆನ್ಗೂ ಡಿಫರೆನ್ಸ್ ತಗೊಂಡು ಆ ಡಿಫರೆನ್ಸ್ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. That's not my claim.
Is it scheduled?
ಹೌದು.
ಶೆಡ್ಯೂಲ್ ಪ್ರಕಾರ ಏನಿದೆ?
ಶೆಡ್ಯೂಲ್ ಪ್ರಕಾರ ಸೇಲ್ಸ್ ಮೆನ್ಗೆ page 48 subject F2 ಸಮೀಕ್ at page 47 ಇಂದ ಶುರು ಆಗುತ್ತೆ. 48 ಅಲ್ಲಿ ಸೇಲ್ಸ್ ಮೆನ್ ಅಂತ ಸೀರಿಯಲ್ ನಂಬರ್ 4. ಅದಕ್ಕೆ 2192 was the
serial number.
Serial number 4 ಅಲ್ಲಿ ಸ್ವಾಮಿ ಸೇಲ್ಸ್ ಮೆನ್ ಸೇಲ್ಸ್ ಗರ್ಲ್ ಅಂತ 48ನೇ ಪೇಜ್ ಅಲ್ಲಿ
Salesman sales girl in group 3.
ಹೌದು.
Group 3 salesman sales girl ಅಲ್ಲಿ ವಲಯ 1ರಲ್ಲಿ ನೀವು ಯಾವ ವಲಯದಲ್ಲಿ
ಇಲ್ಲಿ ಬ್ಯಾಂಗ್ಳೂರು
ವಲಯ
2192
ದಾವಣಗೆರೆ
2000 ವಲಯ
2
CB ರೋಡ್ ದಾವಣಗೆರೆ.
ಹೌದು. ಕನೆಕ್ಷನ್ G ನಲ್ಲಿ ಕ್ಯಾಲ್ಕುಲೇಷನ್ಸ್ ಹಾಕಿದ್ದೀನಿ ಪ್ರಕಾರ.
So you are in ವಲಯ 2.
ಹೌದು.
So that will be 1252.
ಹೌದು.
1265.70.
ಅಲ್ಲ 2180.
2180 ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
ನಂಬರ್ 4 ಕಾಲಮ್ ನಂಬರ್ 4 ಅಲ್ಲಿ
1
ಅದು
group 2 1328 ಇದೆ, group 3 page 49 ಅಲ್ಲಿ ಬರುತ್ತೆ, 15 ಪಕ್ಕದಲ್ಲಿ ಇದೆ, 1265.70 ಇದೆ. ಇಲ್ಲ.
Not for different period, there was different amount being specified.
F1 ಇಂದ ಶುರು ಆಗುತ್ತೆ ಸ್ವಾಮಿ. Earlier F1 page 43.
For which period?
ಅದು ಪೀರಿಯಡ್ 2006. ಹೌದು.
96 to next one ಬಂದಿತ್ತು 2003.
ಹೌದು.
2003 group
2003. 21st February 2003.
Group 3 salesman, sales girl became 2181.
Also.
So from 96 to 2003, you would be entitled to 1265. From 2003 to next year ಬಂತು.
ಅದೇ ಕಂಟಿನ್ಯೂ ಆಗಿದೆ. ಇದೆಲ್ಲ ಅನಿಕ್ಷರ್ F2 ನೇ ಫೈನಲ್.
F ಆದ್ಮೇಲೆ ಇನ್ನೇನು?
ಅದಾದ್ಮೇಲೆ ಆಗಿದೆ, ಇದಕ್ಕೆ ಸಂಬಂಧ ಇಲ್ಲ ಈ ಕೇಸ್ಗೆ. ನಾನು ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಅನಿಕ್ಷರ್ G at page 51. I have given the calculation for the entire period.
ನಿಮ್ಗೆ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ರು?
ನನಗೆ ಕೊಟ್ಟಿದ್ದು ಫಸ್ಟ್ ಇದರಲ್ಲಿ 482 ಬೇಸಿಕ್, 410 VDA,
1382.
ಹೌದು. ಡಿಫರೆನ್ಸ್ 255 ರೂಪಾಯಿ ಬಾಕಿ ಇತ್ತು. ಅದರ ಪ್ರಕಾರ ಲೆಕ್ಕ ಮಾಡಿ ಅಟ್ ಪೇಜ್ 59 ಅಲ್ಲಿ ಟೋಟಲ್ ಕಮ್ಸ್ ಟು 62,400 rupees for the entire period. Page 59, last
65.
Also, difference is 62,413 paisa.
Any dispute in the calculation, Mr. Naik?
Yes, my lord. My lord, what had happened was earlier I had paid them as an assistant salesman, not as a salesman. That is the reason they first approached. After the earlier writ proceeding, when the matter went back at Annexure A order, the Labour Commission.
Is there a classification of assistant salesman in the minimum wages?
Please, he comes under group 3. Group 4. Assistant salesman is in group 4.
Assistant salesman item number 5.
In group 4.
1, 2, 3, 4. Is it 1328?
Please.
So what is the calculation as per group 4?
ಅಲ್ಲ ಆ ತರ ಕೊಟ್ಟಿದ್ದಾರೆ ನಿಮಗೆ.
I had paid.
ನನಗೆ ಈ ಸ್ಯಾಲರಿ ಕೊಳ್ಳೇ ಇಲ್ಲ.
ಸೇಲ್ಸ್ಮನ್ ಆಗಿ ಅಪಾಯಿಂಟ್ ಆಗಿದ್ದೀರಾ ಅಂತ ಏನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರು?
ಅದಕ್ಕೆ they themselves have admitted before the authorities. I will take just my lords, the impugned order starts from ಅದರಲ್ಲಿ ಒಂದು 2-3 ಪ್ಯಾರಾ ಓದ್ತೀನಿ, ಅವರೇ ಕ್ಲಿಯರ್ ಆಗಿ ಅಡ್ಮಿಟ್ ಆಗ್ತಾರೆ.
No, I'm not disputing that. My lord, I'm not disputing that.
So ಇವಾಗ ಸೇಲ್ಸ್ಮನ್ ಅಸಿಸ್ಟೆಂಟ್ ಸೇಲ್ಸ್ಮನ್?
Salesman.
He was paid as a salesman. I have honored the Annexure A order and I have paid the additional amount also. The only dispute is they are claiming for dearness allowance separately. Whether this dearness allowance separately should be paid or not is the issue. Now, my lord may kindly take Annexure F which they have produced. Until 1996 December, the Shops and Commercial Establishment Act, the table was enforced from 1987 to 1996. Now, my lord may kindly see there group 3 salesman for sector 2 where Davangere comes, that is 482.50, that is to be paid. Then after the table at page number 41, my lord may kindly see, after listing out all the tables, they say that the rates mentioned in this notification includes the rates of dearness allowance available for the state average consumer price index 700 points. Dearness allowance shall be paid at the following rates for increase over and above 700 points. Now, my lord, the RBI website does not show that there was any increase of over 700 points in 96. The next notification,
96 to 2003. 96 to 2003. What is the basis variance, basis point difference?
96 to 2003, Annexure F1 After the table is over, ಅಲ್ಲಿ ತುಟ್ಟಿ ಭತ್ಯೆ ಅಂತ it is written at page 45. After the table is over at page 45, may not be kindly. ಈ ಅಧಿಸೂಚನೆಯಲ್ಲಿ ಸೂಚಿಸಿರುವ ದರಗಳು ರಾಜ್ಯ ಸರಾಸರಿ ಗ್ರಾಹಕ ಬೆಲೆ ಸೂಚ್ಯಾಂಕ 1960 1513 ಅಂಶಗಳಿಗೆ ಲಭಿಸುವ ತುಟ್ಟಿ ಭತ್ಯೆ ದರಗಳನ್ನು ಒಳಗೊಂಡಿದೆ. ಇಟ್ ಇನ್ಕ್ಲೂಡ್ಸ್ ರಾಜ್ಯ ಸರಾಸರಿ ಆಧಾರದ ಮೇಲೆ ಗ್ರಾಹಕ ಬೆಲೆ ಸೂಚ್ಯದಲ್ಲಿ 1513 ಅಂಶಗಳಿಗೆ ಹೆಚ್ಚಾಗುವ ಪ್ರತಿ ಅಂಶಕ್ಕೆ ಈ ಕೆಳಕಂಡಂತೆ ಕಾರ್ಮಿಕರಿಗೆ ತುಟ್ಟಿ ಭತ್ಯೆ ಕೊಡತಕ್ಕದ್ದು. ಒಂದು ದಿನಕ್ಕೆ 3 ಪೈಸಾ.
ಇದ್ರಲ್ಲಿ ಎಷ್ಟಾಯ್ತು?
This includes the dearness allowance. Whatever they have written in this table included the dearness allowance.
Page 44 ಅಲ್ಲಿ ಸೇಲ್ಸ್ಮನ್ ಗೆ ಸೇಲ್ಸ್ ಏನು ಅಂತಿದೆ ಅದನ್ನ ನಾನು ಕ್ಲೈಮ್ ಮಾಡಿದ್ರು, ಬೇರೆ ಏನು ನಾನು ಕ್ಲೈಮ್ ಮಾಡಿಲ್ಲ.
Kindly see sales 1
ಕ್ಲೈಮ್ ಮಾಡಿಲ್ಲ,
ನಾನು ಸಪರೇಟ್ ಆಗಿ ಕ್ಲೈಮ್ ಮಾಡಿಲ್ಲ, ಅಲ್ಲಿ ಹಾಕಿದ್ದೀನಿ ಅಷ್ಟೇ. ಇದ್ರಲ್ಲಿ ಅಮೌಂಟ್ ನೋಡಿ ಪೇಜ್ 44 ಅಲ್ಲಿ
ನಿಮ್ ಪ್ರಕಾರ ಏನ್ ಕೊಟ್ಟಿಲ್ಲ ನಿಮ್ಗೆ?
ನನಗೆ ಫಿಕ್ಸೆಡ್ ಆಗಿದ್ದು 1265 ರೂಪಾಯಿ ಫಿಕ್ಸ್ ಆಗಿತ್ತು. ಅದ್ರ ಪ್ರಕಾರ ನನಗೆ ಕೊಟ್ಟಿರೋದು ನನ್ನ ಕಾಲಮ್ ಅಲ್ಲಿ ಇದೆ. 892 ರೂಪಾಯಿ ಬಿಗಿನಿಂಗ್ ಇಂದ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದಾದ್ಮೇಲೆ 999 ರೂಪಾಯಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದಾದ್ಮೇಲೆ ನೆಕ್ಸ್ಟ್ 1107 ರೂಪಾಯಿ ಕೊಟ್ಟಿದ್ದಾರೆ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ. ಮತ್ತೆ 1214 ರೂಪಾಯಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಡಿಫರೆನ್ಸ್ ಈಸ್ 664. ಆ ಕಾಲಂ ಪ್ರಕಾರ ನಾನು ಕ್ಲೈಮ್ ಮಾಡಿರೋದು, ನಾಟ್ ಮೋರ್ ದ್ಯಾನ್ ದಟ್. ಸೇಲ್ಸ್ ಮ್ಯಾನ್ ಅಂತ ಒಪ್ಕೊಂಡ ತಕ್ಷಣ ಐ ಆಮ್ ಎಂಟೈಟಲ್ಡ್ ಫಾರ್ ದಿಸ್ ಸ್ಯಾಲರಿ, ದಿಸ್ ವೇಜಸ್.
Will not may kindly take page 17 impugned order.
ವಿಡಿಎ ಕೇಳ್ತಾರೆ, ಬೇಸಿಕ್ ಕೇಳಿದ್ರೆ ವಿಡಿಎ ಅಂತ ಹೇಳಿದೀರಾ?
ಅಲ್ಲ, ವೇರಿಯಬಲ್ ಡಿ ಅಂತ ಅದು ಹಾಕಿದೆ, ಬಟ್ ಟೋಟಲ್ ಕಮ್ಸ್ ಟು ಅಲ್ಲಿ ನೋಟಿಫಿಕೇಶನ್ ಇರೋದಕ್ಕೆ ಅಷ್ಟೇನೆ ಇರೋದು ಅಮೌಂಟ್.
They can't ask for the VDA separate.
Calculation is basic 2181, VDA 191, total 2372. What you have been paid is 1978, difference is 393. Only come if VDA 191 is taken into consideration.
Notification itself clearly says that ಈ page 44 ಅಲ್ಲಿ 1265 ಅಂತಿದೆ. ಎರಡು ಸೇರಿ
ಇರಬಹುದು
ಅಷ್ಟೇ.
ಅದು ನಿಮಗೆ
ನಾನು ಅದಕ್ಕಿಂತ ಜಾಸ್ತಿ ಕ್ಲೈಮ್ ಮಾಡಿಲ್ಲ.
That will come in page 58. First ಇರೋದು 482 ಇದೆ ಅಲ್ಲ?
ಅದು ಅರ್ಲಿಯರ್ ಪೀರಿಯಡ್.
Yes. Till
ಹೌದು
2003 482.50 ಇದೆ.
ಹೌದು.
ನಾವು ಅಲ್ಲಿ at page 41
ಹೌದು
it includes dearness allowance ಅಂತಿದೆ.
ಹೌದು ಸರಿನೇ, ಅದೆರಡು
ಅಲ್ಲ, ನೀವು 58 ಅಲ್ಲಿ ಬೇಸಿಕ್ ಪ್ಲಸ್ ವಿಡಿಎ ಕ್ಲೇಮ್ ಮಾಡಿದ್ದೀರಾ ಸ್ವಾಮಿ? ಪೇಜ್ 58 ನೋಡಿ.
ಹೌದು 58 ಅಲ್ಲಿ ಹಾಕಿದೆ. ಇದು ನಾನು ಹೇಳಿದ್ದು ಈಗ ಫೈನಲ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಅದು ಹಾಕಿರೋದು. ನಾನು
ಫೈನಲ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಈ ಪೇಜಸ್ ಎಲ್ಲ ಅಲ್ಲಿ ಫೈನಲ್ ಬರುತ್ತೆ.
ಹೌದು
482 ಪ್ಲಸ್ ವಿಡಿಯೋ 624 ಟೋಟಲ್
ಎರಡು ಸೇರಿ 892 ರೂಪಾಯಿ ಆಗಿದೆ ಅಷ್ಟೇ. ಎರಡು ಸೇರಿ ಮಿನಿಮಮ್ ವೇಜ್ ಅದಕ್ಕಿಂತ ಕಡಿಮೆ ಯಾವತ್ತೂ ಇರಲಿಲ್ಲ. ದಿನಕ್ಕೆ 15 ರೂಪಾಯಿ ಕಡಿಮೆ ಸೇಲ್ಸ್ ಮೆನ್ಗೆ ಇರಲ್ಲ.
ಆಯ್ತು, ಬಟ್ ನಿಮ್ಮ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಪ್ರಕಾರದಲ್ಲಿ 1107 ಹಾಕಿದ್ದೀರಾ 58 ಅಲ್ಲಿ, ಪೇಜ್ 58.
ಹೌದು ಸರ್, 1107 1494 ಇಂದ 95 ಗೆ. ಹೌದು ಸರ್.
ಅಂಡ್ ದಿಸ್ ಇನ್ಕ್ಲೂಡ್ಸ್ ವಿಡಿಯೋ 624.
ಹೌದು, ಸೇರಿನೇ ಎರಡು ಸೇರಿ 11,107 ರೂಪಾಯಿ.
ಬಟ್ ಇಲ್ಲಿ ಫಿಕ್ಸ್ ಮಾಡಿದ್ರೆ 482 ಮಾತ್ರ ಫಿಕ್ಸ್ ಮಾಡಿದ್ದಾರೆ, ವಿಡಿಯೋ ಇಲ್ಲ. ಇಟ್ ಇನ್ಕ್ಲೂಡ್ಸ್ ಡಿಯರ್ನೆಸ್ ಅಲವೆನ್ಸ್ ಅಂತಿದೆ.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಇದು ಅವ್ರು ಓದಿದ್ದು ಅರ್ಲಿಯರ್ ಪೀರಿಯಡ್ ಗೆ. ನಾನು ಹೇಳ್ತಾರೆ ಪೇಜ್ 44 ಅಲ್ಲಿ ತಗೊಂಡ್ರೆ 44 ಸ್ವಾಮಿ ಇದು.
44 ವುಡ್ ಬಿ ಯುವರ್ ಕರೆಸ್ಪಾಂಡಿಂಗ್.
ಹೌದು, ನೆಕ್ಸ್ಟ್ ಪೇಜ್ F1 ಅಲ್ಲಿ ಸೆಕೆಂಡ್ ಪೇಜ್ ಅದು ನೋಟಿಫಿಕೇಶನ್.
ಅದು ಕರೆಸ್ಪಾಂಡಿಂಗ್ ಪೇಜ್ 63.
ಅದು ಕರೆಸ್ಪಾಂಡಿಂಗ್ 63.
ಅದರಲ್ಲೂ ವಿಡಿಯೋ ಹಾಕಿದ್ದೀರಾ 191.
ಅದೆರಡು ಸೇರಿದ್ರು ಅಮೌಂಟ್ ಇಷ್ಟೇ ಬರುತ್ತೆ ಅಂತ ನಾನು ಅಷ್ಟೇ ಹೇಳ್ತಾರೆ, ಬೇರೆ ಏನಿಲ್ಲ.
2181 ಬರ್ಬೇಕಲ್ಲ, 2372 ಬರಕ್ಕಾಗಲ್ಲ.
ಅಲ್ಲ, 1267 ಪೇಜ್ 44 ಅಲ್ಲಿ ಸೆಕೆಂಡ್ ಕಾಲಮ್ ಸ್ವಾಮಿ. ಇಲ್ಲಿ ಸೇಲ್ಸ್ ಮೆನ್ ಅಂತಿದೆ ಗ್ರೂಪ್ 3 ನಲ್ಲಿ.
ಸರಿ,
ಅದ್ರಲ್ಲಿ ಎಷ್ಟಿದೆ ಅಂದ್ರೆ 1260 ಅದು 265 ರೂಪಾಯಿ.
Plus VDA 795 ಅಂತ ಹಾಕಿದ್ದೀರಾ.
ಪ್ಲಸ್ ವಿಡಿಯೋ ಬರಲ್ಲ ಅಷ್ಟೇನೆ.
Page 62 ನೋಡಿ. ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಸ್ವಲ್ಪ ನೀವು ಹೇಳೋದಕ್ಕೂ ಇಲ್ಲಿ ಬರ್ದಿರೋದಕ್ಕೂ ಸ್ವಲ್ಪ ಡಿಫ್ರೆನ್ಸ್ ಇದೆ.
52 sorry.
Page 62.
62 page ಇಲ್ಲ 59 ಲಾಸ್ಟ್.
Right, earlier 55 or 56 ಇತ್ತು. 14/2002 to 31/3/2003.
14/2002 to 31/3/2003.
Basic 1265.
ಅದು next column sir. Next notification. That is F2. F2 ನಲ್ಲಿ
ಯಾವ ಇಯರ್ ನೋಡ್ಬೇಕು ಹೇಳಿ.
ಇದು ನಾನು ಈಗ ತಮ್ಗೆ ತೋರಿಸ್ತಾ ಇರೋದು 2002-3. ಅದು F2 ನಿಂದ ಶುರು ಆಗುತ್ತೆ. ಪೇಜ್ 47.
ಪೇಜ್ ನಂಬರ್ ಸ್ವಲ್ಪ ಪ್ರಾಬ್ಲಮ್ ಇದೆ.
F2
14/2002 to 31/3/2003.
ಹೌದು. ಇದು F2 ನಲ್ಲಿ ಪೇಜ್ 47 ಇಂದ ನನ್ನ ಇದು ಪೇಜ್ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ.
F2 came into effect on 2003.
2181 ರೂಪಾಯಿ ಇದೆ. ಇಂಟರ್ನಲ್ ಪೇಜ್ 2 ಆ ನೋಟಿಫಿಕೇಶನ್
ಸ್ವಲ್ಪ ಪ್ರಾಬ್ಲಮ್ ಇದೆ ಮಿಸ್ಟರ್.
ನಾನು ಪೇಜ್ ಸೆಟ್ ಮಾಡ್ಕೊಡ್ತೀನಿ.
F2
ಹೌದು. F2 ನಲ್ಲಿ
on 5th February 2003.
ಹೌದು.
ಅದು 2181 ಆಯ್ತು.
ಹೌದು. ಆ 2181 ನಾನು ಇಲ್ಲಿ ಕ್ಲೈಮ್ ಮಾಡಿರೋದು.
2181 ನೀವು ಕ್ಲೇಮ್ ಮಾಡಿರೋದು 2003 ಇಂದ 14/2003. Plus VDA 84.60 ಅಂತ.
ಅದೇ DA ಬೇರೆ VDA ಬೇರೆ ಸರ್. VDA ಅಂದ್ರೆ ವೇರಿಯಬಲ್ DA.
ಸೊ VDA ಎಲ್ಲಿ ಪ್ರಾವಿಷನ್ ಎಲ್ಲಿದೆ ಅಂತ
DA ಇಲ್ಲ. DA ಇಲ್ಲ. VDA ಇದೆ.
VDA ಎಲ್ಲಿದೆ ಪ್ರಾವಿಷನ್ ಇದರಲ್ಲಿ ನೋಟಿಫಿಕೇಶನ್ ಅಲ್ಲಿ? ಅಷ್ಟೇ ನಮ್ಮ ಕ್ವಶನ್.
ಇಲ್ಲಿ ಮತ್ತೆ ಈ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್ ಸೂಚಿಸಿದ ದರ ಮತ್ತು ಇಂಟರ್ನಲ್ ಪೇಜ್ 3 ನಲ್ಲಿ ಸರ್.
ಯಾವ ನೋಟಿಫಿಕೇಶನ್ ನೀವು ನೋಡ್ತಾ ಇರೋದು?
ಸೆಕೆಂಡ್ ನೋಟಿಫಿಕೇಶನ್ F2.
Yes. Internal page 3.
ತುಟಿ ಮತ್ತೆ ಈ ಅಧಿಸೂಚನೆಯಲ್ಲಿ ಸೂಚಿಸಿರುವ ಕೆಳಗಡೆ ದರಗಳು ರಾಜ್ಯ ಸರ್ಕಾರಿ ಗ್ರಾಹಕರ ಸೂಚ್ಯಂಕೆ ಸೋನ್ಸೋ ತುಟಿ ಭತ್ಯೆ ದರಗಳನ್ನು ಒಳಗೊಂಡಿದೆ. ಡಿ ಅನ್ನು ಒಳಗೊಂಡಿದೆ ಅಂತ ತುಟಿ ಭತ್ಯೆ ಇದೆ. ರಾಜ್ಯ ಸರ್ಕಾರ ಆಧಾರದ ಮೇಲೆ ಗ್ರಾಹಕ ಮತ್ತು ಸೂಚ್ಯಂಕದ 2002 ನೌಕರ ದಿನವೊಂದಕ್ಕೆ 3 ಪೈಸೆಯಂತೆ ತುಟಿ ಭತ್ಯೆ ಕೊಡತಕ್ಕದ್ದು ವೇರಿಯಬಲ್ ಡಿ ಬೇಸ್ಡ್ ಆನ್ ದಿ ಪ್ರೈಸ್ ಇಂಡೆಕ್ಸ್. ಜೀವನ ನಿರ್ವಹಣಾ ಭತ್ಯದ ಲೆಕ್ಕಾಚಾರದ ಮತ್ತು ವರ್ಷಕ್ಕೊಮ್ಮೆ ಮಾಡಲಾಗುತ್ತದೆ. ಹಿಂದಿನ ಕ್ಯಾಲೆಂಡರ್ ವರ್ಷದ 2 ತಿಂಗಳಿಗೆ ಗ್ರಾಹಕರ ಬೆಲೆ ಸೂಚ್ಯಂಕಗಳ ಸರಾಸರಿ ಆಧಾರದ ಮೇಲೆ ಏಪ್ರಿಲ್ 1ನೇ ದಿನಾಂಕದಿಂದ ಪ್ರತಿ ವರ್ಷ ಲೆಕ್ಕಾಚಾರ ಮಾಡತಕ್ಕದ್ದು. ಗ್ರಾಹಕರ ಸೂಚ್ಯಂಕಗಳ ಸಂಖ್ಯೆಯ ವಾರ್ಷಿಕ ಸರಾಸರಿ ಆಧಾರದ ಮೇಲೆ ಹೆಚ್ಚುವರಿಯಾದ ಮತ್ತು ಕಡಿಮೆಯಾದ ಅವರೋಹಣ ಪ್ರಮಾಣವನ್ನು ಅದರ ಲೆಕ್ಕ ಹಾಕಬೇಕು. ಆದ್ರಿಂದ ಮೊದಲ ಲೆಕ್ಕಾಚಾರ ಗ್ರಾಹಕರ ಬೆಲೆ ಸೂಚ್ಯಂಕ 2002ರಿಂದ 2002 ಈ ಸರಾಸರಿ ಆಧಾರದ ಮೇಲೆ 2003 ಏಪ್ರಿಲ್ 1ನೇ ತಾರೀಕಿನಿಂದ ಜಾರಿಗೆ ಬರ್ತದೆ. ದಿನಗೂಲಿ ಗಳಿಕೆ ದರ ಸಂದರ್ಭದಲ್ಲಿ ಮಜೂರಿಯ ಕನಿಷ್ಠ ಇಲ್ಲ. ಇದ್ರಲ್ಲಿ ಏನಂದ್ರೆ ಈ ಪ್ರೈಸ್ ಇಂಡೆಕ್ಸ್ ಜಾಸ್ತಿ ಆಗ್ತಾ ಇತ್ತಾ ಪೈಸಾ 3 ಪೈಸಾ 1 ಪಾಯಿಂಟ್ಗೆ ಅಂತ ಆಗುತ್ತೆ. ಅದನ್ನ ನಾನು 120 ರೂಪಾಯಿ.
ಒಂದು ಕೆಲಸ ಮಾಡಿ, ನೀವಿಬ್ರು ಕೂತ್ಕೊಂಡು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ವರ್ಕೌಟ್ ಮಾಡಿ. ಇಟ್ಸ್ ಓನ್ಲಿ ಎ ಮ್ಯಾಟರ್ ಆಫ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್.
ಇದರಲ್ಲಿ ಇನ್ನೊಂದು ಸ್ವಾಮಿ
ಇಟ್ಸ್ ಓನ್ಲಿ ಎ ಮ್ಯಾಟರ್ ಆಫ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್. ದೇರ್ ಇಸ್ ನೋ ಡಿಸ್ಪ್ಯೂಟ್.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಇನ್ನೊಂದು
ದಿ ಇಶ್ಯೂ ಇಸ್ ನೀವ್ ಹೇಳ್ತಾರೆ DA ಇಲ್ಲ ಅಂತ. VDA ಗೆ 3 ಪೈಸೆ ಅಂತ ಇದೆ.
ಹೌದು,
per point.
Only if there was an increase in the pricing index. I have seen the RBI guideline. There was no increase in the pricing index. I will.
ಎಲ್ಲ ಹೋಗಕ್ಕಿಂತ ಮೊದಲು ಅಲ್ಲಿ ಇರೋದು 60,000 ರೂಪಾಯಿ. ಇದು ಸೆಕೆಂಡ್ ರೌಂಡ್ ಲಿಟಿಗೇಷನ್. ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಅವರು ಇದ್ರ ಮೇಲೆ ಎಷ್ಟು ಲಕ್ಷ ಖರ್ಚು ಮಾಡಿದ್ರೆ ನಂಗೆ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ. ಯಾಕಂದ್ರೆ ಅದ್ರಲ್ಲಿ ಏನು ವಯಾ ಮೀಡಿಯಾ ಮಾಡಿ ಕೊಟ್ರೆ ಆ ಕಡೆ ಏನು ಪೂರ್ತಿ ಎಲ್ಲ.
I have already paid 14,500 under that 62,000. They preferred an appeal again to get back 62,000. I didn't want to have it. That is the reason. Whatever the court ordered, I paid last time.
ಏನಿಲ್ಲ 2010 ಒಂದು
Make the calculation and close this. This is not
ಅಷ್ಟೇ.
right.
ಏನೋ ಒಂದಷ್ಟು ಮೇಬಿಗೆ ಅಮೌಂಟ್
ಯಾವ ಕೂತ್ಕೊಂತೀರಾ ಇಬ್ರುನು ಹೇಳಿ, ನಿಮ್ದು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡ್ಬಿಡಿ.
ಅವ್ರು ಯಾವತ್ತು ಹೇಳಿದ್ರೆ
Next week, next
Tuesday, both of you will sit. What
Please.
time? Where?
My lord, I will contact him. In the court only we will sit.
ಇಲ್ಲೇ ಕೋರ್ಟ್ ಅಲ್ಲೇ ಮಾತಾಡಿ.
Tuesday 4:30.
Please.
Get all your papers, sit across, close it. Thursday we'll have this.
ಇದರಲ್ಲಿ ಎಲ್ಲ ಆದ್ಮೇಲೆ ನಮ್ಮ ಪಾರ್ಟಿ ಮತ್ತೆ ಸಿಗ್ತಾನೋ ಇಲ್ಲ ಅಂತಾನೂ ಗೊತ್ತಿಲ್ಲ ನಮಗೆ.
Both the councils are directed to reconcile the accounts and make their submissions. Released on 23rd at 2:30 p.m. Swami, Lakshman Rao, Labor Court, Industrial Tribunal. 36th time.
Matter ಅಲ್ಲಿ petitioner ಅವರೇ ಇದ್ದಾರೆ ಅವರೇ
37 ಅಲ್ಲಿ Lakshman Rao ಇದ್ದಾರೆ. 36 ಅಲ್ಲಿ Lakshman Rao had appeared before the tribunal. 30. 36 Sri Lakshman Rao is directed to accept notice for the respondent. Counsel for the Lakshman Rao and Som Sundar, R. Som Sundar are directed to accept. Stop practicing. ಅವರು ಚೆಕ್ ಮಾಡ್ತಾರ ಕಾಸ್ ಲಿಸ್ಟ್ ಇಲ್ವಾ? Lakshman Rao and Som Sundar are directed to accept notice for the respondent. Relist on registry is directed to print their name as such. Relist on 14/3.
That gratuity, the lordship has been adjourning the case.
On Supreme Court ಅಲ್ಲಿ case pending ಇದೆ.
29th May. 37. Registry is also directed to print the name of Sri R. Som Sundar as that appearing for the petitioner. And AGA submits that the list in the present matter is drawing the attention of the Honorable Apex Court. Connect the above matter with so and so, relist on 29/5.
May it please this honorable court.
Mr. Kanakraj.
Yes, my lord, I am ready, my lord.
I am appearing for the workman, my lord, who had put in 14 years of service with the respondent. Somewhere, and actually he was originally appointed with the company called Tatra. And subsequently he was transferred to many of the sister organizations of Tatra. Somewhere down the line, he was redesignated as a senior stores assistant. And on that ground, the employer treated me not as a workman. And therefore, I filed a ID seeking the following relief, my lord. The learned trial judge, if your lordship kindly takes page 24 of the typeset.
Yes, please.
Para 4. Whether the first party workman proves that the second party management has illegally terminated him from service with effect from 4/7/2012 without there being any inquiry, and as such the same is perverse and bad in law. 2. Whether the first party workman proves that he is the workman as defined in section 2(5) of the IT Act. 3. Whether the second party management proves that the court has no jurisdiction to adjudicate the dispute and hence the claim petition is liable to be dismissed. Whether the first party applicant is entitled for the relief of reinstatement, back wages and other declaratory relief, and alternatively closer compensation and ex gratia compensation as prayed for in the petition. Your lordship appreciates that the first two things, my lord, are main relief, my lord. The fourth is actually the consequential relief actions. In issue 1, the learned trial judge
Issues have been held in the affirmative in your favor.
in my favor. Issue 2 is also in my favor.
Issue 1, issue 2 is in your favor, which was on Mr. Kanikraj has been held against him. Issue 4 It's been held partly in
But if your lordship looks at my prayer, page 15, my lord. Since the petitioner is a workman who was illegally terminated, the petitioner is entitled for reinstatement with back wages in the sister companies of the respondent actually. The original company in which I was appointed still continues. I had been transferred for about 4 or 5 times in between. And right from 2000 onwards, my lord, I have been denied the 20% bonus that all the workmen were entitled for, my lord. But somewhere in 2000, he treats me as you are a management person, you are a supervisory person, so you are not entitled for the annual increment.
That is now decided. They have not come on appeal. You are not.
They have not come
No, my
on.
lord, I have not challenged this award. I have complied with the orders of the Labour Code.
No, my lord, they have been complied with it in full, my lord.
After having answered issue number 1 and 2 in the affirmative, issue number 4, could it have been restricted only to section 25F?
That is right, my lord. I have complied with that. Here, he received, acknowledged having received that money also. At annexure F.
Yes.
So there is one more small.
Once issue number 1 and 2 has been held in the affirmative, Mr. Karnatka, issue number 4 could not have been restricted to 25F.
No, my lord. The issue is the factory was closed. All workmen closure compensation was paid. Only this workman was not paid closure compensation on the ground that he is not a workman. In terms of the contract of employment, notice pay was given, gratuity was given. He challenged that in the Labour Court. Labour Court said he is also a workman. The court has jurisdiction to adjudicate and ordered to pay closure compensation as paid to other employees. I have complied with that part. I have not challenged the award.
If your lordship, one more small point, Lord, if your lordship takes page 42 of my judgment.
Establishment is closed.
When did it close?
My lord, 4/7/2012. He was terminated consequent upon the closure, 4/7/2012. Award was passed on 27/1/2014. And closure compensation was ordered to be paid. I paid on 27/4. He acknowledges the same receipt of the closure compensation. Nothing remains in this matter.
Page 42, my lord. This is the award actually. The second party management is directed to pay closure compensation to the first party applicant on par with the amount paid to other workmen according to his entitlement. Lord, two things, my lord. Right from 2000 onwards, I had been denied bonus, my lord. When all the workmen got about 20% of the wages as bonus, I had not been given this money ostensibly on the ground. I am not a workman.
That was
and with their contention that he is of the supervisory capacity and all has been rejected by the court. So naturally, from 2000 onwards, whatever bonus that was denied to me for a period of my service records had been fairly impeccable.
How much amount have you paid, Mr. Karnatka?
94,000 rupees, my lord, for 24 years of service. And even the calculation is for them to establish what is the total compensation that was paid to the other workman. They have not given anything of that kind.
Same compensation has been paid.
That this denial of bonus to me is an unfair and discriminatory labor practice.
That has never been agitated. My lord, the issue of bonus is now being raised for the first time. It has never been agitated either before the Labour Court nor any petition filed for claim of bonus. This is the first time we are making such a claim.
No, my lord, it is wrong, my lord. I will.
There is no finding on that. There is no finding on that. Nor a issue is framed on that.
I mean, I have, my lord. My learned friend is factually incorrect, if I can respectfully say so. Your lordship will see page 47.
has raised it, but you have not sought for a prayer in that.
The issue has been framed.
The ID, my lord. In the ID, page 47.
Yes, you have raised that in.
No, Lord, I have, my lord.
Where
If
the-
your lordship sees the prayer, I have, my lord, most respectfully, page 49, my lord.
Prayer B is there, Mr. Kanakraj.
My lord,
Page
there was no,
49.
it was not agitated before the court. No evidence has been laid on that aspect. I would have addressed those issues.
Page
No issue was
49.
framed.
The issues framed, Mr. Murthy, do not cover bonus. Mr. Kanakraj is right in that. The issues framed are what you read out just now.
Just now.
Are only as regards.
Bonus, there is no issue framed.
Termination.
It is he has also framed the other issue, what relief parties are entitled for, and therefore I have made a prayer, I have made specific government.
Then we'll have to remand it for that particular purpose, Mr. Kanakraj.
My lord, establishment is closed. I know where the employer is.
Lord, one more relevant point is
That we don't know. That we can't help you with. But
one more relevant
which is, just one minute, just a minute. There's a pleading to that effect. There's a prayer to that effect.
Yes.
There's a prayer to that effect. In the award at para 2, there's a reference to that. Reference to the claim.
My lord,
Issue has not been framed.
my respectful submission is, if an issue was framed, that would have been addressed by the court. And moreover, under 10(4) application, all these issues cannot be agitated. It is not an industrial dispute under 10(1)(c), not a reference application. It's an application at 10(4)(a).
The individual right of the workman.
Individual right. So how bonus can be included in that? It is not an industrial dispute.
His contention is that he's been paid discriminatory bonus.
That is
Everybody
a
was
issue,
given
my lord.
20%.
My lord, I am not telling what is his right or incorrect. All my submission is, if that was a dispute, what he had, you raise a dispute under the 2AR and under Disputes Act. It's not a reference application. 10(4)(a) confines only to termination, retrenchment, and dismissal. This is application at 10(4)(a).
But once it has been raised here, it should have been rejected. Some finding should have been given by the
No
court.
issue has been framed, my lord. He did not seek an issue framed on that aspect. In fact, this is for the first time this issue has been raised in the sense that agitation has not been done on that. I have not laid evidence. There is no pleading from my part. No evidence has been laid by the other side.
Now
Only
you,
pleadings are there.
what is the salary wages that you have taken into calculation for closure compensation?
Gross salary 11,634.
Into 3 into?
Not into 3, my lord. 11,634 divided by 30 into 15 into 14. That comes to 96,000 rupees, 93,960, which I have paid. Earlier to that, gratuity of more or less an equal amount I have paid. 1,16,000 rupees has been paid earlier.
Then you haven't raised this now. When the issues were framed at that point of time.
Doctor, may I state this? This is an ID. The kind of so-called why the issue has not been framed, why no, it is the duty of the management, my lord, I most respectfully state that. And if your lordship sees this, I have, at the time of the wrongful termination, I had 10 years of service left.
The closure has happened of the gate. It's not your termination. Everybody is service.
When all are paid, all others, my lord, were paid. Usually, if there is a closure compensation, if the company had been doing fairly well, my lord, for every year of completed service, at least about 2 months wage. That is what all the public sector undertakings give.
As per the act,
yes,
it is whatever the last drawn salary, 15 days of it.
15. But I just
into number of years.
He had given me the closure compensation. They proceed on the footing. I am not a workman. I am a supervisory person.
Almost you may be entitled.
Therefore,
It is considered as a workman only, my lord.
But for the declaration.
Only then we are not able to understand your submission for a simple reason that everything has been ordered in your favor.
Yes, Lord.
Only issue that has not been considered is as regards the bonus.
Yes.
Which you did not agitate before the labor court.
I have, my lord, in the evidence also I have stated, my lord. In the evidence affidavit also I have stated, my lord.
There is no evidence, my lord.
No, there is, my lord. Evidence affidavit is there, my lord.
Have you produced anything to show that someone else has got 20% and you got 8.33%?
My lord, simple thing, my lord, I would have produced the bonus register itself. What is paid to the employees? It was agitated seriously. There was no evidence at all. Bonus.
No, my lord, it is wrong, my lord.
The way the matter has gone on, it looks like it was given up there and now.
If your lordship sees page 62, my lord, he says there is no evidence.
It is only a passing reference, my lord.
No, there is no passing reference. Please don't read my pleading, sir. I will read my pleading, my lord. This is evidence.
Now that containing is discriminatory, have you produced any document for this 20% bonus?
But page 62, para 3, my lord.
That's your avament.
It's
Now,
this is a evidence affidavit, my lord.
Yes,
Repetition of the same thing.
Just a moment, Mr. Karnataka.
I'm sorry, my lord. I'm sorry.
Going back and forth, ping pong like this.
I'm sorry, my lord.
What is the evidence that you have produced to establish that somebody else got 20%? Have you produced some document?
I have not produced any. This is the fact which is exclusively within the control of the management. It is for them to lead evidence. I will not be able to, in fact, by the contract of employment, we are even prohibited from discussing our compensatory package with other people. Although I produce evidence, I am a workman, I am not even in a supervisory cadre, my lord. Isn't it unreasonable, my lord? I can only make a statement. Under the Evidence Act, the person who exercises control over the fact has to prove the fact.
Mr. Karnataka,
Please, my lord.
can you produce the bonus register?
My lord, I do not know, my lord, because establishment is 2012.
And for this bonus aspect, we'll have to remand. The rest we'll have to approve.
Bonus aspect cannot be done under 10(4)A, my lord. You should raise an industrial dispute.
My lord, there is one more. I mean, at this point of time, my lord, it is a. I am not really.
We would have asked Mr. Karnataka to try and settle the matter, but he said he has no contact with his.
No, in fact, I tried my level best even at the time of the issue of the rule Nissi, my lord. I have not even been given cost, my lord, by the trial court judge, my lord. I've been fighting at that time of termination.
Try see if you can bring about some closure on this matter.
I'll explore the possibility, my lord, but I'm not sure whether I'll be able to. I'll succeed because I have to contact that employer.
Because this aspect has not been considered, even whether it is raised or not. We'll now that the tribunal has not.
I understand, my lord. To put a quietus whole thing, I'll find out, my lord. Secretly, I'll make an attempt and give me 2 weeks time. I'll come back to you, my lord.
Section 14 benefit if we give, then you'll have to restart the entire thing. So, you want to close it or should we give section 14 benefit?
I'll find out, my lord. I'll find out. Kindly give me 2 weeks time. I'll come back.
2 weeks will be too late, my lord. It is just it's a matter of amount, my lord.
It is not about 2 weeks to get the amount. It's 2 weeks to find the person that he has to speak to.
As your lordship,
would not have.
What is just reasonable and equitable in the circumstances? I don't want another round of litigation, my lord. I have not even been given cost, my lord, by the trial court.
Now before this.
The management takes a blatantly wrong contention.
But now all the labor lawyers are also reasonable and all the employment lawyers are also reasonable. So when he makes a submission that he will try and endeavor to do it, we believe Mr. Karnataka. Make his effort. Let's give him 2 weeks time to do that.
Please.
Give a specific date.
Every matter, after addressing arguments for some time, both the council seek for a short accommodation to explore the possibility of settlement insofar as bonus amounts are concerned. Rest will not survive. Relist on.
And also a reasonable cost of the proceedings, my lord. Because we really, most of these matters, I don't know, the cost, the advocate cost, I think, way
I
back.
have not come to the court.
In all these labor matters, my lord, we want some compensatory cost. We win the case, but we don't get a remedy. As I tell, the learned trial judge has empowered me, enabled me, not empowered me. I look for an empowerment relief.
14th March.
Please, my lord.
Much obliged.
Is appearing for the respondent now, madam. S.V. Prakash has entered appearance for respondent. Dilip Lakshmikant K. Unnati Law Chambers K. Narayana. Ready? Yes.
Lordship, this is a matter. The respondent, he was working as assistant lineman, Your Lordship, and he remained absent from duties from 10/6/1992. After that,
10/6/92.
1992. After that, Your Lordship, he did not appear only. So, Your Lordship, we have issued notice to him. Then after that also he did not turn up. So, Your Lordship, we initiated disciplinary proceedings against him, Your Lordship. So after that, we issued notice to his home address, Your Lordship. Then, in spite of that, also he didn't appear. So disciplinary authority directed KPTCL to issue notice in publication, like in Prajavani, Your Lordship. So in 15/4/1996, we issued the we published in Prajavani that we have produced in Exhibit M2, Your Lordship. After that, Your Lordship, in spite of that publication, he remained absent. So, disciplinary authority considered all the records and passed the order of dismissal on 16/8/1996. Now, Your Lordship, after the lapse of 13 years, respondent in 2009, they asked us, they prayed us to give the order copy, Your Lordship. And after this, in 2012, they approached Labour Code for conciliation. So then, government made reference to Labour Code on 18/4/2011.
Mr. Prakash, 13 years, you did not participate, you were absent for 3 years.
There's no notice to me. What Labour Code form? But I was not served with any notice at all. No, my lord.
You raised it after 13 years.
Pardon? No, my lord, not correct. It's not correct. Kindly see the order.
When did you raise the dispute?
My lord, I raised a dispute, my lord, in 2000 because Lord, the copy was served to me in 2010.
So were you,
the orders.
Were you working till 2000?
No, I am not saying. I was unaware. I have applied for
how many years?
It is not unauthorized absent.
For how many years were you unwell?
No, I have given my lord the leave application for leave.
When did you give your leave application? When did you report to work?
Lord, my evidence, your lordship, kindly I have produced the attendance, Lord, the registers, and Lord, what is shown, Lord, in the attendance register from Lord, documents, Lord.
Yeah. Either. Which exhibit do you want us to see? Exhibit number. According to them, 92 in the Bandeila. When did you?
It has come on record that on account of the direction issued by Commissioner for Public Information, they supplied me the order of dismissal. Till such time, I was not.
You want to know your attendance, Mr.
Attendance. Lord, I have. It is produced. M11.
11 hours.
No, they are there.
See how date to answer. M11. What is the date of your attendance?
That is from
If they have produced it, they would not have produced it in your favor.
No, anyway,
You have to
it
show.
is available on record to show that, they have mentioned this as L vintage, it is from 92.
M11.
Not Mason. It's not Mason. And preparation is not. I have it next
ಎರಡೇ
week.
ಪಾಯಿಂಟ್ ನೀವು ತೋರಿಸ್ಬೇಕು.
Lord, I will.
You are present or you are prevented from
Yes.
being present.
Next week.
Because from 92
Yes, yes, I understand.
till 2011,
Yes, yes. Lord, delay aspect has been considered by the labor court. I was prevented because I was not heard at all. Lord, I understood, my Lord, what
what
explains.
is that document?
I do that.
From 92 to
Yes.
2011, what were you doing? After 20 years, you cannot come back and say that after Ajay presented, learned counsel for the respondent, Sri S.V. Prakash, learned counsel for respondent, seeks to understand a week's time to make a submission. Relist on 23rd.
Lordship, 23rd,
You're not there.
25th,
25th, you will have to argue with the wall.
27th.
7.
I appear for the respondent in this matter, Lordship. Kindly pass over the matter.
Pass over.
The respondent has been superannuated. The reinstatement case. And I will talk 2 weeks.
Counsel for the learned AGS submitted the respondent as the superannuated counsel. None appears for the respondent. Relist on 23. Interim order earlier granted is extended till next date. Mr. Basuraju, ಇಲ್ಲಿ ಅಲ್ಲಿ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರಾ ಶೇಖರ್? ಎಲ್ಲ ಸೆಟಲ್ಮೆಂಟ್ ಇದಾರಾ ಏನು? ಬಸವರಾಜು and DL Sanjeev pass over. Pass over. 43. Yes, Mr. Kasturi. It did reach in the forenoon session only.
Milord, this case, I filed
43. Yes.
requested for a time to examine my witness for 1 or 2 days' time. He was held up in the factory, he could not come. MW2 was to be cross-examined. I couldn't produce him, I requested time, the court refused time. Posted the matter for award. The same day, at 3 o'clock,
Not even for arguments. Refused the adjournment and posted for award.
posted arguments. And then, Milord, at 3 o'clock, I go and file an application to recall that order. And also say, the witness has come, 3 o'clock, he can be cross-examined. Witness is produced on the same day. The court says, I have reserved award, I can't take an application. Application is not maintainable.
Order sheet may have maintained by the.
Where is the order sheet?
Order sheet.
Order sheet. Have you produced the order sheet?
Yes, ma'am. Yeah, but
Annexure E. What is the date?
That is, Milord, on the 29th of August 2017, it was posted for a cross-examination of MW2.
Could you repeat the date, please?
page 97, madam.
97. 10th August. MW1 is absent.
MW1 absent, despite
The Lordship may kindly see page 80.
was ordered.
W1 to W16 were all marked cross-examined. No cross-examination ಅಂತ ಬರೆದಿದ್ದಾರೆ.
29, 8, 17.
83 ನಲ್ಲಿ Order sheet dated 16th August 2016. 500 rupees cost ಹಾಕಿದ್ದಾರೆ. Close case evidence ಅಪ್ಲೈ ಮಾಡಿದ್ದಾರೆ. Kindly see page number 84. That on 19/1/17, first party President's affidavit filed, examined, WMW1, chief deferred to 23/2. Now, on 55/4/17, MW1 absent for presence of fails. Handwriting ಗೊತ್ತಾಗ್ತಿಲ್ಲ.
The pays 500 rupees.
Last chance. On 28/8/17, your lordship will say page 88. MW1 is absent for several times. MW1 absent, appearing not and cross-examination. Hence, the evidence of MW1 is discarded. That is page 88, my lord. MW1 is discarded for not tendering for cross-examination of the inquiry office also, and arguments in DS ಅಂತ ಬರೆದಿದ್ದಾರೆ. For arguments on 29/8 next day. Then heard 29 arguments award so and so. Then on 6/9 award was passed. We made an application on the same day. That is, Millard, on 29/8/17 at page 98. is the same day.
Yes, Mr. Shankar, any serious objections?
Please to recall the order.
Postal resignation, my lord. Yeah, this was happened in the 2015.
There is an order.
ಇರಿಸಲ್ಲ.
15
lakhs or rupees.
ಮಾಡಿ ಕಳ್ಸೋಣ ಅಂತ.
ಇದರಲ್ಲಿ
there is an order by this court saying that he must deposit the money to be this matter posted. Adela Badi Swami, no, I am not on that. The matter can be disposed of.
It impose some cost.
Kindly see.
Was filed in the 2018, my lord. For 5 years, my lord, they are not made in efforts to remand the matter to the labor court. They keep quiet for all 5 years, my lord.
ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ ಬಿಡಿ ಅದು.
ಆಗಿದೆ ಸರ್. ಅರಸಡಿ ಸಿಕ್ಕಾಪಟ್ಟೆ ಲಿಸ್ಟ್ ಆಗಿದೆ.
ಹೌದಾ?
ನೋಡಿ ಸರ್, ಆರ್ಡರ್ ಶೀಟ್ ನೋಡಿ ಸಿಕ್ಕಾಪಟ್ಟೆ ಆಗಿದೆ. 14% was appeared. ಸಿಕ್ಕಾಪಟ್ಟೆ ಆಗಿದೆ. 14% ನಾನು ನೋಡ್ನಾರ್ದೆ ನಾನು ಇಸ್ಕೊಂಡಿದ್ದೆ.
What is the dispute, Mr.
Page 99, Nodi Swami. Page 99, my affidavit. Further, I submitted on 29/8/17. My counsel appeared and framed this convocation plus please to hence this application to recall the audit result. He had come to the court at 3 p.m. This is filed on the same day, 29th August. One day, next day itself it was filed. The affidavit.
In B also not paid, my lord. Only 50,000 has been paid, my lord, during the pendency of the.
If you,
Even though he has received
17B wages have not been paid is a submission made. If you pay entire 17B
resignation case, dismissal Allah. 17B wages doesn't come. He doesn't make an application. There is an order of this court by Justice Devadas. Unless he deposits the money in the court, this court, that 40-50 lakhs he has taken at the time of VRS. This cat cannot even be listed.
Resignation, my lord. OPM
This is a
scheme.
resignation. He has received money.
Receive the money, then what is the?
In the OPM scheme, my lord, and forced resignation. It's a forced resignation.
So deposit the money which you have received.
Forced resignation.
Forced resignation ದುಡ್ಡು ಇಟ್ಕೊಂಡು ಫೋರ್ಸ್ ಅಂತ ಹೇಳಕ್ ಆಗಲ್ವೇ? ದುಡ್ಡು ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ ವಾಪಸ್ಸು.
Order dated 29/7/3/19 of this court. 27/3/19.
Benefits of a forced resignation.
ನಾನು ಚೆಕ್ ಕೊಟ್ಬಿಡ್ತೀನಿ ಬಂದಾಗ ಇಟ್ಕೊಳ್ಳಿ ಅಂತ.
ಟೋಟಲ್ ಅಮೌಂಟ್ ತಗೊಂಡಿದ್ದು ಅವರು ನಾ ಬರೆದಿರ್ತೀವಿ ಪೇಪರ್ ಅಲ್ಲಿ.
You receive the money and if you think it is forced, then you should return back the money.
One aspect, my lord, ಒಂದು ಹೇಳ್ಬಿಟ್ಟು my lord, 28/8/2017, my lord, the evidence of management was discarded and
Next day argument heard and award passed.
29/8/2017, my lord, heard the arguments and posted for award on 6/9/2017.
Same day application was filed.
No. On 6/9/2017, my lord, the matter is posted, but no action taken from 28/8/2017 to 6/9/2017.
28/8 ಗೆ application ಹಾಕಿದೀವಿ ಅಂತ.
ಇಲ್ಲ ಇಲ್ಲಿ ನೋಡಿ.
The application 29/8 annexure F page 98.
ಇಲ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್ ನಲ್ಲಿ 6/9, my lord. Order sheet disclose that, my lord, application ನೋಡಿಲ್ಲ ಅವ್ರು ಏನ್ ಮಾಡಿದ್ದಾರೆ. But order sheet speaks, my lord, on 6/9/2017, when the presiding officer about to pass the award, my lord, on that day, my lord, they filed an application. No action taken from 28/8/2017 to 6/9/2017. In between, they aware that, my lord, that was reserved for award. Order sheet, my lord, no action has been taken.
We will impose costs, we'll remind it with a time bound manner. Affidavit ಇವಾಗ ಹೆಂಗೂ ಇದೆ ನಿಮ್ದು cross examination, they'll keep the witness present on the next day.
Settlement ಏನಾದ್ರು ಮಾಡ್ತಾರೆ.
Any settlement possible, Mr. Kasturi? Instead of remanding and again.
19 lakhs he has taken from the company at the time of retirement for VRS.
ಇವಾಗ ಎಷ್ಟು ಬೇಕು ನಿಮ್ಗೆ?
ಇಲ್ಲಿ 50,000 rupees ಸಾಹೇಬರು ಕೊಟ್ಟಿದ್ರು. ಅವ್ರಿಗೆ ಏನೋ ಹುಷಾರಿಲ್ಲ, ನನ್ನ ಮೈ ಹಾರ್ಟ್ ಈಸ್ ಏಕಿಂಗ್ ಅಂತ ಹೇಳಿ.
ಎಷ್ಟು ನಿಮ್ಮ ಅಮೌಂಟ್ ಹೇಳಿದ್ರೆ ಕಸ್ತೂರಿ ಅವರು
suggest one thing, Lord. Your lordship may impose some cost, remand the matter, because the court says it has no power to recall. Supreme Court says the judgment I passed on to your lordship.
Yes, Mr. Kasturi. ಅದು ಬೇಡ, ಅದೆಲ್ಲ ಬೇಡ.
Now his age is 63 years, my lord. He attended the superannuation 3 years back.
My instructing counsel says 3 ಗಂಟೆ ಕರ್ಕೊಂಡು ಹೋಗಂತೆ.
Without 32
ಅಮೌಂಟ್ ಏನಾದ್ರು ಹೇಳಿ.
ಸ್ಯಾಲರಿ ಅಲ್ಲಿಂದ ಇಲ್ಲಿ ಕೊಡ್ಬೇಕಾಗುತ್ತೆ up to the age of superannuation.
ಅಮೌಂಟ್ ಹೇಳಿ ನಿಮ್ದು ನೀವು ರೀಸನಬಲ್ ಆಗಿದ್ದೀರಾ ಅಂತ ನೀವು ಅಮೌಂಟ್ ಕೇಳಿದಾಗಲೇ ನಮ್ಗೆ ಗೊತ್ತಾಗಿದೆ. ಹಿಂಗೆಲ್ಲ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಅಂದ್ರೆ ನಮ್ಗೆ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಕ್ ಬರಲ್ಲ ಇನ್ ಅವರ್ ಮೈಂಡ್. ಇಫ್ ಯು ಗಿವ್ ಅಸ್ ದಿ ಅಮೌಂಟ್, ಇಫ್ ಯು ಆರ್ ನಾಟ್ ರೀಸನಬಲ್,
50 ಲಕ್ಷ ರೂಪಾಯಿ
ಆಯ್ತು ಬಿಡಿ, ಆಗಲ್ಲ.
ಅವರು ಈಸ್ earlier he promotion as an officer, he was a union leader. Now he doesn't want this to.
Court seeking for the following relief. The grievance of the petitioner is that though the petitioner had led the evidence of his witness, due to certain unfortunate circumstances, the witness could not be present for cross-examination, and the matter was thereafter posted for arguments when an application, arguments and immediately posted for award. At that point of time, the petitioner had made an application for recalling the order and permitting the, by keeping the witness present for cross-examination, which came to be rejected by the Labour Court on the ground that it did not have the power to recall the order once the matter was posted for an award, posted for pronouncement of an award. Shri K. Kasturi, like senior counsel, submit that the valuable right of the petitioner has been lost. The tribunal ought to have, Labour Court ought to have taken into consideration the fact that the witness was kept present for cross-examination. And if cross-examination had been conducted, the matter could have been argued and an award passed on merits rather than depriving the petitioner of his evidence being on record by rejecting the affidavit in lieu of evidence filed. More so when on an earlier occasion, it is the respondent who had sought for time to cross-examine the petitioner's witness. Shri L. Shekhar, learned counsel for the respondent, would submit that enough and more opportunities had been granted to the respondent to keep their witness present, to the petitioner to keep their witness present. And it's only as a last alternative that the Labour Court has taken the cross-examination, has rejected the prayer for adjournment and posted the matter for arguments. Correct. Heard so and so. Having perused the order sheet, I am of the considered opinion that the adjournments which have been sought for are both by the petitioner and the respondent. And both of them have been imposed costs by the Labour Court at one for not having kept their witness present and or kept MW1 present and or for cross-examining MW1, whose evidence was finally rejected. In that view of the matter, I am of the considered opinion that the employer is required to be provided an opportunity to keep its witness present for cross-examination by the workman. The submission of Shri K. Kasturi, learned counsel for the petitioner, is that the witness shall be kept present on
3 PM ಆಗುತ್ತೆ 3 ಗಂಟೆಗೆ ಆಗುತ್ತೆ ತಗೊಂಡಿದ್ವಿ.
ಅಲ್ಲ ಇವತ್ತು ಯಾವ ಪ್ರೆಸೆಂಟ್ ಇಡ್ತೀರ ಅವ್ರನ್ನ?
ಅವನಿಗೆ ಬೇರೆ ಕಂಪನಿಗೆ ಹೋಗಿದ್ದಾನೆ. I had summon him.
That is your problem.
Headache. It's all right. But anyway, give us some time. ಒಂದು ಟೈಮ್ ಕೊಡಿ ಸ್ವಾಮಿ. ನಾನು ಕರೆಸ್ತೀನಿ ಅವರಿಗೆ.
ನಿಮ್ಮ ಕೇಳಿ ಫಿಕ್ಸ್ ಮಾಡ್ಬೇಕಾ ನಾವೇ ಫಿಕ್ಸ್ ಮಾಡೋಣ ಅಂತ?
ನೀವು ಫಿಕ್ಸ್ ಮಾಡಬೇಡಿ. ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಮೇ ರಿಮೈಂಡ್ ದ ಮ್ಯಾಟರ್. ಲೆಟ್ ದ ಕೋರ್ಟ್ ಫಿಕ್ಸ್ ಇಟ್.
ಹಂಗ ಮಾಡಲ್ಲ.
ಒಳಗಡೆ ಅದಕ್ಕೆ ಒಳಗಡೆ ಕರ್ಕೊಂಡು ಬರ್ತೀನಿ.
We won't leave that open. Shall keep him present on 21st March.
Very well.
21st March for the purpose of cross-examination by the counsel for the workman, and further shall keep him present without seeking for any adjournment for further cross-examination if cross-examination is not completed on 21st March. It is made clear that
he has resigned from service to the company, joined some other company. I had to call him back.
That is your problem, Mr. Kasturi.
Very well, bro.
We won't get it.
Yeah, your lordship sees what happens. It is not normal.
This is how much we can do now. You have to clap through the other angle. Get it? Because Mr. Shekhar is also saying that he will cross-examine him on 20. Submission of Shri L. Shekhar, learned counsel for the workman, that he would cross-examine MW1 on 21/3/2023 is placed on record.
The award has to be quashed.
The order is passed in the presence of both the parties to be present before the Labour Court on 21st March 2023.
The award has to be quashed.
Yeah, we are doing that. Above the petition is allowed, the award dated 6/9/2017 and the order dated 28 February 2018 in reference number 24 of 2016 by the third additional reference 24 of 2015 and MA 4 of 2017 by third additional Labour Court Bangalore is hereby quashed. They
5 years in the pending ಇದೆ ಸರ್.
Last ಎಷ್ಟು?
1 ಲಕ್ಷ ಕೊಡಿಸಿ ಸರ್.
Kasturi, you have appeared for, it has to do justice to your appearance.
Some silent issue I can say it will help Mr. Shekhar.
ಕೊಡಿಸಿ ಯಾಕಂದ್ರೆ 5 ವರ್ಷದಿಂದ take any steps ಮೇಲೆ.
ಅದು ಮಾಡಿ ಸ್ವಾಮಿ. ನೀವು ಈ ಅಸೋಸಿಯೇಷನ್ ಕಳಿಸಬೇಡಿ. ಅವರಿಗಾದ್ರು ಬರಲಿ ಪಾಪ.
This cost should be for the workmen. This is not for the association.
Very well.
Association bari 500,000 ರೂಪಾಯಿ ಅಲ್ಲಿ 50,000 rupees.
No fault of mine. No fault of 25 ಮಾಡಿ ಸ್ವಾಮಿ.
No fault of mine. He has already issued 50,000 rupees from me after taking 19 lakhs.
Mr. Kasturi, ನಿಮ್ಮ ಮರ್ಯಾದೆ ಉಳಿಸ್ಬೇಕು ನಾವು.
ಅಯ್ಯಯ್ಯ ಬೇಡತ್ ನಮ್ಮ ಲೇಬರ್ ಅಪೀಲ್ ಆದ್ಮೇಲೆ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಮರ್ಯಾದೆಲ್ಲ ಹೋಗಿದೆ ಈಗ. Kindly have some consideration.
3 months or 6 months.
The labor court shall dispose the matter.
6 months.
Only one witness, Mr. Kasturi?
ಅಷ್ಟೇ ಬೇರೆ ಏನಿಲ್ಲ.
Submission of Shri K. Kasturi that MW1 is the only witness of judgment is placed on record. The labor court is directed to dispose of the matter within a period of 4 months from 21/3/2023.
ಕಾಸ್ಟ್ ಸ್ವಲ್ಪ
ಇರ್ಲಿ ನೀವು ಹೇಳ್ಕೊಡ್ತಿದ್ದಲ್ಲ. Paid to the working.
Password matter. Serial number.
Yes, ನೀವು ಬರ್ತೀರಾ ಅಂತ ಅದಕ್ಕೆ ಅವ್ರು ಸ್ಟೇ ಕೇಳಿದ್ದಾರೆ ಅದು.
Amendment ಬೇರೆ he has to file an amendment application.
Amendment ಆಯ್ತಲ್ಲ?
ಆಗಿಲ್ಲ.
ಆಗಿಲ್ವಾ?
ಆಗಿಲ್ಲ.
I had thought stay for 2 orders.
Yes, you had to amend. ಬೇಡ ಅಂತ ಬೇಕಾ amendment?
Amendment.
Counsel for the petitioner seeks for and is granted 3 days time. You have to first, we can't do that. Last time also we told you that. 3 days time to file amendment application, we list on 23rd February.
List number 2 in serial number 8, Mala. After next week, Mala, serial number 8, list number 2, Mala.
I am for the petitioner. Illappa, Harish Bandari.
List number 2.
Number 2, serial number 8. I'm for respondent.
Harish Bandari.
ಯಾವ ಲಿಸ್ಟ್ ನೋಡ್ತಾ ಇದೀರಮ್ಮ?
List number 2, I'm also.
Number 2, Harish Bandari and SB Mukkanappa.
Harish Bandari, yes.
At the request of the counsel for the respondent, list on 21/3.
Passed over matter, my lord. 21.
What about it, Mr. Kankar?
My lord, it was passed over for the absence of the counsel for the other side.
Ready na?
TCR ಅಂತ ಕೇಳಿದ್ರು, TCR awaiting ತೋರಿಸ್ತಾ ಇದೆ call list ಅಲ್ಲಿ.
TCR kept below, awaiting TCR. Ministry is directed to secure the trial court records at the earliest. Relist on 17/3.
Please.
Number 3. Number 3, 2:30 ಗೆ ಮಾಡಕ್ಕಾಗಲ್ಲ. By 3:30 may not I'll mention. ಎರಡು ಮ್ಯಾಟ್ರ್ ಇವಾಗ ಶುರು ಮಾಡ್ಕೊಂಡಿದ್ವಿ. ಎರಡು ಮ್ಯಾಟ್ರ್
3:30 the court will raise today.
ಅಷ್ಟೊತ್ತಿಗೆ ಬಂದು ಹೇಳ್ತೀವಿ. ಲಂಚ್ 10 ನಿಮಿಷ. We will sit, my lord.
ಸರಿಯಾಗಿ ಲಂಚ್ ಮಾಡಿ.
My lord, serial number 3, my lords, have taken instructions.
3 of
first list, my lords. Where bank account is attached, my lords. Have taken instructions. They have filed an application for waiver with the appeal, my lords. I'll deposit 5 lakhs. 14 lakhs is the outstanding.
Come back. This is not a matter to be mentioned.
Much.
Madam. Serial number 64 ಗೆ judgment ಫೈಲ್ ಹಾಕೊಂಡ್ಬಿಡಿ. 64 ಫೈಲ್ ಅಲ್ಲಿ ಇದ್ಬಿಡಿ. ಇದು ಅದರ್ ಸೈಡ್ ಕೇಳಿರಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಕೋರ್ಟ್ ಕಾಪಿ ಅದರ್ ಸೈಡ್ ಕೋರ್ಟ್ ಕಾಪಿ. ಗೊತ್ತಾಯ್ತು ಇದು ಬಿಡ್ಲಿ ಅಂತ, ಯಾಕಂದ್ರೆ ಅದು ಇದ್ರಾಗ ಮಾಡ್ತಾರಂತೆ ವಿಸಿ ನಲ್ಲಿ. ಪ್ಲೀಸ್
ಸುಧಾಕರ್. ಅಂತ
ಬೋಟ್ಲಿ 0 ಏನ್ ಡೇಟ್ ಕಿಟ್ ತಗೊಂಡ್ಬಿಟ್ಟವ್ರ ಎಲ್ಲ.
ಸರಿ.
Nim chamber. Huh? Oh, you temple, huh?
Past over matters ಕರೀತೀರಾ ಹೆಂಗೆ? Past over ಕರೀ. Oh, first you have division then.
Total, sir? Sir, ಧಾರವಾಡದ AJ MH ಪಾಟೀಲ್ ಅಂತ. MH ಪಾಟೀಲ್. MH ಪಾಟೀಲ್ AJ. Yes, sir. ಇಲ್ಲೇ sorry. 3949
3949
50
50
2880.
ಸಿಗ್ತಾರೆ.
Sorry, ಇಲ್ಲ ಸರ್ ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಅವರು ಮಾತಾಡ್ತಾರೆ ಮೇಡಮ್ ಅವರು ಅಲ್ಲಿ ವಿಷಯ ಒಳಗೆ ಬಿಜಿ ಇದ್ದಾರೆ ಮೇಡಮ್
ಹಲೋ ಮೇಡಮ್ ನಮಸ್ಕಾರ. ಹಲೋ ಸತ್ಯವತಿ ಯಾರು ಇಲ್ಲ, ಇಲ್ಲಿ ವಿದ್ಯಾವತಿ ಅಂತಿದ್ದಾರೆ ಮೇಡಮ್. ಹಾ ಇವರು ಇನ್ನೊಂದು ಕೋರ್ಟಲ್ಲಿ ಬಿಜಿ ಇದ್ದಾರೆ ಈಗ. ಕೋರ್ಟ್ ಅಂದ್ರೆ ವಿಸಿ ಒಳಗೆ ಮಾಡ್ತಾ ಇದ್ದೀವಿ ಮೇಡಮ್. ಇಲ್ಲಿ ವಿಸಿ ಇದೆ ಬೆಂಗಳೂರಲ್ಲಿ ಬೆಂಚ್, ವಿಡಿಯೋ ಕಾನ್ಫರೆನ್ಸ್ ಮಾಡ್ತಾ ಇದ್ವಿ. ವಿಡಿಯೋ ಹೌದು ಹೌದು ಅವರೇ ಬರ್ತಾರೆ ಮೇಡಮ್, ಬರ್ತಾರೆ ಈಗ ಬಂದು ಬನ್ನಿ. ಹಾ ಹೇಳಿ. ಫಾರ್ಮ್ ಕಮಿಟಿ ಮಾಡಿದೀವಿ ಅಂತ ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದೀವಿ ಮೇಡಮ್ ನಾವು.
Millards.
Really, Mr. Patel?
Millards, the committee has formed Millards. Last time I submitted Millards. Thereafter Millards. Thereafter Millards, just now I have received the message from the concerned official Millards. The committee has already worked out the direction issued by this honorable court Millards. I have received the intimation Millards. I will.
SOP ಯಾವ ಪ್ಲೇಸ್ ಮಾಡ್ತೀರಾ ನಮ್ಮ ಮುಂದೆ ಯಾವ ಪ್ಲೇಸ್ ಮಾಡ್ತೀರಾ
Beg your pardon, Millards.
When will you report compliance with all those directions?
We short Millards because of the session is going on Millards. Therefore, the officers are busy Millards.
ಆಯ್ತು, no problem. ಯಾವಾಗ ಮಾಡ್ತೀರಾ ಅಂತ
2 weeks time may kindly be granted.
Learned SCGP, learned AGA submits that the committee formed while order dated 9/12/2022 has met and is in the process of formulating the requirements as directed in the above matter. He seeks for and is granted 2 weeks time to report for list on 10/3. 10/3 at 2:30 p.m.
Beg your pardon for date Millards.
10/3 at 2:03.
Serial number 2, additional SPP.
In this also Millards, we are processing Millards. Because of the session, it is not possible Millards. Kindly have it after 2 weeks.
Mr. Patil, this is causing a lot of trouble.
From the concerned officers, they are also submitting same.
And AGA submits that the concerned officers are in the process of complying with the directions issued by this court. We seek for and is granted 2 weeks time to report further compliance. Released on 10/3 at 2:30 p.m. 10/3.
10/3. Okay.
Relax.
Here we have filed an IA for waiver of that pre-deposit. My lords, 14 lakhs is the amount, my lords. I'll deposit 5 lakhs. My lords.
Deposit or payment?
I'll pay them.
50%. ಅದೇ ಹೇಳಿದೆ ಗೊತ್ತಿಲ್ಲ ಅಂತ
5 lakhs. 5 lakhs it's
25% ಇಂದ 33 ಬಂದಿದ್ದಾರೆ. So these accepts notice for respondent. Passing for the petitioner and copy of the petition on the connection thereof. As I said, objection if any by 15 release on 24 of March. The operation of the order dated 18/1/2023 passed by respond bearing number so and so at annexure C. The state, the next date of hearing, subject to the petitioner making payment of sum of rupees 5 lakhs to the respondent within a period of
4 weeks.
4 weeks from today. That is on or before 17th March, failing which the interim order will stand automatically vacated.
Any other coercive measures, my lords? Because this
Indian coercive.
Because appeal is pending.
Subject to the outcome of appeal.
Amended cast type ಕೊಟ್ಟಿದ್ದೀವಿ. ವರ್ಕ್ಮನ್ ಸತ್ತೋಗಿದ್ದಾನೆ.
ಅಲ್ಲಿ ಏನೋ ಮೆಂಟ್ ಆಗತ್ತಾ ಏನು?
ಇಲ್ಲ ಅಲ್ಲಿ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಆಗ್ಬೇಕು ಸರ್. ಮೆನ್ಷನ್ ಮಾಡಿ ಏನೋ ಒಂದು ಮಾಡ್ಕೊಳ್ಳೋಣ ಅಂತ ಹೇಳಿದ್ವಿ.
ಬಂಡಾರಿ ಅವರಲ್ಲಿ
ಸ್ವಲ್ಪ ಹೊತ್ತು ನೋಡೋಣ ಸರ್. ಅಂದ್ರೆ
3:30 ಎದ್ದೊಳ್ಬೇಕು ಅದಕ್ಕೆ.
ಆಯ್ತು ಒಂದು 10 ಡೇಟ್
12 released on 24th.
Number 40.
ನಾವು ಮಾಡೇ ಇಲ್ಲ.
ಯಾಕೆ ಮಾಡ್ಲಿಲ್ಲ ಮಿಸ್ಟರ್ ನಾಯಕ್? ಊಟ
ಬೆಳಗ್ಗೆ 8 ಗಂಟೆಗೆ ಮಾಡ್ಕೊಂಡು ಬಂದ್ಬಿಟ್ಟಿದ್ದೀವಿ.
ನಿಮ್ ರೆಗ್ಯುಲರ್ ಪ್ರಾಕ್ಟೀಸ್ ಆಗಾದ್ರೆ ಇವತ್ತು ಮಾತ್ರ
supposed to be ದ್ವಾದಶಿ.
ಅದಕ್ಕೆ
ಅಲ್ಲ ಇದಾಗಿ ಹೇಳಿದೆ
40
ಅಲ್ಲಿ 40 ನಲ್ಲಿ ಇಲ್ಲ ಇದರಲ್ಲಿ ಚಾರ್ಜ್ ನಾಟ್ ಪ್ರೂವ್ಡ್ ಮೇಲೆ ವಾಟ್ ಈಸ್ ನಾಟ್ ವಿಲಿಂಗ್ ಫಾರ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಂತ ಕ್ಲಿಯರ್ ಆಗ್ಬೇಕು. ಯಾವತ್ತಾರು ಮಾಡಿ
14th March.
Accident.
Records.
Three incidents have been reference was rejected.
This Mr. ನಾನು ನಡೀತಾ ಇದೆಯಾ ಸೆಟಲ್ಮೆಂಟ್ ಟಾಕ್ಸ್ ನಡೀತಾ ಇದೆ. ಪಾಸ್ವರ್ ಆದ್ರೆ ರೀಚ್ ಆಗಲ್ಲ. on 14th March. 14th 2020. 14th March.
One relating to the seniority and
Service.
14th ಕೊಡೋದು.
16th March.
And the petitioner in this case, trial court records on North in Swami. Next week, I'll give the minor punishment.
So the counsel for the petitioner deal with on 3rd March.
Much.
The Srinivas. Mr. Kantraj. Counsel for the petitioner is present, none appears for this. Released on 17th March.
49.
These two matters, my lord, posted on the same day, because it's covered under the Supreme Court judgment, my lord, not 33C2. Lord, yeah. Yes, good. Lord, for certain.
What is the claim for?
I submit, man. Dismissed work employee filed a 33C2 application claiming wages on the ground that approval application not filed and the order of dismissal is non-est and void. The labor court consider our request and passed an order directing the corporation to pay the wages from the date of dismissal till the date of filing the application. The number of orders passed by the labor court has been questioned before the Honorable Court. The coordinate bench of the Honorable Court allowed the writ petition filed by the management, and I went up to the division bench and the matter is pending adjudication before the division. I want to argue the matter before your lordship, my lord.
33C2, is it applicable?
Yes, my lord.
It's as good as the recovery proceedings. Execution petition. So it is.
Why I am filing, my lord, your lordship aware that, my lord, two views were expressed by the Jaipur Jilla case.
And
yes, Jaipur Jilla, in Jaipur Jilla case, my lord, two judgments has been, three judge benches of two judgments have been considered, my lord. One is, my lord, Shah Board, and another one is Punjab Beverages case.
Mr. Anand and Subramanya argued it in detail before that. I think that judgment is being pronounced on Monday or Tuesday, but
There is one Supreme Court judgment.
Jaipur Jilla.
Supreme Court. 33C2, my lord, there should be, when you go before under 33C2, there should be a quantify some. It should be quantified by.
What is meant by quantified? What is meant by?
Yes, my lord. Yes.
Whether it is full adjudication or
yes, no.
On the mere calculation.
Labor court.
And a little beyond mere calculation is also permissible.
Computation is 33C. If amount is quantified, 33C1.
Award or settlement 33C1. For individual workmen 33C2.
Yes.
Where it is a methodology of calculation and
if the amount is quantified as 33C, amount is specified 1 lakh. They don't pay. Then I have two options. Take recovery certificate of 33C1 or prosecution. Usually we take recovery certificate 33C1 because the revenue authority will collect that money and give it to 33C1. But 33C1 absolutely no adjudication. 33C2 limited adjudication is permitted.
how much is a limited adjudication? That is what we have dealt with in that.
Computation.
In my case,
I think we will be pronouncing that.
In my case, my lord, adjudication is not necessary because, my lord, the very order of dismissal is non-est void, my lord. The five-judge bench held that, my lord, the moment not filed approval application deemed to be in service entitled for wages. That has not
asked for wages.
Yes, my lord, only wages, my lord. Calculate ಮಾಡ್ಕೊಡ್ಲಿ.
ಇದು ಬರಲ್ಲ ಅಂತ.
But also there is, he has to go under 31 and make a claim.
No.
It is an honest. There is a need to go to
There is a clear finding in Jaipur Jilla case. There is a clear finding.
ಮಂಡೇ ಆದ್ಮೇಲೆ ಮಾತಾಡ.
ಮಂಡೇ ಪ್ರೊನೌನ್ಸ್ಮೆಂಟ್ ಇದೆ.
ಟ್ಯೂಸ್ಡೇ ಆದ್ಮೇಲೆ ಮಾತಾಡ. ಏನ್ ಹೇಳಿದ್ರು ಸ್ವಲ್ಪ not be proper.
Can you give start account?
Released on 24th.
Yes.
Fifty appear for the petitioner, Your Lordship.
Ready, madam?
Yes, Your Lordship, I am ready with them.
Yes.
case of accident. 17/4/2009, my lord, caused an accident. And due to the said accident, my lord, a scooterist died.
What was the punishment?
My lord, basic pay reduced to minimum of 3 years. The minimum of 3 years. Thereafter, my lord, after delay of 4.5 years. Yes, 4.5 years delay. Approaching the court. Charges on scooters were totally nearly about 4,30,000 was awarded.
Domestic inquiry was not fair and proper.
Yes, not fair.
Have you challenged the award of the tribunal?
No, man.
MACT. MACT challenge.
They have challenged, we have paid 4,33,000. The scooter is still. We paid 4,33,000. Minimum of 3 years.
What is the reasoning of the?
Page 43, madam. Starts from 42, para 17. I'm sorry, it starts from 26, madam. 26 is the operation. 26, 15th paragraph. Madam. Read that page. Page 27. Madam. In the opposite, the lordships have clearly observed that the delay is not ground to dismiss that consider along with the merits, but it is to be considered along with merits because the present is ruled by the facts and circumstances clearly discloses that the negligence is not on the part of the first party, but it is negligence on the part of the motorcyclist who succumbs to it. And this being the case, first party cannot be held responsible for the act of negligence alleged against. The aspect is not.
Speaker is
Very has.
Idu mic.
The inquiry has considered the
physically ill attack ಮಾಡ್ತಾರೆ virtually madam ಅಲ್ಲಿಂದ attack ಮಾಡ್ತಾರೆ.
Rider of the motor is negligent, but circumstances disclose that the first party tried to avoid the accident by taking the bus towards the right side of the road. But in spite of that, there is an accident. Accident is accident one. This aspect is not considered by the inquiry officer and also disciplinary. They have punished the first party as solely responsible. Hence, the same is not seen.
First one tried to avoid the accident by taking the bus towards the right side of the road.
Sanju sir, I am not able to hear you, sir.
ಕೇಳಿಸ್ತಾ ಇಲ್ವಾ madam? Can you hear us now?
Mic is showing muted, Your Lordship.
The mic is not mute. Mic is on. ಕೇಳಿಸ್ತಾ ಇಲ್ವಾ?
ಮಹಿಳೆ ಇವರು ಕೊಟ್ಟು ಬಿಡ್ತೀನಿ ಇವರೇ ಇದ್ದಾರೆ.
We can't understand the statement, Mr. Naik, that first party tried to avoid the accident by taking the bus towards right side of the road. Left side of the road, ಬೇರೆ right side.
ಮುಂದ್ಗಡೆ ಇದಿದ್ರೆ ರೈಟ್ ಸೈಡ್ಗೆ ಹೋಗ್ಬೇಕಾಗುತ್ತೆ, ಅವಾಯ್ಡ್ ಮಾಡ್ಬೇಕಲ್ಲ.
Coming from the opposite side. Opposite side ಬಂದಾಗ ರೈಟ್ ಹೋದ್ರೆ ಹೆಂಗೆ ನೆಗ್ಲಿಜೆನ್ಸ್?
Go against it. ಕೆಚ್ಚೆಲ್ಲ ಇದೆ ನೋಡಿ, ಅದ್ರೊಳಗೆ ನಾನು ಹೋದೆ ಕೆಚ್ಚು ನೋಡಿ ಗೊತ್ತಾಗ್ಬೋದು. ಕೆಚ್ಚಿದೆ ಅದ್ರೊಳಗೆ. ಐದು ನೋಡಿತ್ತು ಒಂದ್ಸಲ.
ಬಂದಿಲ್ಲ.
ಕೆಚ್ಚೆಲ್ಲ ಇತ್ತು ಅದು ನೋಡಿ.
Records ಇಲ್ಲ. Registering director to secure the trial court records at the earliest released on 20th March. Right side does not make sense.
You cannot go on the, just like.
He has to go to the left to avoid, not to the right.
51, is there any, sir?
ಏನ್ ಮ್ಯಾಟರ್ ಮಿಸ್ಟರ್ ಶೇಖರ್ ಇದು? ಅಬ್ಸೆನ್ಸ್
ಇಲ್ಲ
ಈ ಪಿಲ್ಫ್ರೇಜ್ ನೆಕ್ಸ್ಟ್ ಲಿಸ್ಟ್ ತೆಗಿಬೇಕು ಇವಾಗ. ಅಬ್ಸೆನ್ಸ್ ಆಯ್ತು.
Think so, my lord. Oh, my lord, it should be done. Some yardstick. I believe in
ಒಂದು ಲಿಸ್ಟ್ ತೆಗೆದುಬಿಟ್ಟು
accident case and pilferage. I think
accident will come to last.
Yes.
ಇವಾಗ unauthorized absence ಆಯ್ತು.
Yes.
Now we will take up.
Pilferage.
I think now most of the unauthorized absence matters are over.
Oh, yes. Pilferage is there.
So pilferage will have to take up.
The NINC 2 tickets of ₹27.
ಅದೇ ಬೆಳಗ್ಗೆ ಶ್ರೀನಿವಾಸ್ ಹೇಳಿದ್ರು ₹13.50 excess cost from 1995 to 2023. The expenses must have itself been more than 1.5 to 2 lakh rupees.
Cost itself is going up.
We have to come up with better solutions than this. How many people will spend the time on this? How many man hours are wasted?
One case. But nothing.
This one if you can close, they will also be happy, and you take undertaking from them and close the list ಮಾಡಿ ಕೊಟ್ಟಿ ಅವ್ರಿಗೆಲ್ಲ
ನಾಯಕ್ ಅವರು ಮಾಡಿದ್ರು.
ಮಾಡ್ತಾರೆ ಇಲ್ಲ ಪಿಲ್ಫ್ರೇಜ್ ಮ್ಯಾಟರ್ಸ್. ನಾವು ಅನ್ಅಥರೈಸ್ ಮುಗೀತಲ್ಲ ಮಿಸ್ಟರ್ ನಾಯಕ್. Now next, if you can take up pilferage matters and those could be closed. Whether we are in this roster or not, next roster will phone ಮಾಡಬಹುದು. That pilferage 4 to 3 or 3 to 2 or something like that. ಅದು ಮಾಡ್ಬಿಟ್ಟು ಆಮೇಲೆ then last which will be remaining is accident matters. Unless there is a
Accident ಜೊತೆಗೆ ತಗೋಬಹುದು.
Accident case
ಒಂದೊಂದು ಮುಗಿಸಿ ಅಷ್ಟು ಅರ್ಜೆಂಟ್ ಮಾಡಕ್ ಹೋಗ್ಬೇಡಿ.
ಇದೇ ಜಾಸ್ತಿ ಇದೆ. Pilferages ಇಲ್ಲ.
ಬಹಳ ಇದೆ. ಇವಾಗ ಒಂದು 200 ಮ್ಯಾಟರ್ ಇತ್ತು.
ಹೌದು, ಈಗ most of them are closed.
Most of them are closed.
They also about 15 nearly settled.
Next pilferage ಲಿಸ್ಟ್ ಮಾಡಿದ್ರೆ ನಿಮ್ಮ ಆಫೀಸಲ್ಲಿ ಇಲ್ಲ ಫ್ರಮ್ ದ
ಯಾವ್ದಾದ್ರು ಸಾಟರ್ಡೆ ಕುತ್ಕೊಂಡ್ಬಿಡ್ಬೇಕು. ಸಾಟರ್ಡೆ ಕುತ್ಕೋಬೇಕು ಆಗೋಗುತ್ತೆ. ಈಗ ವರ್ಷ ಬೇರೆ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ ಎಲ್ಲ.
If you want us to keep one court hall open or 2 court halls open.
ಸಾಟರ್ಡೆ
ಹ್ಯಾಪನಿಂಗ್ ಮೇಲೆ ಇನ್ ಬಿಟ್ವೀನ್ ಬರ್ತಾ ಇದಾರೆ, ಮಾಡ್ಕೊಂಡು ಹೋಗ್ತಾ ಇದಾರೆ. ಈಗ ದಿನ ಆಗ್ತಾನೆ ಇದೆ. ಈಗ 20ನೇ ತಾರೀಕು
progress.
Early 20th, my lord has posted certain cases. All of them are settled.
ಹೌದು. Next pilferage ಲಿಸ್ಟ್ ಮಾಡಿ work out a modality.
Yes, we'll give the list.
Both of you ಅಂದ್ರೆ ನೀವು ಶೇಖರ್ ಬಸವರಾಜ್ ಅವ್ರದ್ದು ಆಗತ್ತ ಇಲ್ಲೋ ಗೊತ್ತಿಲ್ಲ. Most of his matters he may not have pilferage.
ಡಿಸಬಿಲಿಟಿ ಕಿಂಗ್ ಅವರು.
Disability.
ಅದು ಜಸ್ಟಿಸ್ ರಾಮಮೋಹನ್ ರೆಡ್ಡಿ ಅವರದಿತ್ತು. ನಿನ್ನೆ ಸೆಕೆಂಡ್ ಕೊಟ್ಟವರು. ಐ ಥಿಂಕ್ ಯು ಆರ್ ಎಕ್ಸ್ಪರ್ಟ್ ಇನ್ ದಿಸ್ ಟೈಪ್ ಆಫ್ ಮ್ಯಾಟರ್ಸ್ ಅಂತ ಅಲ್ಲೂ ಹೇಳ್ಬಿಟ್ಟಾರೆ.
Or disability only. So anyway, we are not looking at disability. Disability we have already covered in that.
Already
So
covered.
that judgment will apply to disability now and all those.
One issue only, that has to encourage.
Pilferage is madre, then there's a lot of issues.
All the newspaper, there is a, if the lawsuit judgment.
Disability.
ಎಲ್ಲಾದ್ರಲ್ಲೂ ಬಂದಿದೆ ನೆನ್ನೆ ಎಲ್ಲ ಬರ್ತಾ ಇದೆ ಅಲ್ಲ so that minority will not to everybody. That's the not that this particular case is it's not only in case of the other establishments also they do commit such mistakes.
A lot of things will happen. If we could,
We'll give the list
all of you can sit together and bring about a resolution.
Yes,
Why should this be pending for such a long?
years together.
Unnecessary.
Thing.
52, we just on 17th March. 54, 17th March. 55.
55, the LRs have to be brought on.
ಬಂದಿದೆ ಎಲ್ಲ ಬಂದಿದೆ ಎಲ್ಲ ಆಗಿದೆ
P2 and P are minus by P1 and Tagin.
ಕಮೆಂಟ್ಸ್
ಮಾಡ್ಬೋದು.
ಏನಿದು?
ಪಿಲ್ಪರೇಜ್ ಇಲ್ಲ
Petitioner.
ಅದು ನಮ್ ಕನ್ಫ್ಯೂಷನ್ ಇಲ್ಲ ಸತ್ಯ. Both of you could be on either side.
ಎಲ್ಲ
The court.
PCR ಬಂದಿದೆ ಸರ್
TCR ಬಂದಿದೆ. TCR ಬೇಕಾ? Pilferage
ಬಂದಿದೆ
ಬಂದಿದೆ.
ಬಂದಿದೆ charges are serious, my lord. Allegation against the workman that, my lord. Section B, article of charge. He failed to issue 2 tickets of rupees 1062, total 2124. This is the allegation made against the workman. He submitted reply as per Annexure C, page 35, madam. Second paragraph, page 35, Annexure C, second paragraph. ತನಿಖಾಧಿಕಾರಿ ನನ್ನ ಮೇಲೆ ಮಾಡಿರುವ ಆರೋಪ ನಾನು ಒಪ್ಪುವುದಿಲ್ಲ. ತನಿಖಾ ಸಮಯದಲ್ಲಿ ವಾಹನದಲ್ಲಿ 23 ಪ್ರಯಾಣಿಕರು ಮಾತ್ರ ಇದ್ದರು. ಟಿಕೆಟ್ಗಳು ಇದ್ದವು. ಅವರ ಪ್ರಕಾರ ವಾಹನದಲ್ಲಿ 25 ಪ್ರಯಾಣಿಕರು ಇದ್ದರು ಎಂಬುದು ಸತ್ಯಕ್ಕೆ ದೂರವಾದ ಆರೋಪ. ಔಟ್ ಆಫ್ 25 ಮೇಲೆ 2 ಅಂತ ಅವರು ಹೇಳಿದ್ದು. ಇವನು ನೋ at the time of check only 23 passengers ಅಂತ. ತನಿಖಾ ವೇಳೆಯಲ್ಲಿ ಯಾವುದೇ ನ್ಯೂನತೆ ಕಂಡುಬರದೇ ಇದ್ದಾಗ ತನಿಖಾಧಿಕಾರಿ ನನ್ನ ಬಳಿ ಮೊದಲೇ ವಶಪಡಿಸಿಕೊಂಡಿದ್ದ EBTM ನಿಂದ 1062 ಟಿಕೆಟ್ ಅನ್ನು ತೆಗೆದುಕೊಂಡು ನನ್ನ ಕ್ಯಾಶ್ ಬ್ಯಾಗ್ ನಿಂದ 1000 ರೂಪಾಯಿಯನ್ನು ತೆಗೆದುಕೊಂಡು ಖಾಲಿ ದಂಡದ ರಸೀದಿಗೆ ಮತ್ತು ಪ್ರಯಾಣಿಕರ ಹೇಳಿಕೆ ಪ್ರತಿಗಳ ಸಹಿ ಹಾಕಿಸಿಕೊಂಡು ಅಪರಾಧ ಜ್ಞಾಪನಾ ಪತ್ರವನ್ನು ತಯಾರು ಮಾಡಿಕೊಂಡು ನನ್ನ ಸಹಿ ಮಾಡುವಂತೆ ಕೇಳಿದೆ. ಸಹಿ ಮಾಡುವ ಮೊದಲು ಅಪರಾಧ ಜ್ಞಾಪನಾ ಪತ್ರ ಓದಿದಾಗ ತನಿಖಾಧಿಕಾರಿ ನನ್ನ ವಿರುದ್ಧ ಸುಳ್ಳು ಆರೋಪ ಮಾಡುವುದು ಕಂಡು ಬಂತು. ಆ ಬಗ್ಗೆ ನಾನು ತನಿಖಾಧಿಕಾರಿಗಳನ್ನು ನೀವು ನನ್ನ ವಿರುದ್ಧ ಸುಳ್ಳು ಆರೋಪ ಹೊರಿಸುತ್ತೀರಿ, ನಾನು ಸಹಿ ಮಾಡುವುದಿಲ್ಲ ಎಂದು ಸ್ಥಳದಲ್ಲಿಯೇ ಪ್ರತಿಭಟಿಸಿದೆ. ಆದ್ರೆ ಈಗಾಗಲೇ ನೀವು 2 ಫಾರಂನಲ್ಲಿ ಸಹಿ ಮಾಡಿರುತ್ತೀಯ EBTM ಟಿಕೆಟ್ ಅನ್ನು ಸಹ ತೆಗೆದುಕೊಂಡಿರುತ್ತೇವೆ. ಅಪರಾಧ ಜ್ಞಾಪನಾ ಪತ್ರಕ್ಕೆ ಸಹಿ ಮಾಡಿ ನಿರಾಕರಿಸಿದರೆ ಈ ಒಂದು ಆರೋಪವನ್ನು ಸೇರಿಸಿ ನಿನ್ನ ಕೆಲಸವನ್ನು ಕಳೆಯುವಂತೆ ವರದಿ ನೀಡುತ್ತೇವೆ ಎಂದು ಹೆದರಿಸಿದರು. ತನಿಖಾಧಿಕಾರಿ ಬೆದರಿಕೆ ಹೆದರಿ ನಾನು ಸಹಿ ಮಾಡಬೇಕಾಯಿತು ವಿನ ಅವರು ನನ್ನ ವಿರುದ್ಧ ಮಾಡಿರುವ ಆರೋಪವನ್ನು ಸಿಗುತ್ತೇನೆ ಎಂದು ಒಪ್ಪಿಕೊಂಡು ಸಹಿ ಮಾಡಿರುವುದಿಲ್ಲ. ತನಿಖಾಧಿಕಾರಿಗಳ ಪ್ರಕಾರ ನಾನು ಯಾವುದೇ ಆರೋಪಕ್ಕೆ ಅವಕಾಶ ಮಾಡಿಕೊಡದೆ ನಿಷ್ಠೆ ಹಾಗೂ ಪ್ರಾಮಾಣಿಕತೆಯಿಂದ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತೇನೆ. ಸಂಸ್ಥೆಯ ದ್ರೋಹ ಬಗೆದು ಸಂಸ್ಥೆ ಹಣವನ್ನು ದುರುಪಯೋಗಪಡಿಸಿಕೊಂಡಿಲ್ಲ. ತನಿಖಾಧಿಕಾರಿಗಳು ತಮ್ಮ ತನಿಖಾ ಪ್ರಗತಿಯನ್ನು ಮೇಲಧಿಕಾರಿಗಳನ್ನು ತೋರಿಸಿಕೊಂಡು ಸಾಬಾಸ್ಕಿರಿ ಪಡೆಯಲು ಉದ್ದೇಶದಿಂದ ಈ ರೀತಿಯಾದ ದಾಖಲೆಗಳನ್ನು ಸೃಷ್ಟಿಸಿಕೊಂಡು ನನ್ನ ವಿರುದ್ಧ ಸುಳ್ಳು ಆರೋಪ ಹೊರಿಸಿರುತ್ತಾರೆ. ಇದು ಅಂದು ನಡೆದ ಸತ್ಯ ಸಂಗತಿಯಾಗಿದ್ದು ಇದ್ದ ಸತ್ಯಾಂಶವನ್ನು ತಮ್ಮ ಮುಂದೆ ನಿವೇಶಿಸಿಕೊಳ್ಳುತ್ತಿದ್ದೇನೆ. ಆದ್ದರಿಂದ ತಾವು ದಯಮಾಡಿ ಎನ್ಕ್ವೈರಿ ವಾಸ್ ಇನಿಷಿಯೇಟೆಡ್ ಮೇಲೆ after conducting inquiry, my lord, after conducting phase of an inquiry, my lord, the respondent dismissed the petitioner from service by an order dated 22/1/2016, my lord. This order was subject matter in ID number 22/2017 before the third edition labor court, my lord. As the workman filed claim statement as per necessary. Respondent filed counter statement. Based on the pleadings, my lord, the learned presiding officer framed an issues. One of the issues is, my lord, validity of the inquiry, my lord. After hearing and considering the both oral and documentary evidence, my lord, The learned presiding officer answered the issue number 1 in negative, holding that inquiry conducting with respondent management was not fair and proper. Thereafter, my lord, the second party examined the reporting officer as per annexure G, my lord, page 67. They stated what they submit report, my lord, at 67 and 68. The cross examination at page 69, my lord. May I read cross examination? Yes. It is also suggest that when inspected the bus, only 23 passengers were boarded and the first party issued tickets to all the 23 passengers. I had not checked the cash bag of the first party to know about 2 tickets, each amount of rupees so and so was in possession of first party. It is possible that intentionally not checked the cash bag of the first party. Witness warrant that en route, there is no provision for checking cash bag. This is within the purview of outstanding red mark case. As per the general standing order, my lord, they required to check the ST revenue if the conductor involved in serious red mark case. Wherever the destination, my lord, they have to check the ST cash at the spot itself, my lord. That is the circular. General standing order, not only circular, general standing order. My lord, the
Usually they check the cash back, 1,000 rupees would have been less there.
Yes. No further inquiry is necessary. 1,062 rupees tickets not issued and not and collected money, my lord. And when they checked the ST revenue, my lord, the same amount is excess, my lord. There is no need for other further inquiry. There is the matter. Here, that's the reason, my lord, general standing order was issued. Here he said that, my lord, no, madilla, madam necessity illa, saying that, my lord. Further, my lord, for 7, the witness. So I saw the general standing order to the checking inspector. Witness identified general standing order number 166 dated 28/4/72. What do you, madam? General standing order. It is marked Exhibit W1. It is true to say that in case of serious misconduct, is to be checked the cash bag. Check the cash bag. They must, my lord. The general standing order, my lord, is admitted, my lord. There is any serious red mark case detected, my lord. At the interruption itself, my lord, he has to check the cash. It is true to suggest that passenger statement copy should be furnished to the first party at the time of checking. It is false to say that the copy of M3 passenger statement not furnished to the first party. There is no acknowledgement by the first party regarding receiving the copy of the exhibit M3 passenger statement. So as per their own circular, my lord, they have to furnish the copy of the passenger statement to the delinquent employee. But they state that my lord, no acknowledgement has been produced by the corporation. Nan bandilla anta. It is possible to say that not furnished the copy of passenger statement to the first party. The blue ink writing of exhibit M3 is of passenger. M3 may kindly be done. M3 in the, I think, statement. The blue ink in writing of exhibit M3 is of passenger. In fact, my lord, they have to obtain their particulars, my lord. Checking inspector has to return the particulars and simply obtain the signature of the passengers, my lord. Here he stated that, my lord, blue ink writing of exhibit M3 is of passenger. Yes. Red ink writing is of my handwriting. So, in fact, my lord, the practices are the rules of the corporation is that, my lord, he has to take the particulars and the statement from the passengers and he himself return the same.
ಎಲ್ಲ ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ 3:30 ಒಳಗೆ ಆಗಲ್ಲ. ಇನ್ನ ಅದು ಸೆಟಲ್ಮೆಂಟ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಇದಾವೆ.
ಸ್ವಲ್ಪ ಹತ್ರನೇ ಇರ್ಲಿ ಸರ್, ಬರ್ತಾನಿಲ್ಲ. ಎಕ್ಸಾಮಿನ್ ಮಾಡೇ ಮಾಡ್ಬೇಕು ಸರ್ ನೀವು. ಅದು ಎಂಕ್ವೈರಿ ಸ್ಟೇಟಸ್ ಆಗಿದೆ, ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಎವಿಡೆನ್ಸ್ ಕೊಟ್ಟಿದ್ದೀವಿ.
ಜನರಲ್ ಆರ್ಡರ್ ವ್ಯಾಲಿಡಿಟಿ ಎಲ್ಲ ಎಕ್ಸಾಮಿನ್ ಶಾರ್ಟ್ ಮ್ಯಾಟರ್ ಅಂತ ಹೇಳಿ ಎಲ್ಲ
ಇದು
ಸೆಟಲ್ಮೆಂಟ್
ಇದು ಆಬ್ಜೆಂಟ್ ಮ್ಯಾಟರ್ ಸರ್, ಸ್ವಲ್ಪ
ಅರ್ಜೆಂಟ್ ಮ್ಯಾಟರ್
ಆಬ್ಜೆಂಟ್ ಮ್ಯಾಟರ್
ಮತ್ತೆ ನೋಡಿ
ಅಬ್ಜೆಂಟ್ಮೆಂಟ್ ಮಾಡ್ತಾ ಇದೆ, ಸೆಟಲ್ಮೆಂಟ್ ಇದು ಅಲ್ಲಿ ಹೋಗ್ಲಿಲ್ಲ.
57 ಅಲ್ಲಿ ಮಾಡ್ತಾರೆ ಅಲ್ಲ ನೋಡಿ ಇವತ್ತು 57 relist on both the council submitted as a possibility of a settlement relist on 27th February.
Okay. And the caption of settlement ಬರ್ಲಿ ಸರ್ ನೋಡೋಣ.
The caption reporting sir. 8 the request of the council for the respondent relist on 7th March.
60 for the
9.
There are two issues.
Amit Deshpande. Shri Subramanian Bhatt is present. None of Amit Deshpande is not present. Convert to appear on the next day. Yes.
58, what happened, your lordship?
What's your senior's name? What's your senior's name?
Your lordship, what about 58, your lordship?
Third, 7.
Much obliged, lordship.
9. Mr. Subramanian Bhatt is ready to address his arguments. The passover is sought for by Mr. Amit Deshpande. Relist on 14th March.
for the respondent in this case, madam.
Service matter.
Labor matter.
Labor
It
matter.
was
SKSRTC into that.
well, it's labor arising from the award of the labor court.
But the classification is
Wrong it is. Labor.
Per case that is
issue.
issue, my lord, the
Non-issue of tickets.
tribunal held that my lord.
7-3
not
ಹೋಗಿತ್ತು
proved.
ಪೋಸ್ಟ್ ಮಾಡಿಸ್ಕೊಂಡಿದ್ದಾರೆ ಅದನ್ನ.
Relist on 7/3. And the original date 7. 61. Both the council submitted the possibility of a settlement being released on 7th at 2:30 PM under the caption reporting settlement.
ಅಲ್ಲ ಇದು ಇನ್ನು ನಾನು ನೋಡೇ ಇಲ್ಲ, ಮಾತಾಡಿಲ್ಲ.
ನೋಡಿ ನೋಡಕ್ಕೆ ಇನ್ನೂ ಒಂದು ವಾರದಲ್ಲಿ
ಆಯ್ತು.
ಯಾವ್ದೂನು by 28 they should unauthorized ಆದ್ರೆ ಒಂದು ಕೇಸ್ನು ಇಲ್ಲಿ ಕೊಡು.
ಅಯ್ಯೋ.
Next, we have told Mr. Sanjeev to start working on peripheral matters. List of peripheral matters ಮಾಡಿ ಭಂಡಾರಿ ಅವರು ಬಂದ್ರಲ್ಲ. ಪನಿಷ್ಮೆಂಟ್ 4ರಿಂದ 5ರಿಂದ 3, 3ರಿಂದ 2, 4ರಿಂದ 2.
ಒರಿಜಿನಲ್ ಡೇಟ್ ಇಸ್ 7/3, it is ಅಂತ ಬಂದಿದೆ. ನೋಡಾಯ್ತು.
Punishment will be there. It won't be that punishment won't be there. Punishment will be there and the undertaking will also be there.
Undertaking ತಗೊಂಡ್ರೆ ಅವ್ರಿಗೆ ಭಯ ಇರುತ್ತೆ.
Undertaking.
ನಾನು ಮೊದಲಿಂದ ಸಜೆಸ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ.
Affidavit notarized ಮಾಡಿ. Notarized.
ಫ್ರೂಟ್ ಹಾಕ್ಸ್ತೀವಿ ನಾವು. ಫ್ರೂಟ್ ಹಾಕಿದ್ರೆ ಅವ್ರಿಗೂ ಭಯ ಇರುತ್ತೆ, ನಾವು ಹೇಳ್ಬೋದು ಅವ್ರಿಗೆ.
If they violate the ಆಮೇಲೆ ಇನ್ನೇನು ಮತ್ತೆ violate ಮಾಡಿದ್ರೆ ಹೋಗಿ.
ಅದೇ ಕಂಟ್ರೋಲ್ ಇಟ್ಬೋದು.
One time measure. If they violate the undertaking.
ಅಂತದ್ ಕೇಸ್ನ ಇಲ್ಲೇ ಮಾಡ್ಬಿಡ್ಬೇಕು. ನಾವ್ ಇಲ್ಲೇ ಮಾತಾಡ್ತೀವಿ, ತಮ್ಗೆ ಹೇಳ್ಬಿಡ್ತೀವಿ, ಹಂಗೆ ಮಾಡ್ಬಿಡ್ತೀವಿ.
ಎಲ್ಲ ಇಲ್ಲ.
ಅಲ್ಲಿ ಬೇಡವೇ ಬೇಡ ಅಲ್ಲಿ. ಅಲ್ಲ ಸೆಟಲ್ಮೆಂಟ್ ಬೇಡ, ಜಾಯಿಂಟ್ ಮೆಮೋ ಮಿಸ್ ಇದು ಅವ್ರು ಸುಮ್ನೆ ಅವ್ರು ಇವಾಗ ಏನಾಗಿದೆ ಇವ್ರ ಕೇಸಲ್ಲಿ ಜೆನ್ಯೂನ್ ಕೇಸ್ ಸೆಟ್ಲ್ ಆಗೋ ಕೇಸು ಅಲ್ಲಿದ್ದಾರೆ ಲಾ ಆಫೀಸರ್. ದೆನ್ ಐ ಟುಕ್ ದ ಪೇಪರ್ಸ್ ಫ್ರಮ್ ಬಸವರಾಜ್. ಐ ಸೆಡ್ ಐ ಗಿವ್ ಒಪಿನಿಯನ್, ಅವ್ರು ಒಪ್ಕೋತಾರೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ದೆನ್ ಐ ಸ್ಪೋಕ್ ಟು ದ CLO. ನೀವು ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡದೇ ಇದ್ರು ಇದು ಮಾಡ್ಬೇಕು ಯಾಕೆ ಅಂತ ನಮ್ಮ ಒಪಿನಿಯನ್ ಕೊಡ್ತೀನಿ ಅಂತ. ಈ ಕೇಸಲ್ಲಿ ಶುದ್ಧ ಒಪಿನಿಯನ್ ಕೊಡೋಕೆ ನಮಗೂ ಟೈಮ್ ಆಗುತ್ತೆ. ಅದಕ್ಕೆ ತಾವು ಇಲ್ಲೇ ಹೇಳ್ಬಿಡ್ತೀವಿ.
ಎಲ್ಲಾದ್ರೂ ಒಪಿನಿಯನ್ ಬೇಕು.
ಅಲ್ಲಲ್ಲ ಇಲ್ಲ ಇಲ್ಲೇನ್ ಬೇಕಾಗಿಲ್ಲ, ನಾವು ಕ್ಲೋಸ್ ಮಾಡ್ತೀವಿ.
ಇಲ್ಲಿ ಬೇಕಾಗಿಲ್ಲ, ಇಲ್ಲಿ ಬರೀ ಆರ್ಗ್ಯುಮೆಂಟ್.
ಅಲ್ಲಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಲ್ಲ, ಅಲ್ಲಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಲ್ಲ. ನಾವು ಮುಂಚೆನೆ
ಇಲ್ಲೇ ಹೇಳ್ತೀವಿ ಶಾರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಮಾಡ್ಬಿಡು.
ಶಾರ್ಟ್ ನಾವು ಆಮೇಲೆ ಮೆಲೋಡ್ ನಮ್ಮ ಕಡೆಯಿಂದ ನಾವು ಅಪೀಲ್ ಹಾಕಲ್ಲ. ಇಬ್ರು
ಹೋಗಲ್ಲ
ಕೇಳ್ಕೋಬೇಕಲ್ಲ, ಬೇರೆ ಅಡ್ವೊಕೇಟ್ ಹತ್ರ ಹೋದ್ರೆ.
ನಾನು ಅಲ್ಲಲ್ಲ ನಾನು ಅಂಡರ್ಟೇಕ್ ಕೊಟ್ಬಿಡ್ತೀನಿ ನಾನು. ಐ ವಿಲ್ ನಾಟ್ ಫೈಲ್ ಎನಿ.
ಫೇಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಕಷ್ಟ ಆಗುತ್ತೆ.
It's always better that there's a joint memo.
ಬಟ್ ಅದು ಸ್ವಲ್ಪ ಕಷ್ಟ ಸಮಯ. ಬಟ್ ಮುಂದೆನೆ ಹೇಳ್ಬಿಡ್ತೀವಿ ಸಮಯ ಅದನ್ನ.
ಏನ್ ಕಷ್ಟ ಏನು?
ಇಲ್ಲ ಸ್ವಲ್ಪ ಅವ್ರಿಗೂ ಕಷ್ಟ, ನನ್ಗಂತೂ ಸ್ವಲ್ಪ
ನಿಮ್ಗ್ ಸುಲಭ ತಾನೆ.
ಅಲ್ಲಲ್ಲ ಅವ್ರು ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ವಾಟ್
ನಿಮ್ ಕಷ್ಟ ಏನ್ ಹೇಳಿ?
ಒಂದ್ಸತಿ ಕಲ್ತು ಮಾತಾಡ
ಅದು ಮಾಡ್ಬೋದು,
ಆಗತ್ತೆ.
ಅದು ಮಾಡೋಣ.
ಈ ಸತಿ
ಮೀಟಿಂಗ್
ಅಲ್ಲ, ಈ ಸತಿ ಎಂಡಿಂಗ್ ಕರೆದ್ಬಿಡಿ. ಹೇಳಂಗಿಲ್ಲ.
ಬಟ್
ವಾಲ್ಯೂಮ್ ರೇಸ್ ಮಾಡೋದು ಯಾವುದು? ಇದಾ ಇಲ್ಲ ಇದಾ ಇದಾ ಇದು ಹೌದಾ? ಮಾಡಿದೆ ಸೆಟ್ಟಿಂಗ್ಸ್ ಎಲ್ಲ ತೋರಿಸುತ್ತೆ ಈಕ್ವಲ್ ಇಲ್ಲ. ಅದು ಮ್ಯೂಟ್ ಇಲ್ಲ, ಇಲ್ಲೆಲ್ಲ ಬರುತ್ತೆ. ನಾನು ಅವತ್ತು ಹೇಳಿದ್ದೀನಿ. Right.
ಏನ್ ಚೆನ್ನಾಗಿದೆ ಅಲ್ಲ ಇದು.
ಮಿಸ್ಟರ್ ಶ್ರೀನಿವಾಸನ್, ಕೇಳ್ತಾ ಇದೆಯಾ ಮಿಸ್ಟರ್ ಮುಕ್ಕಣಪ್ಪ?
Yes, my lord, I am hearing. Serial number 64 where I am representing.
ಆಗ್ಲೇ ಕರೆದೇನೋ ಕೇಳಿಸಿಲ್ಲ. 64 we adjourned to 17.
17-3, my lord.
13 service matter ಇವಾಗ ಆಗಲ್ಲ. 2 list on 14th March, 3 14th March, 4 Madam Mr. Patty. Madam, number 4 MC Patty is there.
ಯಾರು ಕೊಟ್ಟಿಲ್ಲ, ಎಲ್ಲ ಕೊಟ್ಟು ಹೋದ್ರು ಅವರು. ಅವ್ರ ಕಡೆ ಎಲ್ಲ ತಗೊಂಡೋದ್ರು, ಯಾರು ತಗೊಂಡೋಗಿಲ್ಲ ಅಂತ ಕಾರಣ.
That is no more, my lord.
Yes, but ಅಲ್ಲಿ ಯಾರು ಅಪಿಯರ್ ಆಗಿದ್ದು? KR ಚಿಕ್ಕಮಂಗ್ಳೂರು.
ರಮೇಶ್
ಯಾರು ತಗೊಂಡ್ತೀರಾ?
ಯಾರಿಗೆ ಕೊಡ್ತಾರೆ?
ರಮೇಶ್ ನಾನು ಕೊಡ್ತಾರೆ, ಬಟ್ ಅವ್ನಿಗೆ ಸಿಗ್ತಾನೆ.
ಈಗ ಅಲ್ಲಿ ಚಿಕ್ಕಮಂಗ್ಳೂರಲ್ಲಿ ಏನಾಯ್ತು ಅಂದ್ರೆ ಒಂದ್ಸಲ
ಒಬ್ಬ ಪ್ರಿಸೈಡಿಂಗ್ ಆಫೀಸರ್ ಇದ್ದಾಗ ಎಲ್ಲಾ ಕೇಸ್ ಮುಗಿದು 4 ಕೇಸ್ ಉಳಿತು ಕೊನೆಗೆ 4ಕ್ಕೆ 4 ಲೇಬರ್ ಕೊಟ್ಟರು. ಆಕ್ಚುಲಿ ಭಾರಿ ಇದಾಗೋಯ್ತು. ಆಮೇಲೆ ಯಾವ ಕೇಸ್ಗಳೇ ಇಲ್ಲ ಅಲ್ಲಿ. ಕೊನೆಗೆ ಅವ್ರಿಗೆ ಇನ್ಚಾರ್ಜ್ ಕೊಟ್ಬಿಟ್ಟು ಅಡಿಷನಲ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜ್ ಅಂತ ಮಾಡಿದ್ರು ಸರ್. ನಮಗೆ ಕಂಪ್ಲೀಟ್ ಖಾಲಿ 4ಕ್ಕೆ ಕೇಸು, ಅದು 4 ಬೆಳಗ್ಗೆ ಹಾಕಿ ಮಧ್ಯಾಹ್ನ ಬಂದ ಅದೇ 4 ಕೇಸ್ ಎಲ್ಲ ಮುಗಿಸ್ಬಿಟ್ಟಿದ್ರು.
ಇಲ್ಲ ಇನ್ನೊಂದು ಇವಾಗ ಸೆಟಲ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ನೋಡ್ತಾ ಇದ್ವಿ 6 months ಗೆಲ್ಲ ಅವಾರ್ಡ್ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ. ನೆನ್ನೆ ಐ ವಾಸ್ ಆಸ್ಕಿಂಗ್ ಅವ್ರು PM ನಾಗರಾಜಿಗೆ ವರ್ಕೇ ಇರ್ತಿರ್ಲಿಲ್ವಂತೆ. ಸೊ ಎಲ್ಲ 6 months ಅದು ಇವಾಗ ಸೆಟಲ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ನೋಡಿದ್ವಿ ನಾವು. ಫ್ರಮ್ ದ ಡೇಟ್ ಆಫ್ ಡಿಸ್ಮಿಸಲ್ ಟಿಲ್ ಅವಾರ್ಡ್ ಇಸ್ ಓನ್ಲಿ 6 months.
ಒಂದು 120 ಕೇಸ್ ಇತ್ತು ಎಲ್ಲ
ಮುಗಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ.
You have to reach that stage.
2018 ಮ್ಯಾಟರ್ಸ್ ಆ ತರ ಇದೆ.
ಇಲ್ಲಿ ಬೆಂಗಳೂರಿಗೆ ಆ ಜಡ್ಜಿ ಹೇಳೋಕೆ ಇಷ್ಟ ಇಲ್ಲ. ಚಿಕ್ಕಮಗಳೂರು ಮಾತ್ರ ಆನ್ ಮೆರಿಟ್ಸ್ honorable presiding officer used to decide on merits, sir. ಸುಮಾರು ಕೇಸ್ ಬಟ್ ಡೇಟ್ ಕೂಡ ಹಾಕೊಂಡು ಮುಗಿಸೋರು.
ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾ? ನೀವು ತಗೊಂತೀರಾ?
ನೋಟಿಸ್ ಹೋಗ್ಬಾರ್ದು, ಯಾಕಂದ್ರೆ ಅದು ಎಲ್ಲಿರ್ತಾನೋ ಕಷ್ಟ ಆಗತ್ತೆ.
14 ಮ್ಯಾಟರ್.
ಅಡ್ರೆಸ್ ತಗೊಂಡು ಲೆಟರ್ ಬರೆದು ನಾನು
It is informed that Shri MC Patil, direct counsel for respondent, is no more. His registry is directed to issue court notice to respondent returnable by 11/4. 7 released on 17th. 9 registry is directed to print the name of Lakshman Rao or
Somsundar.
R. Somsundar. To print the name of Shri R. Somsundar along with Shri Lakshman Rao as that appearing for respondent. Released on 14/3. Then released on 16/3. 11 to 16.
14 training matter.
11 to 13. 21/3. 14 released on 20th February along with so on. 15, 16, 17 released on 23/3. 24/3. 24/3. Yes, madam, list 3. List 3.
ಸ್ಕ್ರೀನಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 4, 6,
1 ಏನಾಯ್ತು?
1 ಮುಕ್ಕಣ್ಣಪ್ಪ ಅವರು
ಮಿಸ್ಟರ್ ಮುಕ್ಕಣ್ಣಪ್ಪ
ಫಿಲ್ಫ್ರೇಜ್ ಕೇಸು ಪ್ರಾಬ್ಲಿ ನೆಕ್ಸ್ಟ್ ಕೇಳ್ತೀನಿ, ಫೋನ್ ಮಾಡಿ ಕೇಳ್ತೀನಿ. ಆಮೇಲೆ
serial number 1, my lord, it could be disposed of. It can be disposed of, my lord. This can be.
Everything can be disposed of in what terms and that time?
ಅಲ್ಲ ಅವ್ರು ಹೇಳ್ಬಿಟ್ಟಿದೀನಿ ನಾನು ಅದನ್ನ ಪೀರಿಯಡ್ ಅನ್ನ ಡಿಲೇ ಪೀರಿಯಡ್ ಅನ್ನ ಎಕ್ಸ್ಕ್ಲೂಡ್ ಮಾಡಿಬಿಟ್ಟು ಕ್ಲೋಸ್ ಮಾಡ್ಬೋದು ಅಂತ ಹೇಳಿದ್ದೀನಿ, ಮಾಡ್ಬೋದು.
11 on 27 possibility of settlement. 27th 2:30 reporting settlement. 2
ಈ 2 ನಲ್ಲಿ SP ರಮೇಶ್ ಅಪಿಯರ್ ಆಗ್ತಾ ಇದ್ದಾರಂತೆ. ಕಲಕ್ ಹಾಕಿದೀವಿ ಅಂತ ಹೇಳಿದ್ರು. ಮಲಡ್ ಹಿ ಆಸ್ಕ್ ಮಿ ಟು
Shri SP Ramesh submits that he has entered appearance for
ಹಾಕಿದ್ದಾರೆ.
Shri Lakshman Rao. Registry is directed to print his name as such.
This we will settle, madam.
Now
24/2.
24/2 at 2:30 PM. 3
ನಲ್ಲಿ ನಾನು ರೆಸ್ಪಾಂಡೆಂಟ್ ಸರ್ವ್ಡ್ unrepresented ಇದ್ದಾರೆ.
3 released on 10th April. ಯಾರು ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ ಅದರಲ್ಲಿ? ಎಕ್ಸ್ಪರ್ಟ್ ಏನು? 10/3. 4
settled, madam. 24/2 for reporting settlement.
14 settlement 2:30. 5
madam 5 ಅಲ್ಲೂ ರೆಸ್ಪಾಂಡೆಂಟ್ ಸರ್ವ್ಡ್ ಇದ್ದಾರೆ.
10/3. 6
madam 6 is settled, madam.
24/3.
7 ನಲ್ಲಿ ರಮೇಶ್ ಬರ್ಲಿಲ್ಲ. madam
training case. 7 SP Srikanth has entered appearance. Delete Shweta Anu, released on 20th along with so and so. 8
kindly call this matter there on Tuesday. ಏನಾಗಿದೆ ಅಂದ್ರೆ where about transfer. I am informed, my lord, that somebody that is no more. I want and I have sent a letter. Minister post is returned. Postal Sara
at the request of
8 to dispose ಮಾಡ್ಬೋದು ಮೆಮೊ ಹಾಕ್ಕೊಡ್ತಾ ಇದೆ.
Counsel for response.
You ಹೇಳಿದ್ರೆ ಹೇಳ್ಕ ಅವ್ರಿಗೆ.
21st.
I'll file memo on Monday.
9.
9 ಮಾತಾಡಿಲ್ಲ ಇದು ನಾನು ನೋಡ್ಲಿಲ್ಲ. ಮೇ ಬಿ ಅರ್ಜೆಂಟ್ ಟು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮೇಲ.
27. 10.
10 ಅಲ್ಲಿ ಸರ್ವ್ಡ್ ಅನ್ರೆಪ್ರೆಸೆಂಟೆಡ್ ಇದ್ರು. 10 ಅಷ್ಟೇ 11 11 ಅಷ್ಟೇ.
10 ಯಾರು ಅಪಿಯರ್ ಆಗಿರೋದು ಇದ್ರಲ್ಲಿ? Sri Kantraj V is directed to accept notice for respondent. Counsel for the petitioner to serve a copy of the petition along with the annexures on the respondent counsel. Relist on 10-3. If trial court will appear as ಇಲ್ಲ ಅದೇ ಇವಾಗ ಎಲ್ಲಾನು ಹಿಂಗೆ ಹಿಡಿಯೋದು.
11 ಅಲ್ಲಿ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ. ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್
ಮತ್ತೆ ಕಾಂತರಾಜ್ ಅಂದ್ರೆ ಇನ್ನೊಂದು
ಶೇಖರ್
ಚನ್ನಬಸಪ್ಪ. 11. The L. Shekhar accepts notice for respondent properties. Relist on objections if any by 17th. Relist on 24. 13.
ಅಲ್ಲ 12 ಅಲ್ಲಿ ಲಾಂಗ್ ಆಬ್ಸೆಂಟ್ ಇದು. ಅದು ಚನ್ನಬಸವಣ್ಣನೇ ಇದು ಮೈಸೂರ್ದು. ನಾನು ಎಲ್ಲಿ ಹುಡ್ಕೊಂಡು ಹೋಗ್ಲಿ ಅವ್ರು, ನಾನು ಕೆಲ್ಸಕ್ಕೆ ಬಂದಿಲ್ಲ. So neither he will be available to the local advocate or him. ನಾನೇ
ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ತೀನಿ, ಅದೇನೋ ಕಳಿಸ್ಕೊಟ್ರೆ ಸಂತೋಷ.
But long absentee, even on the basis of interim order, he was working.
Don't make a mention of his name. Let him contact. Relist on
Virupaksha Kuri.
16th March. 13.
13 no ಮಾತಾಡಿಲ್ಲ.
ಇಲ್ಲ ಯಾವತ್ತು ಡೇಟ್ ಹೇಳಿ ಎಲ್ಲ ಮುಗಿಸ್ಬೋದು.
ಬ್ಯಾಕ್ ಪೇಸ್ ಇಲ್ಲ ಏನು ಇಲ್ಲ ಕೊಟ್ಬಿಡ್ಬೋದು.
ನೋಡ್ತೀನಿ ಸರ್. ಓಕೆ
ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಬಹುದು.
24 to 27 to 14 BMPC ಅದು ಕೇಳ್ಬೇಕು ಅಂತ ಮಾಡಿರ್ಲಿಲ್ಲ. BMPC ಇದು
ಏನ್ ಮಾಡ್ಬೇಕು
ಡೇಟ್ ಇರಲಿ. ಡೇಟ್ 27 to
15
settle ಆಯ್ತು.
24 to
16 also settle ಮಾಡ.
24 to
17 settle ಮಾಡ.
24 to
18 ಅಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಸರ್ವ್ಡ್ ಅನ್ರೆಪ್ರೆಸೆಂಟೆಡ್.
ಯಾರಮ್ಮ 8?
ಶೇಖರ್ ನೋಡಿ ಅದ್ಯಾರು ಕೋಲಾರ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ಅವರೇನೆ ನೋಡಿ ಹೆಂಗೆ
ಎಲ್ ಶೇಖರ್ ನೋಡಿ ಎಷ್ಟು ಸಿಂಪಲ್ ಇದು ನೋಡಿ. 18 L. Shekhar accepts notice for the respondent seeking instruction release 1-3. ಇವೆಲ್ಲ ತೆಗ್ರಿ ಮೇಡಮ್. All the things wherever respondent is not served or served unrepresented. Who is the counsel ಇಟ್ಕೊಂಡು ಕೊಟ್ಬಿಡಿ. ಕೋಲಾರ್ ಶೇಖರ್
ಸೆಟ್ಲ್ ಆಯ್ತು. ಮುಂದೆಲ್ಲ ಆಗಿದೆ ಬಿಡಿ, ಎಲ್ಲಾರ್ದು ಹೇಳಿದೀನಿ. ಅಲ್ಲಿ ಯಾವ ಅಡ್ವೊಕೇಟ್ ಅಂತ ನೋಡೋದೇ ಇಲ್ಲ ನಾವು. ಫೈಲ್ ತಗೊಂಡು ಯಾರಾದ್ರೂ ಬಂದ್
ರಿಜಿಸ್ಟ್ರೇಷನ್ ಮಾಡಿದ್ರ ಎಲ್ರು ಇನ್ನ ಮಾಡಿ
ಇನ್ನೊಂದು ವಾರಕ್ಕೆ ನಿಮ್ ಮುಂದೆ ಬಂದ್ಬಿಟ್ಟು ಕಾರ್ಡ್ ತೋರಿಸ್ತೀನಿ. ಇದನ್ನ ತೋರಿಸ್ತೀನಿ ಒಂದೇ ವಾರ.
29 February ಅವತ್ತು ತೋರಿಸ್ತೀರಾ ನೀವು?
ಇಲ್ಲ 28th ಮೇಲೆ
ಏನ್ ನೀವು ರಿಜಿಸ್ಟ್ರೇಷನ್ ಮಾಡಿದ್ರಾ?
ಇಲ್ಲ ನನಗೆ ಗೊತ್ತಾಗಿದೆ, ನಾನು ಎಲ್ಲ ತಗೊಂಡಿದ್ದೀನಿ. ನಾನು ಅಪ್ಲೈ ಮಾಡಿ
ಕೇಂದ್ರಕ್ಕೆ ಹೋಗಿ they will assist you.
ಬಾರ್ ಕೌನ್ಸಿಲ್ ಕಾರ್ಡ್ ಇದೆಯಾ? ಅಷ್ಟೇ, ನನ್ನ ಹತ್ರ ಇಲ್ಲ, ನಾನು ಅಪ್ಲೈ ಮಾಡಿದ್ದೀನಿ.
ಇದು ಪೇಪರ್ಲೆಸ್ ಕೋಡ್ ನಾವು ವಿ ಆರ್ ಸ್ಟಾರ್ಟಿಂಗ್ ಫಾರ್ ಟ್ಯಾಕ್ಸ್. ಅದಾದ್ಮೇಲೆ ಒಂದೊಂದೇ ಬರುತ್ತೆ. ಅಷ್ಟೊಳಗೆ ನೀವೆಲ್ಲ ರೆಡಿ ಆದ್ರೆ ಇಟ್ ವಿಲ್ ಬಿ ಈಸಿ. ಬಹಳ ಎಲೆಕ್ಟ್ರಾನಿಕ್ ಫೈಲಿಂಗ್ ವಿಲ್ ಬಿಕಮ್ ಕಂಪಲ್ಸರಿ ಇನ್ ಎವ್ರಿಥಿಂಗ್.
ಅವಾಗ ಒಂದು ಹೊರೆ ಹೊತ್ಕೊಂಬರ ತಪ್ಪುತ್ತೆ.
CJI also emphasizing on this.
It will become compulsory for all.
Yesterday also expressed that those who are not using the hybrid system, all the High Court has to.
Government is spending 7,000 crores this time, so all that will be used for this. So it will, and it will become easy. ನೀವು ಇಷ್ಟೆಲ್ಲ ಫೈಲ್ ತಗೊಂಡು ಬರೋದ್ ಬೇಕಾಗಿಲ್ಲ. ನಾಯಕ್ ಅವರು ಎಷ್ಟು 4 ಬ್ಯಾಗ್ ತರೋದ್ ಬೇಕಾಗಿಲ್ಲ. ಅವ್ರು ಒಂದ್ ಲ್ಯಾಪ್ಟಾಪ್ ಒಂದ್ ಐಪ್ಯಾಡ್ ತಗೊಂಡ್ ಬಂದ್ಬಿಟ್ರೆ ಮುಗೀತು ಅವ್ರಿಗೆ.
ಪೇಪರ್ ಓದಿದ
ಅದೇನು ಅದು ಕರೆಕ್ಟ್.
ಅದು ನಿಮ್ಗೆ ಅನ್ಸತ್ತೆ, ಅದು ನಿಮ್ಗೆ ಇವಾಗ ಅನ್ಸಿಗೆ ಅಷ್ಟೇ.
ನಾವ್ ಈಗ ಸ್ಕ್ರೋಲ್ ಮಾಡ್ತಾ ಇರ್ಬೇಕಿದ್ರೆ ಒಂದ್ಸಲ ಕಣ್ಣು ತಪ್ಪಿತು ಅಂದ್ರೆ ಮತ್ತೆ ವಾಪಸ್ ಅವರ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್.
ಇಟ್ ಈಸ್ ಓನ್ಲಿ ಒನ್ ಮೆಂಟಲ್ ಬ್ಲಾಕ್. ಮುಂಚೆ ಇದು ನಮ್ ರೆಗ್ಯುಲರ್ ಫೋನ್ ಇದ್ದಾಗ ಸ್ಮಾರ್ಟ್ ಫೋನ್ ತಗೊಳಕ್ ಅದೇ ನಂಗೆ ಬರಲ್ಲ, ಯೂಸ್ ಮಾಡಕ್ ಆಗಲ್ಲ, ಅದು ಇದು ಅಂತ ಇತ್ತು. ಓನ್ಲಿ ಎ ಫೇಸ್. ದ ಮೆಂಟಲ್ ಬ್ಲಾಕ್ ಫಾರ್ ಸಮ್ ಟೈಮ್ ಇಟ್ಸ್ ಎ ಫೇಸ್. ಇವಾಗ ನಿಮ್ಗೆ ಲಕ್ಸುರಿ ಅನ್ಸುತ್ತೆ. ಅಟ್ ಸಮ್ ಪಾಯಿಂಟ್ ಆಫ್ ಟೈಮ್ ಇಟ್ ಬಿಕಮ್ ನೆಸೆಸಿಟಿ.
ಇವಾಗ ನಮ್ VC ಓಪನ್ ಮಾಡಕ್ ಆಗದೇ ಇಲ್ಲ ಅನ್ಕೋತೀವಿ. ಇವಾಗ ಅದು ಬರೀ VC ಮ್ಯಾಂಡೇಟರಿ ಮಾಡಿದ್ಮೇಲೆ
ಅವ್ರು ಇಲ್ಲಿ ಬರೋದೇ ಇಲ್ಲ. ಇವಾಗ ಆರಾಮಾಗಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ತಾನೆ. How many women, especially younger women who have had younger children, are appearing through VC? They are doing e-filing. ಬರೋದೇ ಬೇಕಾಗಿಲ್ಲ. Inclusive.
ಪೇಪರ್ ವರ್ಕ್ ಹೇಳ್ತಾ ಇದ್ರಲ್ಲ, ಆಫ್ ಲೇಟ್ ಅಬೌಟ್ ಲಾಸ್ಟ್ 3 to 4 years, our experience in the industry tribunal, especially in the industry tribunal, where there are several demands and author cases, paperwork is being minimized. Only up to 2018 ವರೆಗೂ ಮಾತ್ರ ಇದೆಲ್ಲ ದಪ್ಪ ಫೈಲ್ಗಳು ಇದೆ ಅಲ್ಲಿ. Nowadays, the marathon proceedings ಇಲ್ವೇ ಇಲ್ಲ ಈಗ. Because those type of cases are reduced. At the conciliation stage, ಎಲ್ಲ ಸೆಟ್ಲ್ ಆಗ್ಬಿಡ್ತಾ ಇದೆ. ಈಗ ತಾವ್ ಹೇಗೆ ಮಾಡ್ತಾ ಇದ್ದೀರೋ ಹಾಗೆ ಕನ್ಸಿಲೇಷನ್ ಸ್ಟೇಜ್ ಸೆಟ್ಲ್ ಆಗುತ್ತೆ. ಓನ್ಲಿ ದಿಸ್ ಟರ್ಮಿನೇಷನ್ ಕೇಸ್. ಇನ್ಫ್ಯಾಕ್ಟ್ ಲೇಬರ್ ಕೋರ್ಟ್ನೊಳಗೆ ನಾವು ಸಜೆಷನ್ ಮಾಡಿದ್ವಿ, ಬರೀ ಕೇಸ್ ಆಡ್ಸಿ ಮ್ಯಾಟ್ರಿಗೆ ಒಂದು ಲೇಬರ್ ಕೋರ್ಟ್ ಇಟ್ಬಿಟ್ರೆ ಬೇರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಬೇರೆ ಕೇಸ್ಗಳೆಲ್ಲ ಇಟ್ಟರೆ ಲೇಬರ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ಒಂದೇ ಕೇಸ್ ಆಡ್ಸಿ ಮ್ಯಾಟ್ರ್ ಇಟ್ಟರೆ ಕ್ವಿಕ್ ಡಿಸ್ಪೋಸಲ್ ಆಗಿ ಮುಗಿದೇ ಹೋಗುತ್ತೆ. ಮುಗಿದೇ ಹೋಗುತ್ತೆ ಇವಾಗೆಲ್ಲ.
If you sort it out by what it is,
yes,
becomes easier.
ಬಹಳ
ಫಿಲ್ಟ್ರೇಜನು ಅಷ್ಟೇ 100 ಮ್ಯಾಟ್ರು ಇದನ್ನ 5 ಕೊಟ್ಟಿದೀವಿ 4 ಮಾಡ್ಬೋದು ಅಂತ ಇಟ್ಕೊಂಡ್ರೆ 100 ಮ್ಯಾಟ್ ಒಂದಿನದಲ್ಲಿ ಮುಗಿಯುತ್ತೆ.
ಮಾಡ್ಬೋದು ಈಗ ಆಗಸ್ಟ್ ಮುಗಿದೋಗುತ್ತೆ, ಮಿನಿಮೈಸ್ ಆಗ್ಬಿಡುತ್ತೆ.
ಹನ್ನೆರಡು ಗಂಟೆಗೆ ಅಲ್ಲಿ ಲೋಟ ಹುಡುಕ್ಬೇಕು ನಾನು. ಅಲ್ಲ ನೋಡಿ ಸರ್, ಬೇರೆಯಾ ಬಟ್ ಈಸಿ ಆಗ್ತಾ ಇದೆ. ಅಲ್ಲಿ ರಿಯಲಿ ಸೆಟ್ಲಿಂಗ್ ದ ಮ್ಯಾಟರ್. ಪರ್ ಡೇಗೆ 10 ಬಂದ್ರೆ
Court officer. Court officer. Madam court officer.
27. Iದೇ thing.
Court officer. Court officer.
Yes, madam.
Court officers.
Yes, madam.
List number 2, serial number 12 ಏನಾಯ್ತು?
21st March, madam.
21st March.
Yes, ma'am.
Thank you.
List number 2, sir. Serial number 2. Court officer. Court officer.
March, madam.
Sir, ಕೇಳ್ಸಲ್ಲ ಇನ್ನೊಂದ್ಸಲ ಹೇಳಿ please.
14th March. 14 March.